You shouldn't be here. I have it, sorry.
Oh,
okay. Sorry. It's under there, but I didn't want to use, I didn't want to waste power.
But you never know. It doesn't. Yeah.
You need me to go on over there? Or you
Yes,
still-
yeah. There's a lot going on right here.
It is. Sorry.
You good? All right. Good morning, everyone. We're back on the record in Jame Daniels versus MARTA. It is Monday, the 19th at 8:42. Appreciate people being on time. Sorry, the courtroom wasn't open, but you all were here. Our jurors are trickling in. While we wait for them, I figured we could make a record of rulings on the various motions in limine. But before we do that, Mr. Johnson, you ready to go forward?
I am, Judge. Thank you.
Great. Ms. Arnold, you ready to go forward?
Yes, Your Honor.
Anyone else you need to introduce? There are like more people hovering around the MARTA table than last time.
No, Your Honor, you met John Monaco from MARTA,
Mhm.
and then Dan Codman here is helping us with tech.
Fantastic. And the Zoom session is up. That's what people should join if they're going to be sharing exhibits. And it is being fed live through YouTube. So if there are people who want to watch who maybe shouldn't join the Zoom just because it's problematic or who knows what, then they can find the YouTube link on the court website. So let's start with plaintiff's motions in limine. And we've discussed some of these during a teleconference that was not taken down. So I'll move through somewhat quickly, but if I hit a spot where we need to have debate, I'm not steamrolling anyone. And if you want to get something on the record, please do so. And maybe I need to reevaluate something. Let me just make sure. Deputy Gordon, you need me? Oh, okay. You're helping the jurors trickle in. What's our count right now? 4? Okay, well, we're a third of the way there. Oh, I should add this before we get into the motions in limine. A juror contacted us late Friday expressing dismay / panic that he had been selected. Juror 28, Mr. Garfinkel, the expecting father. And he has asked that he be excused. The news that he was selected was very stressful for his wife. He was told to show up this morning and that we would talk about it with him outside the presence of the other jurors. So we'll hear what he has to say. My plan is to let him know that we were aware of that and he will be excused immediately should something come up. But otherwise, he's going to need to be here as a juror. His email was a little more forceful than the way he articulated it to us on Zoom. And that may have been the byproduct of reality hitting household. But I wanted you all to know that because we need to chat with him before we get started with the rest of the jurors. All right. I'm starting with plaintiff's motions in limine. The first was a request that there be no discussion about Ms. Daniels' application for SSDI. And it was not opposed. I intend to grant it with the caveat that it sounds like neither side will go there. If plaintiff does something that makes that an eligible topic, all I'd ask Ms. Arnold is that we talk about it before you drive a bus, no pun intended, through the door that you think Mr. Johnson or Ms. Sadler might have opened. The second motion was labeled unsupported alternative causation arguments. And for me, the key word there was arguments. I'm denying it as written. I am open to an on-the-spot objection, but if an argument is unsupported, then it's not proven. But either side is free to make any argument they want. It may not prove to be particularly persuasive, but I believe the defense is entitled to explore Ms. Daniels' duty to mitigate. They've admitted liability, but if they are exploring why, I'm making this up, the wrist hasn't healed as well as it could have, or the range of motion on the wrist isn't as good as one might hope, and there are reasons to explore that it wasn't just the accident, I think the defense is free to do that. That being said, I'm not precluding you for objecting on the spot. It's sort of, my response is much like your response, Mr. Johnson, to some of the defense motions that we'll get to, which is there's not going to be a blanket, you can't do this. It's so situational, we'll need to see it come up. But I don't intend to preclude MARTA from making any argument they want. If it's not supported by evidence, then there's a real good rebuttal, other than we're not liable. They've acknowledged that. It just may be that the accident, MARTA's theory is, wasn't the only cause or even the major contributing cause to a particular aspect of Ms. Daniels' situation today. That's how I read the defense's response, and that's how I plan to handle it. Number 3, improper impeachment through medical records. This is another one that I'm denying as a motion in limine. Everyone needs to be on his or her toes about how the rules of evidence work. I will enforce the proper impeachment procedure. And if someone objects during trial that either someone hasn't said something contradictory, or they're being impeached without a chance to maybe correct what they said or modify what they said, I'll certainly enforce that. I won't allow improper impeachment if it's objected to, I guess is how I handle number 3. Number 4 is entitled The Effect of the Suit on the Defendant and the Community. I don't think, I agree in part with this motion that it would not be appropriate for the defense to argue you really shouldn't enter a judgment against MARTA because the MARTA fares may go up. I don't think that's what we're going to hear. But I do think the defense is entitled to argue the law, which is that damages are to be equitable to both sides. And as long as I'm hearing that, I think it's perfectly appropriate. But it wouldn't be appropriate to tug at the jurors to say, well, let's just think about the repercussions of giving a lot of money to Ms. Daniels. That could be hard on MARTA, which is part of the community. We wouldn't want to lose a bus route because we're making life better for Ms. Daniels. So hopefully that's not where you're planning on going. I don't think it is, but I'll add that cautionary instruction. Number 5 is a motion seeking to prevent the defendant from saying sorry or apologizing. I'm denying that. I think that the defendant is free and opening to say what happened was regrettable and the pain and suffering that has occurred was tragic. And for that, MARTA, they're going to use whatever words they want. That doesn't change liability, and it certainly doesn't change the scope and breadth and depth of pain and suffering, monetary damages, et cetera. Number 6 was a motion seeking to prevent MARTA from referring to the event as an accident. I don't plan on giving any instructions on that concept of legal accident, which is horribly confusing. I don't think the facts in this case would lead to that being an appropriate jury charge. And I've sort of ruled on this already because that introductory paragraph that I gave to the jurors, Mr. Johnson, you only wanted collision in there. I use both words. I think they're interchangeable here, but I certainly won't prevent MARTA from referring to what happened as an accident in lay terms. It was an unintentional incident. It was the fault of MARTA, but it was not an intentional act. So it's an accident. If somehow, Mr. Johnson, you perceive that MARTA is inching towards this concept of legal accident, let's pause and discuss it. I don't think that's appropriate, and we'll see how that flows. Those were all of the plaintiff's motions. Any questions or concerns about those rulings, Mr. Johnson?
No, Judge, thank you.
You're welcome. To the larger universe of defense motions in limine. So the first motion, number one, was entitled Liability Evidence. And in general, I grant the motion in the sense that MARTA's liability doesn't need to be, ought not to be litigated, but that's tempered a little bit by the fact that just because MARTA admits something doesn't mean the jury sees nothing. For example, the crash video. I've already ruled the crash video is going to be played. I had 5 specifics that I needed you to explain, Mr. Johnson. I think one of them's already gone away, and that was whether the bus driver was going to be called as a witness.
Correct.
So that's number one. Number two was calling Charles Boone to testify. If you were planning on doing that, I need a preview of what you'd be asking him about.
Sure. He was listed as a witness because it was unclear what we were going to be able to stipulate to with respect to the video. My understanding is we've now, while we have our differences of opinion as to whether the video should be shown, given that it will be shown, they've stipulated to the authenticity of it, to the telematic data around it being what it is. And that's why he was listed as a witness in case I needed to establish any of that, which I don't.
So assuming there is no fight during trial about the admissibility of the video, you won't be calling Mr. Boone.
That's correct.
Okay. Ms. Arnold, given that representation, I think we're all right with Mr. Boone. You agree?
Correct.
Okay. So Mr. Maddox, Mr. Boone off. Then the Officer Dadea, and
We will not be calling the officer.
okay. And I apologize to him if that's not how you pronounce his name. That's what I said to the jurors, but we don't have an issue there. And then one document and then one topic, the crash report, which I assume is the police report that the officer wrote.
We're not putting it in.
Okay, this is getting easier. And then the final one was the MARTA investigation. And again, I don't know if that's a document or also a subject, asking witnesses about, well, what did MARTA conclude? And were they concerned that driver Maddox had done this before or this or that? Again, that seemed like it ought not to come in.
It's not coming in, Judge.
Okay. I don't think we have an issue with liability evidence then. Those were the specific items that the defense raised. Conceptually, we ought not to go in that area. I think, Ms. Arnold, now it will be objection by objection. If you think there are questions that the plaintiff's team is asking that gets into that area of liability, you're free to object. And I may be able to construct some rules. Let's not talk about this topic or whatnot. But the sense I'm getting from Mr. Johnson is the video is in and he's going to go for damages and injuries from there. All that flows from there.
Right. The only other 2 examples were the citations and Maddox's driving history, but I think we all agree that's out as well.
We do agree.
Yeah.
Okay, good.
Thank you.
Yeah, I guess my shorthand for that was Mr. Matt. If he's not testifying, I assume we're not getting into anything about him other than someone may say that was the name of the driver and people will see how he was driving. Number 2 is the video of the accident, and my notes were I need to see it before I can rule, but I'll likely deny it. And I did. The video is coming in. Mr. Johnson, your evidence presentation pros will stop it at whatever time mark I put in that email.
Yes, Your Honor.
I could do it, so they should be able to do it. I practiced.
Yes.
Excellent. Number 3, witnesses and evidence not.
Forgive me.
I'm sorry. Yes, ma'am.
I did want to make one additional point just for the record, Your Honor. I think Your Honor's ruling was that you are going to allow the beginning portion up until the accident to play all the way through. Okay.
Yes.
We would still object to that because the form that the video was produced in does show the telematics data. And we think that's, 40 seconds of showing Mr. Maddox's speeding down the road in the rain before this accident happened, which again, focuses the jury on his conduct, which shouldn't be an issue in this case since we've admitted liability. So we would just request, if that isn't going to be cut out, then we'd request that it be cropped just so you're showing only the bus not the telematics data, so that that's all the jury sees, because they're viewing the impact and the accident itself, but not anything with respect to his conduct.
So I don't know how the experts are going to be duking it out, but do you expect, Ms. Arnold, that the plaintiff is going to want to be able to discuss the force of impact that is in part a physics calculation? The speed of the bus is material to how forceful the impact is. Because jurors can see it, but a layperson, myself, it looked like the Nissan ended up okay. The airbag went off, and it didn't seem to rattle too much. We know to the contrary, because Ms. Daniels was seriously injured. If I had known that the bus was going, I'm making it up, 45 when it had the head-on collision with Ms. Daniels, I might think, gosh, that was much more forceful than it looked in the video. Is the evidence of the speed of the bus coming in short of what's on the video?
Not that I'm aware of. She's not aware of what speed the bus was traveling.
Okay, well, let me ask it a different way, and then I'll hear from Mr. Johnson. In the back and forth with the experts, has any expert said, yeah, it has to have been extremely forceful impact because the bus was going 45 miles an hour? In other words, does the speed of the bus factor into any expert work that you've seen, heard, read?
No.
Okay. So, Mr. Johnson, your thoughts on the speed of the bus?
Thank you. Yeah. The speed of the bus is relevant for the same reason that the visuals of the collision are relevant. It informs the jury of the complete nature of the impact. Now, we don't have to say, if you instruct us not to, let me volunteer this. We don't have to say that the speed limit was 35 miles an hour, which it was. He was going 10 miles an hour over the speed limit downhill in the rain when this happened. But we don't have to mention that the speed limit is 35, but I think the jury's entitled to know that just for the wreck, bus was traveling 45 miles an hour as Ms. Daniels was coming the other direction. And I think that informs the jury to some extent about her damages.
Okay. All right. I'm going to allow the video to be played as it is. And you'll need to be thoughtful, Mr. Johnson, about how much you focus on how fast the bus was going, because MARTA has admitted liability, but I do think that the speed of the bus is relevant to the nature of the impact.
Thank you, Judge. I'm simply going to explain to the jury what the line is that they're going to be seeing, and that it's a line that tracks speed, and that it's apex, it's 45, and
Okay.
that's as far as I'm going with any speed analysis.
All right. So number 3, witnesses and evidence not previously disclosed. I think we've worked through that now. I think Ms. Page argued much of that on Friday. Was there anything more from the defense side that you think that we need to cover, Ms. Page, in terms of, I know there's this thing with Mr. Seaman and his opinions about what was in the minds of the doctors, and we'll get to that. But was there anything else you were concerned about?
No, Your Honor.
Okay. I mean, you may have been concerned about my rulings, but there weren't other exhibits that, wait a minute, we've never seen this before.
No, Your Honor.
Okay. Mr. Johnson, anything that you came across this weekend that you're really hoping to be able to use but hadn't been disclosed before?
Just fixing to give you a list. No, there's nothing, Judge. We've disclosed everything, and we've given a complete copy of our exhibits to Ms. Arnold this morning.
Okay. So what I'm going to do then is just provide this instruction. Should either side come up with something in the throes of trial that they just found or for whatever reason hadn't been disclosed, we ought to talk about it before you spring it on anyone.
Yes, Your Honor.
Number 4, I think we've gone through as well. That's post-accident photographs and videos. I appreciate it was really a 2-tier objection now. 1, maybe they weren't timely disclosed. And then 2, there was concern about either cumulative nature or being unduly prejudicial because of the graphic nature or inflammatory nature. I think I've ruled on all that based on what Mr. Johnson shared as the universe of those images and videos he's going to play. Ms. Page, was there anything more on your motion in limine number 4?
No, Your Honor.
Okay. 5 concerns evidence of Ms. Daniels' family members' distress concerning her injuries and her suffering. My take on this is that Ms. Daniels can talk about how her injuries have affected her, as well as how her injuries' impact on others have affected her, because that may be part of her suffering. Part of what I grieve and suffer and hurts is that I'm making up relatives for you. I can't hold my daughter the same way I did, or I can't care for my mom the same way I used to. I think that that is an element of pain and suffering for Ms. Daniels. What I don't think is relevant and admissible is having Ms. Daniels' daughter or mother come in saying, it has hurt me seeing my daughter suffer, or I have had to drop out of soccer because my mom couldn't drive me to soccer anymore. And that makes me, daughter, really sad. I think that's coming from the wrong party, because it's not the pain and suffering of others that's at issue before the jury. It's the pain and suffering and injuries of Ms. Daniels. That's my initial ruling on this. Mr. Johnson, you know where you're planning on going with all this. Tell me if that ruling works, and if it doesn't, what you think I ought to change.
Judge, I really think it does work. That is what I argued in my brief on this issue. The only modification I would make to your hypothetical about dropping out of soccer is, I think that in this, soccer does not play into this case, mercifully, but if it did, and if a relative said, a child said, I had to drop out of soccer, that would be admissible if it only for the purpose of showing how that affected Ms. Daniels, not how it affected the child.
But why would you need to get it through the child rather than through Ms. Daniels?
I think you could get it either way.
Okay.
And I don't think it would be improper either way it came in.
But you would not follow up with the daughter to say, and has that been tough,
No.
having to drop out of soccer? Okay.
We will not, Judge.
All right. Assuming that's how we manage things, Ms. Page, Ms. Arnold, Mr. Dial, does that work consistent with a motion in limine, or you think that actually Ms. Daniels shouldn't be able to talk about how the impact of her injuries on others has affected her, if that question makes sense?
That works for us, Your Honor. Our concern was having family or friends come to the stand and testify about how it's affected them personally.
Okay. Well, it was a well-argued motion. Number 6 was surveillance. That's granted. It's unopposed. Sounds like we're staying away from the surveillance work that was done. 7 is reference to liability insurance. That's granted and unopposed. That goes in both directions. 8 concerned evidence about settlement discussions. Other than one potential juror, may have been the doctor, saying, why didn't you mediate this, or why didn't mediation work? It ought not to come up again. Both sides agree with that and don't intend to go there. 9 relates to arguments about other claims or lawsuits against MARTA, unopposed and granted. Do we have an update? Only missing 2? All right. Are we calling them? They're on their way. Fantastic. Let's press on. Number 10, references to the financial status or size of MARTA, unopposed as to MARTA's wealth. I had a note about discussing financial hardship evidence. I assume that's not financial hardship to MARTA.
No, their motion was titled financial status, size, and wealth, and spoke about MARTA, but in the interior of the motion, they attempt to limit Ms. Daniels' ability to say this has been a financial disaster. And it's been hard to live that way.
Okay. Aren't we supposed to be able to?
It's an element of our damages,
Yeah,
so
okay.
we would oppose that part of the motion.
I think that's why I flagged it. So Ms. Page, Mr. Johnson affirms that he doesn't intend to say, oh, don't worry about MARTA. It's so big. cut a big check for Ms. Daniels. They won't even notice a rounding error in their budget. But he opposes this notion that he shouldn't be able to get in evidence about the financial impact on Ms. Daniels of the accident. I think I agree with him, but maybe you've got a perspective I didn't understand.
Yeah, so one of our concerns is about Ms. Daniels talking about her anxiety, worry, or anything related to medical bills. And within the motion, we cited Warren v. Ballard, where it says recovery for anxiety, agony, or worry over payment of medical bills was not appropriate to be admissible because it does not relate to a material issue. And there's no basis to recover for anxiety over medical bills. And then we also cited the Goss brothers case, which mentioned that neither the wealth of the plaintiff nor the defendant is relevant. A man's treatment before the bar of justice should not vary with his financial condition.
Okay.
So that was our concern about her talking about her worry or her anxiety over medical bills or just different expenses that she may have since then.
So I'm familiar, less so than you, with the cases that say anxiety over medical bills. But I don't know that the case law extends so far as how am I going to take care of my family now that I can't do the work that I used to do? Are you saying that there ought not to be testimony in that second category or just about the medical bills?
Well, when it comes to not being able to do the work that she used to be able to do, that's something that's in dispute, which will come out through some of the experts throughout the trial. So at that point, we think that's up for the jury to decide rather than having Ms. Daniels testify to that.
Well, okay, we're now combining a bunch of things. I don't know whether Ms. Daniels is going to be able to testify about whether she can do the work she used to do or not. I bet she could. I can't move my wrist. And then experts are going to say, yes, she can. No, she can't. But this motion was about two things. One, don't talk about how big and successful MARTA is. Everyone agrees with that. The plaintiff isn't going there. But there was the second piece about the impact on Ms. Daniels, the financial impact on Ms. Daniels of her injuries. And I agree with you that the case law does say stress over medical bills is not where we need to go with this. My question was, I appreciate it's in dispute, but the plaintiff is going to argue Ms. Daniels can't do what she used to do. And whatever it is she can do makes it harder to provide for herself or her family. And my understanding was that stress or anxiety about not being able to provide for family was admissible, but maybe to your ultimate point, which was what the jury doesn't get to do is say, we take from the rich to give to the poor. And that's sort of the moral at play here, and emphasis about how now Ms. Daniels isn't able to earn a living gets to well, we feel bad because she is of lesser means than MARTA is. But I don't know how you insulate against that, because I think Ms. Daniels is able to get in evidence that I used to run apartment complexes, but now because of my leg and my wrist, I can't. And the only job I can get, picking it up, is that I'm working as a cashier at QT. And that pays $10 less an hour. But that's a financial argument as opposed to a anxiety argument. I guess that's your point.
Yes, Your Honor.
Okay. Mr. Johnson?
I think that's all exactly right. I don't intend to ask her about her anxiety over her medical bills. Not one of my questions.
Okay, but what about her anxiety in terms of providing for herself?
Absolutely.
Okay, and you don't believe that's prohibited by case law?
I don't. And I think it's hard to parse that out between her anxiety about everything else.
Okay, I agree. You will need to, it's one bright line is no questions about anxiety about medical bills. And we'll just need to see how it flows in terms of how Ms. Daniels is processing her changed circumstances.
Your Honor.
Yes, ma'am.
Just one point, going back to motion in limine number 2.
2.
Yeah, I just wanted to confirm
This just in.
that was it not 2?
2 is the video.
Okay, 3, I'm sorry. Just wanted to confirm that the apartment documents that you previously wrote, they're not coming in, correct?
Is that what I honestly don't remember. That was on the phone call. And I think
Yeah, we also talked about it Friday when I brought it up in relation to the videos and you said, oh, you thought that only related to the apartment documents. So I just wanted to confirm,
Okay,
yes.
The reason that she's asking you this is we talked about it after court. I didn't hear any discussion about those documents. And as I've explained in court, I don't always hear every little thing, but I just don't recall that. And it's not the world's largest issue, but if you ruled on it, if you'll let me know what your ruling is, that's great. Otherwise, we can talk about it for 2 minutes.
okay. Ms. Page, remind me of the origin story for those. You got those when?
After the close of discovery,
Okay,
just a couple weeks ago.
okay. And Mr. Johnson, the reason for the late discovery, this seems like it would fall into a different category than I didn't know my client's mom had pictures.
I got these documents late. I think my recollection is that we thought we had disclosed them in a prior batch of documents that we disclosed again and again and again as documents came available.
Yeah.
This is one that was missing. It's not, if I can explain what it would be used for, if it were used at all. And even if you granted my ability to use it, we may not. But if it was used, it would be used by Ms. Daniels to say, so when I was a property manager, one of the things I would do is, the stuff that's listed here on this form for me to do.
Okay,
And that's all it would be used for. But anyway, I just wanted to make that.
great. No, I appreciate that context. And I will exclude those based on their late disclosure.
Thank you, Your Honor.
Let's get to number 11 is moot now because it had to do with questioning jurors. Hopefully I ruled on that one correctly. 12, failure to call witnesses equally available to both parties. I need you to explain what you, I understand those words, but if both sides could call a witness, then I don't think that, either side could say, why didn't you call this person? It's when the witness is unavailable or only one side could have procured that witness. I think that we need to work through it, but I may have misunderstood what the concern was.
Your Honor, we'll withdraw this motion now that we know for certain that Mr. Maddox and Officer Dedea aren't testifying.
Okay, got it. Number 13 is is a motion to eliminate that seeks to preclude plaintiff from arguing that the jury should send a message through the award that it grants. I grant that, and it's unopposed as to sending a message. The word justice is also problematic, other than the fact that jurors are instructed to deliver an amount that is fair and just to both sides. So I'm not precluding Mr. Johnson from saying a verdict that delivers justice, but every time you say that, you would have to follow by saying, which of course would be a verdict that is fair to both sides. If you want to use that word, I'm going to need you to qualify it, because otherwise it is just dangling the word justice out there is like sending a message. We need to do right by Ms. Daniels. And that's not what the jury is supposed to do. The jury is supposed to do right for both parties. Its damages are an amount that are fair and just as to both parties.
If I could give a response. Justice is the same thing. It's a synonym for doing what's right. I object to having to, every time I say the word justice, having to then redefine it. There's no case law that I have found anywhere in this state that requires any time a plaintiff utters the word justice in a civil case, he has to then give a definition of it. I agree about send a message. That is something more commonly used in a punitive damages case, which this is not. But to call for justice is the same thing as to call for fairness. And I believe that it places an inappropriate burden on the plaintiff to have to redefine a word that is, if you look it up, a synonym for essentially doing what's right for all parties.
Here's what I'm going to ask you to do. I hear your point. Well, I guess you can use the word justice, and you're going to decide whether it behooves you at some point in your presentation to explain what you mean by that, because you run the risk of using it and then the jurors are surprised that what it really means is something a little different from send a message, because it can be twisted that way. And I'm not saying anything pejorative about what your approach is going to be. I was persuaded by what I already understood the law to be, but the motion that, of course, this is about compensating for the injury actually sustained, which is fairness, which is justice. You'll just need to be thoughtful about
I
that.
simply didn't want it in the back of my mind this entire trial that I might accidentally utter the word justice in an inappropriate way. So
No,
that's why I oppose the motion.
don't feel that hamstrung.
And if I may, Your Honor, you touched on exactly our concern, which is the connotation with doing justice or sending justice is the same as sending a message. And there is no punitive damages in this trial. And this is an admitted liability trial. So, any arguments, we would still, object to any arguments about doing justice for her as sending that same type of message.
Okay, well, it's going to be very contextual, and you'll need to decide whether you want to object and draw attention to it, or maybe after opening, we have a discussion and I say, the way you use the word justice, you might as well have said sends a message. You're going to need to use it differently in your closing. And it may be that the way Mr. Johnson uses it, you understand, and you'd wish he'd say something else, but the word itself isn't as radioactive as insurance, which people shouldn't be talking about. All right, let's press on. Number 14, golden rule argument. I intend to grant that. And as I understand Mr. Johnson's response, we don't intend to go there, but the fact that you granted it, Judge, doesn't mean that if we go there and the defense doesn't object, that they have preserved it on appeal. Defense counsel around the state has learned the hard way that if you get a favorable motion in limine ruling, you can't rest on that thinking, we have protection throughout the trial. My direction to you, Mr. Johnson, is let's not, you should not engage in a golden rule argument.
Understood, Judge. Thank you.
All right. The reptile arguments, number 15. I'm denying it as it is pled because it's too vague. I don't, Mr. Johnson and his team can go about motivating jurors in lots of different ways. What they may not do is, as we've already discussed, talk about sending a message or protecting the community. This is about Ms. Daniels. It's not about other cases. It's not about MARTA hits people with buses once a month and this has got to stop. That's not what this case is about. Now, whether Mr. Johnson's approach to energizing the jurors involves talking about safety rules, maybe he does that and he's not crossing a line. This will be very contextual, and we'll need to see what happens during the course of the trial. But as a standalone, I'm denying number 15. Were there specific concerns beyond what was in there, Ms. Arnold or Ms. Page, you wanted to bring up?
No, you touched on it. This case is about the plaintiff, not the community. But also, I don't know why there would be any circumstance where we should be talking about safety rules in a admitted liability case. So maybe that just was not the best example. But hopefully that's not going to be one of the arguments he makes, because we would certainly object to that.
Right. I don't know that safety rules would fit. I'm not a student of Mr. Keenan. And so I learned some about it by reading the motion, and that's just something that you mentioned about 10 times with safety rules. So just figured that's what reptilian arguments involve. But no, this isn't, because you've admitted liability, we don't need to get into this is why buses drive slowly. This is why buses, when it's raining, drive slowly. That's not where we're going here. All right. Mr. Johnson, your takeaway from this is that I don't view motion 15 as limiting you in any way.
Thank you, Judge.
All right. Other than that, if it's a repetition of sending a message, you're not doing that. 16, improper hypotheticals and speculative testimony. This is a motion I'm denying, not because conceptually I think it's wrong, but it's question specific. Y'all, both sides need to follow the rules of evidence as best you can. But what I'm going to need the defense to do is object at the time it's coming up. The one footnote exception I'll flag is this, Mr. Seaman, you've identified some material that looks facially speculative to me, and so it was appropriate to flag that. This motion doesn't get to quite that granularity, other than you gave an example that you expect Mr. Yeager to speculate. That's the verb you used about Ms. Daniels' ability to return to work. I don't know what's going to happen with Mr. Yeager, but if a question is prompting him to speculate and it's objected to, I'll sustain it. And if we keep running into Yeager objection, speculation, sustain, then we'll just have to have Yeager stop testifying. So I'll enforce the prohibition against speculative testimony, but it needs to be invoked at that time. Does that make sense?
Sure.
All right. Rebuttal experts. I'm denying it for now because I think it is conditional. We'd need to see what happens after plaintiff rests, defense puts on its case. But there would need to be a real good reason for that, a non-cumulative reason to have a rebuttal expert.
Can we talk about it for just a minute?
Sure.
Sure. So I don't expect that there will be a rebuttal here, but in the hypothetical where the plaintiff calls an expert and the defense calls an expert on the same subject, who then criticizes the plaintiff's testimony, the plaintiff's expert should be allowed to rebut anything that is brought up that is new by the defense witness. The point I was trying to make in my brief is we don't have to pre-rebut everything we believe that any defense witness would say.
I agree. No, I agree.
That's all.
Good. I'm just letting folks know that if you're going to call a rebuttal expert, we're going to talk first about what he or she is going to discuss. And I reserve the right to say, you know what, you've identified 3 areas. This one is cumulative, so stay away from that one. If your expert is simply going to say, like I told you before, the answer is 9, the jurors have already heard that your expert said the answer was 9. I suspect it would be more sophisticated than that. And if it is in fact rebutting something, there's nothing improper with that, I believe. We have everyone? Okay. Undisclosed expert opinions. Do we have any concerns about any more of those?
No, I just want to make sure no one,
There no more?
I just want to make sure no one comes to trial and has something new we haven't heard before. So,
Okay. Other than Mr. Seaman's recent deposition, anything else on the horizon, Mr. Johnson?
No, any inferences, any testimony that Dr. Seaman makes will be based on the numbers in his new report.
Okay. If it's not moot, I'm granting it. In other words, expert opinions coming in now that the defense hasn't seen would be excluded. The issue that you believe, Mr. Johnson, was made moot was the fact that Seaman got the second deposition. And I agree with you on that. Ms. Arnold is simply saying, if there's something beyond that, there'll be concerns and they'll likely be sustained.
Yeah, and again, with the same proviso that an objection be made at the time so that we can iron out the issue.
Well, objection be made at the time, but what won't work well for you in the end would be for you to go in an area that you know is new, and then Ms. Arnold or Ms. Page or Mr. Dial say, we had no idea that Yeager was going to talk about the other knee. That's just not anywhere.
Right. I don't anticipate anything like that, Judge.
Okay.
I just don't.
All right. 19 is evidence in opening statements. We've already talked about that. No depositions, but if it's photos or a video that you've got a good faith basis will be coming in, you can use those. Both sides can. Authoritative literature is granted, unopposed, and it's mutual. No expert should say, well, it must be true because look at this heavy book I'm holding in my hands. 21, displaying demonstrative evidence without having shared it first, granted, unopposed, and goes in both directions. And similarly, any other exhibit not being tendered and published before the other side has seen it. I'm hopeful that there are no exhibits that a side hasn't seen and is real familiar with. I think what we would get down to is if there's 700 pages of medical records, people might not have memorized what page 601 has on it. And so just make sure the side that's using page 601 says very clearly, I'm looking at 601 now. So the other side can scroll to it so they just know where things are. But presumably you'd be getting in the medical records as a single exhibit. Once they're in, you can bounce around wherever you want. It's just giving the other side the heads up that I'm jumping to page 601. But those rules apply in both directions. Any questions about that?
No.
Number 23 is a motion from MARTA to preclude the plaintiff from introducing evidence, making arguments about when in the stream of litigation, MARTA ultimately admitted fault. I don't think you had time to file a written response. But if you did, I didn't.
I did.
You did.
Judge, it's in my omnibus
Oh.
reply.
Okay. And it is?
That generally it's permissible for plaintiff's counsel to comment on the conduct of the defense of a case, and it's permissible to read and comment upon the pleadings in a case. The case cited by MARTA is Redmond v. Daniel, and in our view, that case was not on point. Redmond holds that the plaintiff has the burden of proving that any alleged damages were caused by specific acts of negligence on the part of that defendant. That's what that case seems to stand for, as far as we can tell. The attempt to preemptively, preclude any argument is problematic because there are so many ways that it could come up. But I do not intend, just for the edification of the court, I do not intend to stand up here and say MARTA fought tooth and nail against liability until a month ago when a pretrial was due, and then they switched. And now that comes up a lot in civil cases, and it is proper to comment on that. But in this
Tell
case,
me why
that's not the case.
Tell me why it's proper. How is it relevant to the extent of your client's damages and injuries, whether MARTA on Friday, just before we started picking the jury, or the very first right there at the incident, Mr. Maddox signed a form saying this was 100% my fault and my employer's fault?
In a case like this case, had MARTA stuck with a position for any length of time that said, not our fault, I would have amended the complaint to seek attorney fees, and it would have been relevant for that reason. I'm not going to make an argument that they waited till the last second to admit liability, because it's not true.
Okay. Well, let me push you a little on that, because that's not true and you're not going to do that. How is it relevant in any way to the question the jurors are working through that MARTA didn't on day one admit liability? I
don't particularly believe it is.
Okay.
It's never my intention to raise this point. I was just responding to the merits of their motion.
Okay. So I'm going to grant the motion. If you think the way the trial unfolds, Mr. Johnson, that it becomes relevant, the timing of MARTA's admission of fault, let's talk about that outside the presence of the jury, because as I understand what's being litigated here, I don't think it's relevant. If it's relevant, it is so barely relevant and probative that the undue prejudice would outweigh. I just don't think it's relevant at all.
Your Honor, just briefly, the other part of that motion really dealt with arguments we anticipate from plaintiff's counsel about strategy related to MARTA's admission of fault, that we're admitting fault to get a discount or to nickel and dime the plaintiff. And some of those examples of argument were listed in the motion. He responded that he absolutely intends to criticize MARTA's handling of the case, but as he just pointed out, there is no claim for attorney's fees here. So any discussion or argument about MARTA's strategy or conduct would be inappropriate.
So tell me, Mr. Johnson, what Ms. Arnold seems to have a different perspective of what you're going to do than what you have, because I thought you just told me you don't plan on sharing with the jury when MARTA admitted fault, and you have intentionally not amended the complaint to be able to argue that they were stubbornly litigious or anything like that, because they haven't been. There's not an agreement as to what the dollar amount is, but that good faith disagreement is why we're having the trial. So what is it that you would argue to the jury about MARTA's conduct in this case that's relevant?
Sure. It would be trial conduct. It would be things that came up at trial. If MARTA raised points that I felt were inappropriate, I'm going to point that out to the jury, and I'm going to tell them why I believe that an inappropriate point was brought up. I'm not talking about how they litigated the case up until now. I'm not going to bring in any past litigation scenarios.
Okay.
It would be court focused, trial focused.
So I'm just making it up, but if a defense expert said Daniels is a malingerer, you might, based on contrary expert testimony, say, look how MARTA is treating this. They call a witness who described my client as a malingerer. You've seen the videos. You, Mr. Johnson, don't believe the evidence supports calling my client a malingerer. And I guess that's commenting on trial conduct, which is, in my mind, perfectly appropriate and different from what I understood Ms. Arnold to be saying, which is Mr. Johnson saying MARTA has been difficult from the get-go, nickel and dime my client. They want to make sure she gets nothing. That's not how this has played out as I have understood it until now. But now we're in trial, and we'll see when the gloves come off how things are handled.
Completely with everything you just said.
Okay. Then I think I follow that. Can we postpone talking about Mr. Seaman because all our jurors are here?
Yes, Your Honor. If we are getting ready to get started, we do want to invoke the rule of sequestration though before
Okay.
we get started. Want to make sure I say that on the record. Sorry.
Great. That'll apply in both directions. So other than Ms. Daniels and the MARTA representative, although I don't think he's testifying, if there's anyone here who's a possible witness, need to be outside. My thought is that we bring Mr. Garfinkel in to hear from him, and then I'll get your thoughts on the record after he goes back in the jury room. Then we will get started with the, I'll swear them in and give them the introductory charge, and then you all can do your openings. If we could get Mr. Garfinkel, he's also, I think, 28. He's probably not going to remember that.
Oh, I'm sorry.
Yeah, she's on.
Good morning. Take a seat anywhere you want in the jury box. Mr. Garfinkel, you were juror 28 on Friday, and you shared with us the exciting family situation you have, the stressful family situation you have. When reality sank in that you had been selected, despite sharing with us the concerns and potential immediate conflict you would have, you reached out with an email to my staff. I've summarized it for the lawyers, but I wanted to give you a moment to articulate anything more. We were very much aware how expectant your wife is. And I tried to make plain that should that expectancy materialize into it's time, all you would need to do is say, I got to go, and your jury service would be done. You helped us understand that even though the due date is safely a few weeks away, if history is a guide, that's not necessarily an assumption we should make. Despite all that, you were selected. And here you are. But you were concerned. And so I wanted to give you a chance if there was more you wanted to say so we could hear it. And I also wanted to reassure you and reaffirm that as long as you've got a device on you that someone can contact you with, you are going to be able to leave immediately should something come up. Having said that, what do you want to add? And if you don't mind taking your mask off so we can hear. Thanks.
This situation, we're very imminent. I mean, as of last week, I think it was Thursday, doctor could feel the baby's head, cervix is soft. My wife is having very frequent contractions. She's taking care of our 3-year-old. My in-laws, her parents, are in Europe right now. Her stepdad and mom are in Europe right now, and she is miserable. And so I feel the need to be there with them as we may be going to the hospital today. I can't predict any more than that, but me being here is very anxiety driven for all of us.
Understood. Let me see if Mr. Johnson has any questions for you about that. Nothing?
I don't.
Okay.
I'm sorry.
Ms. Arnold, do you have any questions for Mr. Garfinkel?
I'll echo, sorry for the situation.
Okay. Let us talk about it a little bit more. Do you have on you somewhere a device so that your wife can hit a red button and then you stand up and say, hey, it's been real, and you go? Good. Okay. Have it on vibrate rather than ring. We need to talk about your situation a little bit and then we'll get you back out here. Thank you. Mr. Johnson, tell me your thoughts about Juror 28.
It's a awful situation for him. I'm fine recusing him, going with the alternate, and if we end up with less than 12, going with less than 12. I'm not going to be the one that says that somebody who's fixing to have a baby has to stay.
Okay. And I would never tell Mr. Garfinkel that you were that person.
I know.
Ms. Arnold, your thought about what we do with Juror 28.
I mean, I don't want to be the one either, but I think that as long as he has a way to exit quickly, I don't want to be in a position where we don't have an alternate. So I'd rather start, and if he's got to go, he's got to go, and then we have our alternate.
Okay, so Mr. Johnson offered another scenario, which would be Mr. Garfinkel goes and we'll probably make it just fine with 12. But if something happened, Mr. Johnson's not opposed to going forward with 11.
Your Honor, we struck the jury thinking that he was in play. And so we might have made some different decisions if that weren't the case. So I don't think we can agree to that.
Okay. He was as in play then as he is now. I guess we'll just cross that bridge when we get to it, but we'll keep him for now and see where things go. But you all should be thinking more about how that plays out if Mr. Garfinkel needs to go. All right. Let's bring all the jurors in, please. Thank you.
Judge, is there a lectern or anything that moves that we could put something on as we face the jury?
No,
This is what we have.
that rotates though. I mean, that you can pick that up and throw it. I don't recommend it, but so if you wanted to move the lectern a little, that little wood piece on top, you can rotate it, but all that other equipment's in the way. So I've had people bring like a little music stand. That's fine. Just don't push it off.
All around the juror.
Oh, you all can sit once you get to your spot. We're standing for you. So if you get to the chair that you want to sit in, take it. Thank you, Deputy Gordon. Everyone can be seated. Good morning, ladies and gentlemen. Happy Monday. Welcome to courtroom 8D. This is your new home away from home. This is where the lawyers and I were on Friday when you were at home or work or wherever you were. I appreciate everyone being here on time. We actually got here about 8:20 and have been working through some legal issues that took a little bit longer than forecast because now it's 9:40. Did anyone have any problems either getting to the lot where the shuttle is, or some folks may have gotten dropped off? Any logistical issues? Okay, seeing no hands. I want to talk briefly about masks. When you're in courtroom 8D, if you choose not to wear a mask, that's fine. That's your choice. When you all are in the jury room, which is a little smaller, I'd ask you as a group to decide what everyone is comfortable with. This is a larger space with air purifiers running, et cetera. And in particular, folks who will be talking a lot, that won't be you out here. I've actually directed them not to wear masks. So the lawyers are not being disrespectful of you, but it's real hard for a court reporter to take down what's being said if the mask is in between the mouth and the microphone. So you will develop your own comfort level while you're in the courtroom. When you're in the larger courthouse, the chief judge's order is still in effect. And so we all wear masks in the larger public areas. And then, as I said, in the jury room, you all can decide how you want to manage that. We are going to get started with the evidence in just a little bit. I need to talk to you a touch about the law that applies to a civil case, not specifically to this case, but in general, and what to expect about a trial. And then we'll get started. But the first thing I need to do, even though you just got comfortable, is to get you to stand. I need to administer the jury oath. So if you would all stand and raise your right hand. Good. Do you swear or affirm that you shall well and truly try the case that has been submitted to you and give a true verdict according to the law that I provide and the opinion that you form concerning the evidence that you receive, to the best of your skill and knowledge, without favor or affection to either party? Please say yes if you so swear or affirm. Yes. Does anyone not so swear or affirm? No? Great. Hands down. Take a seat. You're official jurors now. For the rest of your time here, when you show up, you're going to do what you did today, which is come around and go straight to the jury room. The jury room is your space. The bottled water in the fridge, that's for you all. And when it runs out, I checked on it this morning before you got here. It looked like there was more bottled water on top. If you run out of that, let us know. There is even more back in my office. The coffee maker is yours. I don't know if those little cup things are still there. You can bring your own if you have a preferred flavor, but if they're out, let us know. And I think we can bring more in there. All that stuff is for you to use. We will break typically 1 10 to 15 minute break in the morning, 1 in the afternoon, and about an hour at lunch. The timing of those things will be variable because it's driven by the flow of the trial. If we've got a real interesting witness and it's noon, I'm not going to interrupt that person, but I may ask the lawyer who's asking questions at that time, how much longer do you think this will go? And if he or she says 15 more minutes, we'll have lunch at 12:15 rather than at 12. That won't shrink your lunchtime. It just means that the lunch break starts a little bit later. Sometimes I may have a meeting that drives when we have to break, but otherwise it will be somewhat fluid. More importantly, we break whenever you need a break. So if we've been going for a while and you're starting to fade and it's hard to follow what the witness is saying, raise your hand, get Deputy Gordon's attention. And if we need to take a break as simple as, hey, I'm just going to stand up and move around a little bit, we can do that. It may be that you need to use the restroom, and we will certainly accommodate you so you can do that. When you are back in the jury room, you're free to spread out all the way down that hallway. You may need to make a phone call, do whatever you're doing. That hallway is private. You're safe back there. When you're out in the hallway, don't play the drums or anything. I have two colleagues further down the hall, and they'll come yell at me if you make too much noise. But if you just want to walk, look out the window, whatnot, you're welcome to do that. If you need anything, let Deputy Gordon know. Like I said, if supplies are running low, he can help stock you up. One other point. When you are circulating, come and going from the courthouse, you may bump into the lawyers and the parties in this case. If they seem standoffish, they see you and they kind of turn and run away. Don't misinterpret that. It's very, very important that the lawyers interact with you only when we're all together, so that lawyer from one side doesn't say something to you that lawyer from the other side doesn't get a chance to listen to and say, well, wait, I want my turn to tell them where to eat lunch. So you may simply want to know, where's a good place to eat lunch? And these lawyers need to say, you know what, I can't talk to you outside of court. Both sides need to have an opportunity to hear what the other side says. So all very nice people here, but they're going to treat you a little bit like you have the plague, or more so if they've got the plague. So they need to keep their distance. So ask me, ask a staff member, and we'll be happy to do our best to answer your question. We can't start till everyone's here. You are all on time-ish, so that's good. Tomorrow morning, we will not have as much stuff to work through, so we'll be waiting for you. So if you need to leave a little earlier tomorrow to be ready to go at 9, then do that. But for most of you, that was not an issue. And you all by now should have the phone number for Chambers. You wrote it down actually on Friday. Ms. Hansberry's number is our main number. Please call if something comes up and you're stuck. Judge, I'm trying to get here from Hapeville, but there's a big wreck. Then we can relax and we know you're on your way. It's when we can't find you that we get worried and maybe send people out to find you. So keep us posted. And also, we'll reach out to you if something happens in court. That means you don't need to be here at 9, you can be here at 11. That doesn't typically happen, but we'll make a two-way communication. I'm going to now tell you a little bit about what to expect for a trial. The first thing I want to talk to you about are those notepads you have. You are free to take notes if you want to take notes. You are not required to take notes. There is not an exam at the end of the trial, but there is something called deliberations. When we're done with all the evidence, you're going to go back with your colleagues and decide what happened in this case and make a ruling. And you will do that based on your collective recollection of what witnesses said, and then the physical evidence that was presented. Maybe there'll be pictures or documents. Those kinds of things go back with you. What you do not get is witness testimony. You will not have transcripts of what the witnesses said when they testified. So some people like to take notes based on something they heard that they think is interesting or relevant, and you're welcome to do that. Your notes will be private until you begin your deliberations, and then you're free to share your notes with each other. Hey, I wrote down X when person said that. You shouldn't let someone else's notes overcome your personal recollection. If you are certain that the witness said the sky was blue and someone else said, I wrote down that it was cloudy, that's interesting that that person wrote it down. But if you are convinced that the testimony was that the sky was blue, and that's your independent recollection, then that's what you go with. Please don't let your note taking distract you from what's going on in court. Another role you have is determining the credibility or believability of witnesses. And one way that humans do that is by watching how people react to questions. And you may get a witness who, in response to questions from one side, is real open and making eye contact. And the moment the other side starts asking some hard questions, the person shuts down, won't make eye contact, starts sweating, who knows what. That may communicate something to you as a judge of credibility, But you'll miss it if the whole time you're trying to write down word for word what everyone says. You will be overwhelmed if you try to write down word for word what everyone says, and you'll miss some of the physical dynamics of witness testimony. So feel free to take notes if you want. If you run out of paper or your pencil gets dull, we can give you new pencils. We can't afford pens for everyone, so that's why we start with pencils. You can bring your own writing implement. Last thing about notes, they'll be destroyed when the trial is over. You don't have to worry about them ending up online or anything like that. They're private. If you choose to share them with your colleagues during deliberations, that's great. But when they're done, they get shredded. You all are about to hear the trial of Jame Daniels versus MARTA, which is also known as the Metropolitan Atlanta Rapid Transit Authority. I'm going to call it MARTA throughout the trial. I need to talk to you a little bit about some of the general principles of law that apply to civil trials and the way a trial flows so that you have a better understanding of what to expect. Most of you have not served as jurors before, and I'm here to tell you it's not like on TV. No one's going to run into the courtroom in the middle of someone's testimony and say, I shot him. First of all, no one got shot, but that's not how it really happens. And how you are to conduct yourselves during the trial. The main two rules being pay attention while you're in court, and when you're out of court, don't conduct any outside research. It's real tempting these days, like I'm just going to look this one thing up because the witness said something about that. You cannot get evidence outside the four walls of this courtroom because that won't be evidence that the other side could challenge. You may look something up about an injury and say, oh, look, on WebMD, it says X. WebMD didn't testify. WebMD didn't come in here so that lawyers for both sides can say, where did you get that opinion? You are going to have experts who testify during this trial talking about injuries. That's where you get your evidence in this case and not from outside sources. In a civil case like this, the plaintiff has the burden of proving her case. She must prove the extent of her damages and the value of the injuries, et cetera, the things we talked about on Friday, by what is known as a preponderance of the evidence. The term preponderance simply means superiority in weight. And as it is used in civil trials, preponderance of the evidence simply means the greater weight of evidence on the issues involved. To be a preponderance, the weight of the evidence must be sufficient to incline what we call a reasonable and impartial mind. We've got 13 of them sitting right there, to one side of the issue rather than the other. And this is where thinking of that, the blind lady, well, she's not blind, she has a blindfold on, with the scales is actually helpful. In a civil case, you are deciding, do the scales move at all? The plaintiff has the burden of moving the scales in her direction, just perceptibly so. There's not, unlike in a criminal case where there's a big debate about, well, how much did the scales move? What is a reasonable doubt? If you, after hearing all the evidence and seeing all the evidence, feel like the plaintiff has moved the scales perceptibly in her direction, she's met her burden of proof. If the scales are even at the end of the trial, or they are perceptibly leaning in MARTA's direction, then the plaintiff has failed to meet her burden of proof. The basic structure of the trial is that in a few moments, both sides will have an opportunity to present opening statements. This is a chance for the lawyers to give you a preview of what they expect the trial will be all about. Nothing that the lawyers say in their opening or at any other time during the trial is evidence. Evidence comes to you in two forms: what a witness says under oath, and then the physical evidence that comes in, the papers, the photos, et cetera. The lawyers are free to give you their preview, and you're free to write it down, but you need to remember that just because lawyer X said, hey, this is what is going to happen in the case, doesn't mean that that's what happened in the case. You would need to conclude that some witness or witnesses actually said those things for you to say that's the proof in this case. Neither side is required to give an opening statement, but both sides probably will. Once the openings are over, the plaintiff begins to present her case, and that will start by Mr. Johnson or his colleague calling the first witness. That witness will come on up, sit right there, be sworn in, and ultimately will answer the first question. And that answer to the first question is the start of evidence. The lawyer's questions are not evidence. It's only the answers that the witnesses give. When the plaintiff has presented all of her evidence, at some point I'll say, Mr. Johnson, call your next witness. And Mr. Johnson will say, Judge, plaintiff rests. Great, we've heard from the plaintiff. I'll turn to Ms. Arnold, say, Ms. Arnold, are you going to call any witnesses? And the defense has the same right to have witnesses come on in here. Now, they don't have the burden of proof. They may feel that they've got all the evidence they need out of the plaintiff's witnesses, but the defense will be free to call their own witnesses. And ultimately, at some point, Ms. Arnold will say, when I ask, we'll call your next witness, she'll say, we don't have any more witnesses. The defense rests. And generally, that's the end of the trial in terms of evidence. There may be rebuttal every once in a while. Something comes up and the plaintiff has the opportunity to say, well, we need to recall a witness or call a different witness because something came up during the defense case that we need to rebut. Eventually, the lawyers on both sides say, no, we're done. No more evidence. And then the lawyers will have a chance to give what we call closing arguments. This is when the lawyers seek to persuade you to decide the case in their favor. And they will argue, not at you, but with you, hey, this is what the evidence shows. It's just real clear, ladies and gentlemen, based on this testimony, this is what happened, and this is what you should do. And you should feel free to be persuaded. But remember, just because the lawyers tell you that's what the evidence is, doesn't make it so. You decide what the evidence is in the case. When the lawyers are done with their closing arguments, I will speak with you one last time, and that's when I will give you more detailed legal charges about the things that are at issue, what constitutes pain and suffering, what damages are available, how you think about damages and calculating an amount. There's certain legal guidance I'm required to give you to help you work through the questions you're being asked to decide by these parties. During trial, as you have no doubt seen on TV, parties may object. Someone will stand up, objection, hearsay, whatever the objection might be. My job in connection with that is to rule on the objection. I'll either say sustained or overruled. If I overrule the objection, we keep on going the direction we were in. If I sustain the objection, that means that the question was not a legally proper question. No one's done anything wrong. It's just that the way that question was set up, the witness was about to say something that the witness ought not to be allowed to say. And so the lawyer who asked the question either needs to reformulate the question or head in a different direction. Every once in a while, the objection is made only after the witness has started saying some things, because the question on its surface seemed fine, but the witness moved in a direction that the lawyer was not expecting. And you'll hear a lawyer say, objection, move to strike. And I may sustain the objection and tell you all to disregard what you heard that witness say. If you wrote down what that witness said, cross it out. And I need you to police it when you're in your deliberations. If you're deliberating and one member of your group said, hey, remember that guy said that the person was wearing a blue shirt, and for whatever reason, I told you to disregard that. You need to say, we weren't supposed to worry that was disallowed. There was something about that testimony that we weren't supposed to pay attention to, and we're not supposed to be talking about that the guy said the shirt was blue. That may seem like an unfair thought requirement because you heard it and you're thinking about it, but you need to uphold it. The good news is if it is something really central to the case and someone blurts it out, we're not just telling you to disregard it. We're probably telling you you need to go home because it was a mistrial and we have to do this trial all over again. But we've got good lawyers, and I am hopeful that something like that doesn't happen. And frankly, this isn't the kind of case where there's a real high risk that a witness is going to blurt something out that would so taint you all that me telling you to disregard it just wouldn't be fair. But it can happen that you need to disregard something, and I'll ask you to do so. The other thing that lawyers may do when they are opposed to something that just happened is stand up and say, Judge, I have a motion. And all you need to know when you hear motion is it's probably you get a bonus break because the lawyers are going to need to articulate more freely outside your presence what their concern is. Sometimes I'm able to defer that motion until a natural break. I may ask the lawyer who's got the motion, hey, could we hold off to lunch to do that so you don't need to take an extra break, and we'll use our lunch to cover that and you can have your lunch. My job with the motions and the objections is simply to apply the law as best I understand it. If I sustain an objection, that does not mean I'm picking sides. It simply means that that objection was a valid legal objection and I ought to sustain it. If I overrule a motion, it doesn't mean it was a bad motion. It just means that the merits were on the other side. Nothing that I say during the course of this trial should be interpreted by you as some indication that I think one side is doing a better job that the evidence is stronger for one side or the other, or that I have any inclination as to the decisions you will be making. That's not my role. I'm here to make sure that the case is fairly tried and that your needs are met. Your job is to decide the facts of the case from the evidence that you see and hear. I've already told you what the evidence is, testimony and exhibits. You'll use those to decide what are the damages in this case, if there are damages, and how do you quantify that? We've also talked about what's not evidence, what the lawyers say, what I say. Questions are not evidence. You will be determining the credibility or believability of the witnesses you hear. There may well be witnesses who disagree, who recount things differently, who have differing opinions about what they've experienced in this case. And you need to reconcile all that. You'll decide which witnesses you believe or disbelieve, if they're witnesses you disbelieve. In determining credibility, you're free to consider all of the facts of this case, the manner in which the witness testified, the witness's apparent intelligence, the witness's interest or lack of interest in the outcome of the case. We sometimes call that bias. And the means and the opportunity that the witness had to know about the things she's testifying about. You are free to believe or disbelieve some or all of a witness's testimony. Your job is to determine what testimony is worthy of belief and what testimony, if any, is not. Now, you may from time to time determine that there are conflicts in the evidence. If you do find conflicts in the evidence, you should try to reconcile them as if every witness was testifying fully truthfully. As you know, very often one person's recollection about an incident differs from another. It doesn't mean that someone's being untruthful. They saw it differently. They were standing in a different place. Their memory is slightly different from someone else's. If, however, you do find that some parts of the evidence are in such conflict as to make it impossible for you to reconcile it, you must believe the evidence that seems most reasonable, probable, and truthful to you. You must pay as close attention as you can throughout the trial. Testimony will not be replayed. You don't get to say, wait, I was kind of dozing the last 10 minutes. Could you have that guy repeat his answers to his previous 15 questions? That won't happen. So let me or Deputy Gordon disappeared on us. No, not let me. There he is. He went to the Miami, Texas A&M game. It didn't go well for poor Deputy Gordon's team. 3 field goals. He traveled all the way to Texas, and all he got for that is 3 measly field goals. But he's back, and we're glad he's back. Anyway, let us know if you're starting to fade so that we can figure out a way to get you re-engaged. During trial, to help minimize the urge to get online to research something, you will be permitted to submit questions of your own. And the way you do that is by writing them down on those note cards. There's one small stack of note cards, and we're going to add more to that stack very shortly. But you'll see on that bench in front of you, they're little 3x5 note cards. You are free to write down questions if you have them. Don't put your name on the card, just whatever the questions are. Write them only on one side of the card. You can put multiple questions, as long as they're legible, on one card. And when we're done with the witness's testimony, after the lawyers have asked all they're going to ask, I will ask you all every time, do you have any questions for this witness? And if you do, write them down. Deputy Gordon will collect them. I will review those questions with the lawyers, because just like lawyers can ask objectionable questions, you can too. Those that are not objectionable, I will ask of the witness. If your question is not asked, you should not draw a conclusion from that. Oh, the judge doesn't like me. That's not it at all. It just was a question that was an improper question for whatever reason. When the witnesses are done answering your questions, the lawyers will have one last crack at the witness, because we have all found that jurors ask good questions. And the lawyers, oh my gosh, I didn't even think of that. I want to follow up, and I will let them follow up. That's the way you can have something explained to you if you didn't get it the first time the witness explained it. And that happens all the time. You will see during the trial, I will ask questions every once in a while. If I'm confused by something, I'll say, I'm sorry, could you explain that again? And you ought to have that same right. And you do. Just write it down on the card. And if it's an appropriate question, it will be answered, or at least the witness will give an answer. It may not be what you were hoping you'd hear, but that's not how questions work here. I'm going to say it again. It just bears repeating in this day and age. You must decide this case solely on the testimony you hear and the exhibits you receive in court. This will not be on the media, but in the crazy off chance you're driving home, listening to NPR, and someone says, hey, exciting trial with Judge McBurney involving a MARTA bus, change the station, because that reporter's rendition of what happened is fascinating and probably inaccurate. You were here and you heard it all, and you shouldn't read about it or listen to it on the radio. I don't think you're going to run into that, but if you do, move away from it. No outside research, and you need to be very discreet about how you talk to people in your life while you're serving as a juror. You're going to get home today and someone is going to say, how'd it go? What happened? And the answer is, it was interesting, or pick your adjective, but that's it. Don't go into the details, because well-meaning people will say, oh, that's fascinating. That happened to me once. Let me tell you my situation. Or I was a juror once, and when the judge does this, that's what it really means. Maybe they're right, maybe they're not, but you are now starting to hear about things, facts, circumstances, trial process. That's not this case. The lawyers aren't there to say, wait a minute, I object to that, or well, let me ask that person a question. So you're probably not going to want to talk about it anyway, because you'll have been here all day, but resist the temptation to share with that significant other, your pet, your plant, a coworker, what's going on in your life. Don't post online, hey, had a trial today, because well-meaning folks will post back saying, let me tell you the best trial strategy. And when you hear a lawyer say this, this is what it really means. Don't engage in any of that. When the trial is over, you can do whatever you want. You can write a book, you can sing a song, but until it's over, we need to do our best to keep you in a protective bubble so that what you hear about civil trials, and this trial in particular, occurs in the courtroom. Last point, and it may seem a little counterintuitive, it's important that the 13 of you don't discuss the case until all the evidence is in. So when you take your first break today, don't go back there and say, well, what do you think? I'm already leaning this way or that way. You may be already leaning some way, although you haven't heard everything yet, but you don't engage with others on that. You'll have all the time you need when it's time to deliberate, to discuss with everyone what you think about the case and what you think ought to happen in this case. But until you've had all the evidence, the lawyers have tried to frame it in their closing arguments, and I've given you the law that you have to apply. It's premature to start discussing. Talk about anything else you want. Don't talk about the case until you've heard it all. That is it, my friends. I appreciate you listening to me. We are going to pivot now and make sure the technology is working here. Does that screen? It does. I'm going to make sure that screen rotates a little bit. That big screen. Is there anything on the screen up on the wall? No? It is sort of, is it on? It's not on. Don't hurt yourself. Okay. How could you tell it was not as a low red? Blue light. Okay. See? Well, we can sort that out during a break, as long as the big gallery screen is on. You got it? Okay. Something may pop up there. We'll make it hopefully show what's on that big screen too. Mr. Johnson, are you ready with your opening?
I am, Judge. Thank you.
You bet.
Good morning. My name is Trip Johnson, and I am here today with my colleague, Jackie Sadler, to represent Ms. Jame Daniels, who is this lady sitting right here in the corner. As I think you've heard, this is about a catastrophic collision that occurred on March 2nd of 2020. MARTA admits that it caused the collision, and we'll talk about that. And this case is about what it's going to take to compensate Ms. Daniels fairly for everything she has been through and everything she will go through for the rest of her life. I want to begin by telling you what the evidence is going to show about the collision itself and where Ms. Daniels was going and why she ended up in a car hit by a MARTA bus. On March 2nd, 2020, Ms. Daniels was at her job. She was a property manager for a 210-unit apartment complex called the Vineyards at Browns Mill. And she was employed by a management company, HCI Management, but she was the property manager of this 210-unit, 20-acre property. It was lunchtime, and Ms. Daniels had a friend whose mother was in a rehab facility. And apparently the mom was having some problems at the rehab facility. And Ms. Daniels decided that she would help out if she could. So she got in the car at lunchtime and was heading to this rehab facility to see if she could help this lady out who was having an issue at the rehab facility. And Ms. Daniels was going up Cleveland Avenue, near where the Cleveland Avenue Public Library is, if any of you all happen to know where that is. While at the same time, a MARTA bus was coming the opposite direction on Cleveland Avenue. And rather than try to explain to you how the collision occurred, we're going to just show it to you, okay? And we can talk about it. If we will go ahead, please, and play exhibit P6. And actually just freeze it before you start it. So I can say another word about this. This is the video you're going to see is a video the parties have agreed. It's the video shot from the front of the MARTA bus looking forward as the MARTA bus is driving. The lines you see here are timestamps and indications of speed from 0 to 60 at the top. See that? And these little dots are seconds, so that you will see at a couple of seconds before the collision, the bus was going about 45 miles per hour. With that, I'm going to let you watch the video and see how this collision occurred. Students didn't see it. And she was horribly, horribly injured, as you'll hear in the evidence. While she's in her car, the evidence will be that many of her bones are broken, and we'll go through the long list of them later. And she couldn't get out of the car, so you'll hear her tell you the story about how they finally were able to get her out of the car and get her into an ambulance, and fortunately get her to a level 1 trauma center, which we all know is Grady here in town. You're then going to hear about the first 2 weeks of the month that she spent in the hospital. The first 2 weeks at Grady were emergency surgeries primarily, and trauma care and recovery. The evidence is going to be she couldn't leave her bed, she couldn't move her arms, couldn't move her legs, but at least family could visit you at Grady. Now, keep in mind, and the evidence will be in this case, that in March of 2020, we were in the height of the COVID pandemic. So it's fortunate that Grady had rules that allowed family to visit. So Ms. Daniels, as bad as I believe the evidence will be about her life in Grady, she took some comfort in having family there. But after the first 2 weeks, she was transferred from Grady to DeKalb Emory DeKalb Hospital for what was supposed to be initial rehabilitation. And she was there for another 2 weeks. Strict COVID protocols were in place while she was there, okay? The evidence is going to be that she was isolated from her family members for that stay. The evidence is also going to be that she got misdiagnosed with COVID, and you'll hear all the travails that she underwent while at this rehab facility. After a month in the hospital on June 2nd, 2020, she was finally released to go home, but of course, home wasn't possible, so she moved in with her mother. And for the next 2 months, she lived with her mother, and you're going to hear about her life there. Now, before we talk about that, in order for you to understand what this did to the life that Ms. Daniels was leading before the collision, you're going to need to hear some evidence about what her life was like before, so you can make a comparison. With that, let me ask that we put up Plaintiff's Exhibit 32A. This is a picture of Janice Daniels, taken from before the collision. And you're going to hear about the life she led. You're going to hear that she had a successful career. She was on a forward-leaning career path. She had started with HCI management. She'll have to tell you for sure, but before 2013, and she started off as a leasing agent for this apartment complex, then got promoted to the assistant property manager of the entire complex, and then got promoted to property manager. And she did that job for years. And the evidence is going to be that she was good at it. She's going to tell you about it. And she's going to tell you how that made her feel. And she's going to tell you about her family. She has 3 children. She's going to tell you about her life with her 3 children. She's going to tell you about what she liked to do. She's going to tell you about going out with friends, wearing cool shoes. I'll have to call this cool shoes. I don't know how she described her. And dresses, and going out when she could. She's going to tell you about all of that. The evidence is going to be that Ms. Daniels hasn't worn that dress since the date of the collision. And let me show you why we believe the evidence is that that is so. You all see that, right? Yes. This is a medical illustration that will come into evidence later in the case. When the doctors testify during this trial, they'll testify by video. They've already given their testimony, so you'll watch the doctors, and you'll see them discuss this. This is an illustration to show you all of the different parts of Ms. Daniels' body that were broken by this MARTA crash. She broke both bones.
Can you pause for 1 second? Can you please stop screen sharing? Because I'm able to, not you, Mr. Son, your team. There we go. Now that's on the screen for me. Yep.
Okay. She broke both bones in her left arm, for which they installed permanent plates. She broke her right arm and her right wrist, for which they initially had a long plate that extended from her arm into her wrist. Eventually, this was removed, but she now has a frozen wrist. Her right wrist doesn't move up and down, frozen in place. She broke her knee that they put back together. She broke both bones in her right leg, and she broke her ankle. The initial surgeries in this case at Grady were involved two trauma surgeons that operated on her essentially at the same time. We had one trauma surgeon that concentrated on the lower body, put back together her knee, put back together her leg, put back together her ankle. He had to do that in two different surgeries because in order to heal the leg, he had to place some exterior rods that went through her skin into the bone. And then eventually he was able to remove the exterior rods. We'll show you pictures of this so you'll see what I'm talking about. But that's what this illustration is right here. The hand surgeon will tell you, and arms, upper extremity surgeon, Dr. Payne, will explain to you what she did and why it was extremely complex. Ms. Daniels eventually, as I say, was discharged from both hospitals, first Grady and then Emory. When she got to her mother's 1 month after the collision, the evidence is going to be she couldn't walk, she couldn't stand, she couldn't even sit up. Everything was done for her: bathroom, feeding, bathing, everything. But that 2 month period in her mother's, the evidence is going to show, was that time when she first began fighting back and first began making little steps of progress until she was able to, months after that, walk. But let me show you an example of that from when she was at her mother's. I want to show you a video clip that the evidence is going to show was the first time Janice was able to sit up and get out of bed and get into a wheelchair. So you'll see what I'm talking about. If you'll please play exhibit P12.
Take your time. There you go. Look at that champ.
Yes.
Look at that champ.
Yeah, boy. Never can keep me down.
That was the beginning of her rehab. After 2 months, and again, keep in mind, if you're listening to the evidence, this is COVID, right? This was raging COVID, fear of COVID. She was staying with her elderly mother, her older mother. And so her children were living separately from her. And they couldn't come visit because grandma could get COVID. And so Miss Daniels lived alone with her mother for this period until it became too much. And she relocated from Atlanta to Texas, where her father lived. Her father was a preacher in Texas, and her sister lived there also. So she moved to Texas to recover there. When she got to Texas, she still could not walk, but that's when she began the physical therapy that led to her being able to stand on 2 feet again. And we're going to show you video of that rehab journey. We're going to show you what it took for her to learn how to walk again. We're going to show you the exercises she did to rehab her wrist. So you'll see all this. Now, the evidence will be that while she was in Texas, she was more mobile than when she was in Atlanta. She was able to get around in a wheelchair pretty well if people pushed her. And she was able to go to high school football games while she was in Texas. They would take her, family would take her to watch kids play football. That's a thing in Texas, is high school football. And she went to a number of games, and you'll hear about that. Sadly, her father passed away while she was there. And the evidence will be that they were very close, and it was a bad situation. But she relocated back to Atlanta after being for some months in Texas. And it's from there that we pick up the story of what her life sort of began to be after that. She was able eventually to walk. The evidence is going to be that her right knee was bent inwards instead of facing forward as she walked. Her right knee was bent inwards. The doctor, who you'll hear, Dr. Moore, calls it knock knee syndrome. It's when apparently, according to Dr. Moore, the arthritis can twist your knee inward. So she walked with a limp because of that. And she walked in pain because of that. And she's going to testify that her ankle caused her severe pain when she would walk. Now, she lost her job after all of this. And you're going to hear testimony that she was not then, she is not now physically capable of being a property manager for a 210 unit property with no elevators on it. On a 20-acre property. You're going to hear that evidence, and we're going to bring you, in fact, our first witness we're going to bring you is Ms. Daniels' former boss, Heather Poole. Ms. Poole was with Ms. Daniels for years as Ms. Daniels progressed up the ladder at HSI, and Ms. Poole was always ahead of her on that ladder. And so Ms. Poole, I believe the evidence will be, was largely responsible for suggesting her for promotions along the way. And Ms. Poole will explain to us what it takes to be a property manager at a place like this, physically, what it takes, what is the job involved. And she'll tell you what she has observed about Ms. Daniels since the collision occurred and whether she believes from her observation as to whether Ms. Daniels could do that job. MARTA may bring evidence to you to try to convince you that she could do that job. She could have done that job last year, maybe MARTA will say. I don't know. I just ask you to listen to the evidence on this and make your own decision. As part of that, last August, we hired a physical therapist named Mark Yeager to perform a series of tests called a functional capacity evaluation. He ran Ms. Daniels through a battery of physical tests to test all parts of her body to see if he could quantify what she could and could not do and how that list of what she could or could not do generally fit within certain federal categories of jobs. And you'll hear his testimony about that. And to be clear, the evidence will be he is our expert. We hired him to do this. We paid him to do this. Now, MARTA also hired a physical therapist to conduct the functional capacity evaluation. Her name is Peggy Freeman. And she did essentially the same thing that Mr. Yeager did, although her testing methodology, some of the bending and twisting and lifting were slightly different, but she put Ms. Daniels through this same battery of tests. And MARTA may have her come testify and tell you what she thinks and whether she feels that her results or her opinions are any more valid than Mark Yeager's. If that happens, I ask you to give her your respectful consideration, listen to what she has to say, listen to what Mr. Yeager has to say, and draw your own conclusions. Because we have the burden of proving all aspects of our case, one of those aspects is wage loss. Not only past wage loss, but future wage loss. And more generally, this is kind of combined in a term called economic damages, okay? And that is why we're bringing you Mr. Yeager, who will tell you how she was doing back when he saw her last August. And that is why we're bringing you an economist to testify about the numbers. His name is Dr. Bruce Seaman, and you'll hear from him, and he will tell you how he calculated Ms. Daniels' prior losses and how he calculates her future losses. MARTA disagrees with Dr. Seaman's calculations, as you'll hear. And that's fine. We ask that you listen to what Dr. Seaman has to say about how much she lost before and how much she's likely to lose in the future. Draw your own conclusions. The evidence, though, is going to be that that element of her case, which we value total economic losses for her lifetime, from 2020 until 35 years from now, is about $900,000 if you add it all together for her lifetime. And while we're going to present you that evidence, I will tell you that the evidence is also going to be that that is the very smallest part of her case. Very smallest part. But it is part of her case, and I'm her attorney, and it is my obligation to seek an award for her for everything she's entitled to, whether it's big or whether it's small. She is, we believe, entitled to wage loss and lost economic damages, and we're going to be asking you for those at the end of the trial. We're also going to be asking you to have MARTA pay her medical bills. Her medical bills total around $900,000 so far. The evidence is going to be that that number will increase in the future. Ms. Daniels, just this past June, about 90 days ago, I guess, or less, just had another surgery. This time it was to fuse her right ankle because she had been living since the collision in such bad ankle pain that the doctor concluded that the only fix for that, fingers crossed, is to fuse her right ankle. The evidence will be that her ankle is fused at the subtalar joint, which means that she is still able to move her right foot up and down, like you might press a gas pedal, right, in a car. She can do that. The evidence is going to be that she has forever lost the ability to rock back and forth, left to right. That's what happens when you get your ankle fused in this manner. All she can do now is move her ankle up and down. You'll also hear that she is going to have now a total right knee replacement. Because as you'll recall, we talked about the right knee being bent in and being extremely painful. The doctor who's going to do that surgery will tell you about it. It's just basically called a total right knee replacement. But they can't do that surgery until she finishes recovering from this current ankle fusion surgery. And she's in the middle of her physical therapy now. You know, there's a whole protocol that you follow. The evidence will be after a surgery of any kind, and she's in that part of the protocol now, which is doing the physical therapy after the ankle surgery. So when she heals up enough from that, she's going to have a right knee surgery to replace her right knee. That doctor is going to come testify by video. He's also going to tell you that right knee replacements aren't forever. Typically, they last about 20 years. So we are going to present evidence to you that she's going to suffer another surgical intervention for which she's entitled to have MARTA pay in about 20 years. And you'll hear about that as well. At the end of this case, we're going to ask you to place values, dollar values, for every injury that Ms. Daniels suffered. And I want to talk about that for just a minute and put up an exhibit that's just my handwritten note. It's just my typed notes. Do you have that? Apologies for this being a little on the small side, if anybody has eyesight like mine. But these are some examples of some of the areas that we're going to be asking you to place a value on at the end of this case. So I wanted to go over them with you now so you'll know what to listen for at trial when you have to decide what these things are worth. We've got, of course, medical bills and then the economic losses, which I've already talked to you about. We have the pain and trauma from the crash while she's still in the car with her broken bones and has to be extracted from the car. We've got her life in Grady Hospital for 2 weeks, where she couldn't move and had emergency surgeries. We've got her 2 weeks at Emory DeKalb Hospital, which she'll tell you about. We have 4 surgeries initially performed by 2 doctors: leg, ankle, arm, wrist. They include knee, but that's sort of part of the leg, we'll say. She had a second surgery on her right leg, which we're going to ask you to assign value to. She had a right ankle fusion surgery in June of this year, which we'll ask you to assign value to. She's going to have a right knee replacement surgery, which we'll ask you to assign value to. She is likely, according to her doctor, to need some sort of revision probably 20 years out, because that's typical for people with right knee replacements.
Your Honor, I hate to object, but this is getting into argument, which isn't proper in opening statements. And this is not the verdict form that they'll be asked to fill out, Your Honor. So I just wanted to state that. I hate to interrupt.
Okay. If you want to move through this a little more quickly.
I'm almost there.
Okay.
You're going to hear about every aspect of her life that was impacted and for which MARTA owes her money from the date of the crash until today. But the most important part of her damages, and what we believe will be vastly the largest part of her damages, are what MARTA owes her for the next 35 years that she's likely to live on this earth. For everything that she's going to live with is permanent. Now, MARTA is going to rightly point out that this ankle surgery that Ms. Daniels just had, because the doctor will tell you, if it all goes right, it should greatly reduce the pain in her ankle. And that was the goal of the surgery, is to reduce the pain in her ankle. It's not there yet, but we're hopeful. The doctors are hopeful, Ms. Daniels is hopeful. The knee replacement will hopefully, as the doctor who's going to do it said, fix her knee so that she's not in terrible pain and doesn't inwards. And so you may conclude that after all of that, you may conclude that a right leg, knee, and ankle are just like normal, just like it never happened at some point in the future. And therefore, you may decide that there is no money to be awarded for the next 35 years of that. We don't believe that's what the evidence is going to be, but listen to what MARTA has to say, what we have to say, to make your own opinion about that. What we believe everyone will agree to is that her right wrist is never going to be the same. That the scarring all over her body is never going to be the same. That her right ankle is always going to be fused for now and forever. And that she's going to have other lifetime issues. And we're going to ask you to fairly value those for the next 35 years. We are never going to ask you, and the evidence will support this, we believe, we are never going to ask you for a number for anything that we can't support. We will tell you where we get our numbers into this case. And I'm sure that MARTA will as well. Now, let me say a word about the order of the evidence in this case. Because I think it might lessen maybe some anxiety just to know what's coming, just so you won't be here wondering what's next, what's next. As I told you, you will first hear from Heather Poole, who was Ms. Daniels' former boss. She's going to talk about her job there and what that was about. After that, we're going to call our functional capacity evaluation expert, Mark Nader. And he's going to tell you about the testing he did this last August and what his conclusions were. And then we're going to bring you our economist, Bruce Seaman, Dr. Bruce Seaman, and he's going to tell you the numbers he calculated for if you find that she deserves her wages from the date of the collision until today or to some other point in the future. He's going to tell you what those numbers are. His job is not going to be to tell you whether you should award those numbers. That's going to be your job. He's going to tell you what the numbers are. And he's going to tell you his best understanding of what the numbers in the future are likely to be and how they compare to what Ms. Daniels would have earned if she had been able to keep her old job. After that, you will hear from Janice Daniels' daughter. She's a teenager. And she's going to talk to you about what she's seen her mother go through. And she's close to her mother. And I think that she can offer a little bit more insight than somebody who sees her less often. So we're going to call her to testify. As I mentioned, Ms. Daniels is currently living with her mother again because she's rehabbing from this ankle surgery. So we're going to bring her mother. Her mother's name is Marilyn Lundy. And she's going to come tell you what she's seen of her daughter as her daughter has been through all of this. After that, and this will be, I'm sure, tomorrow, you're going to hear from the 4 doctors. Dr. Payne, who did the lower extremity emergency stuff. Excuse me, Dr. Payne, who did the upper extremity emergency stuff. Dr. Moore, who did the lower extremity. Dr. Kadakia, who did the ankle fusion, and Dr. Sadlak, who was going to do the knee replacement. Doctors don't much come to trial anymore live because of the conflicts involved with that. So the court permits the parties to take their testimony in advance. And that's what we've done. So we asked for your indulgence. We're going to show you 4 not exciting video shows. It's just that, as Judge McBurney will tell you, it's our obligation to prove our case. And I can't come back here into this case and ask you to award damages to Ms. Daniels unless I prove to you that she suffered those damages. So because of that, we're going to call these 4 doctors and you're going to watch 4 videos of those doctors. And that is why. After that, you're going to hear from Ms. Daniels. She's going to tell you her story. She's going to tell you everything she can think of. She's going to tell you, for example, that when she got back to Atlanta for that period of time from Texas, when she returned from Texas in Atlanta, and as she began getting better, she began doing some things. She took some trips, in fact, and she's flown on airplanes. The evidence is going to be she's flown several times to see her son play college football because he did. And she is going to tell you about a trip she took for 2 days to Las Vegas when her daughter turned 21 years old. She took her to Las Vegas for 2 days. She'll tell you about using the scooter in Las Vegas for 2 days and coming back. She's going to tell you about all the little trips she can think of. So you'll know that she took. MARTA may present evidence or suggest that because she's taken a series of plane rides and car rides, that she's fine to go back to work. And you'll make that determination. Also, since getting back from Texas, she's learned to drive again, and she is able to drive. And she drives her daughter, did before the ankle fusion surgery. She drove her daughter to school a lot of the time. In the morning, about 30 minutes, and then home about 30 minutes. And she'd pick her up sometimes in the afternoons. Ms. Daniels will tell you that the rest of her day was mostly spent laying around with her ankle and her leg was swelled. But she drove. And we're going to tell you all about that. As she got back from Texas, from then until now, she has gotten better. She's not appreciably better since we believe the evidence will be, since Mark Yeager did his functional capacity evaluation, she still can't use her ankle that they just used. But that's because she's in the middle of healing from it, and Ms. Daniels is hopeful that that surgery is going to be great. And that it's going to take away the pain, even if that is at the expense of being able to move her ankle in certain directions. At least it's going to take away the pain. She's going to tell you she's hopeful that the knee surgery to replace her knee is going to take away that knee pain and give her a functioning knee. We don't know, but she's hopeful. At the end of the case, we're going to come back. We're going to remind you of this. We're going to address any concerns that MARTA has raised about anything we've said, and we're going to ask you to tally all this up, and it's going to be in the millions and millions of dollars. If you will simply do us this favor, if you will listen to Judge McBurney and follow his legal instructions in this case, and if you'll put your faith in Judge McBurney to do that for you, to give you the law and for you to follow it, Ms. Daniels to put her faith in you, and we really appreciate it. Thank you.
Thank you, Mr. Johnson. Ms. Brown, you good if we do the other opening before we break? Yes, excellent. All right, thank you.
Okay.
If you take down the board and easel.
Ms. Daniels needs to stand up from time to time. When to let the court.
Sure. So we'll talk about that outside the presence of the jury in greater detail. But Ms. Daniels, if you need to stand up, you should stand up, as long as it's not a big production this time. But let's bring those kinds of things up during breaks.
Thank you.
Okay.
Yeah, anything she wants.
Good morning, ladies and gentlemen. I just want to first acknowledge the significant injuries that Ms. Daniels has suffered and recognize the sympathy that is natural to feel for her as a result of this traumatic accident that my client caused. I know that she's been through a lot, both physically and emotionally, and she deserves my respect, and she has my full respect for what she's been through. While it's natural to feel sympathy for Ms. Daniels and the injuries she sustained as a result of this accident, you have a duty as the triers of fact to listen to the judge's instructions and scrutinize the evidence that will be presented in this case. Because this case is not about sympathy. It's about the facts and the law. And it's my job to help give you the facts you need to decide this case under the law as the judge instructs you. Now, Mr. Johnson stood up here and focused a lot on Ms. Daniels' injuries and her treatment. But what he didn't focus on a lot, and what he didn't talk too much about, are the things that she's still able to do, the many things that she's still able to do that she loves. He mentioned some of the travel, spending time with friends and family, watching her son play at his out-of-state college football games, going to the nail salon, going to the hair salon. These are things that she enjoyed before this accident that she still enjoys today. He also didn't focus too much on the projections for Ms. Daniels' future recovery. That her ankle surgeon, Dr. Kadakia, expects her to be walking in a normal shoe without pain after she recovers from this most recent surgery. That her knee surgeon, Dr. Sadlack, expects her to, upon recovery, be able to sit, stand, and walk without pain and without any loss of range of motion in that right knee. Mr. Johnson didn't tell you that his paid expert, Bruce Seaman, just changed his opinion several weeks before trial. Dr. Seaman's first opinion is based on the assumption that Ms. Daniels never is able to work again in any capacity. His new opinion offers a lost earnings scenario where she goes back to work as early as next September. Now, Dr. Seaman agrees that also that if Ms. Daniels is able to return to her prior job as a property manager after she heals from this most recent and anticipated future surgery, then his estimated lost earnings drop to zero. Dr. Seaman agrees, no one could rule out the possibility that she's able to go back to her prior job. No one's in a position to do that right now. Perhaps most importantly, Dr. Seaman now says that his first scenario, where she doesn't go back to work ever again in any form of employment, is no longer defensible. No longer defensible to assume that she has no remaining earnings capacity based on the evidence. So we have a woman who's still on the road to recovery with a future much brighter than the one that Mr. Johnson just described to you. And that's what the evidence will be, ladies and gentlemen. But Mr. Johnson doesn't want to focus on that. So I'm going to spend the rest of my time talking about the rest of the story, the things Mr. Johnson didn't focus on. Now, as you listen to the evidence in the case, I want you to focus on 3 key points that are going to help you, as the trier of fact, decide the question in this case for you, which is what is fair and reasonable compensation for Ms. Daniels. We'll talk about those 3 points. 3 points that are grounded in the evidence in this case. Ms. Daniels is independent in her, this stands for activities of daily living, bathing, cooking, dressing, brushing her teeth, toileting, and she can still do many of the activities that she enjoyed before this accident. The goal of her recent and future surgeries is to eliminate the pain that she's currently experiencing when she's sitting, standing, and walking. And you heard me say, Dr. Sadlack and Dr. Kadeki will tell you about that. And Ms. Daniels will return to some form of employment in September of 2023. And you just heard that the plaintiff's own expert will testify that the alternative is no longer defensible. She's expected to go back to work. No one disputes that this accident, again, hasn't significantly impacted Ms. Daniels, emotionally and physically. MARTA is not here to dispute that, and you're not going to hear me argue that. That is not why we're here. MARTA is ready and willing to compensate Ms. Daniels, to fairly compensate Ms. Daniels for the injuries that she sustained. And both parties are relying on you to determine what amount of money will do that. We submit that an amount much less than what Mr. Johnson is submitting to you will still reasonably and fairly compensate Ms. Daniels and put her on a path forward to recovery. So that brings me back to these 3 key points, which I want you to remember as you listen to the evidence in this case. Mr. Johnson has the ability to present his case first because, as the judge told you, the plaintiff has the burden of proof. So when you listen to the plaintiff's case, I want you to be thinking about these 3 key points. And I'm going to talk a little bit more about the evidence that supports these 3 points. But let me back up for a second. As I mentioned during voir dire, my name is Brandon Arnold, and I'm here with my legal team, Mariah Page, Jad Dial, and we are proud to represent MARTA. And we have John Monaco here from MARTA, who's also sitting with us at council table. As you heard one year, MARTA doesn't need much of an introduction because it's the principal public transport system here in Metro Atlanta. This case isn't about MARTA. It's about Ms. Daniels and the injuries she sees. And that's what you're here to decide. What is fair and reasonable compensation for Ms. Daniels? Mr. Johnson talked a lot about the injuries that Ms. Daniels has sustained, a lot about her treatment. And he talked a lot about the challenges that she's faced, both physically and emotionally. But MARTA doesn't dispute the injuries that she's sustained. And MARTA doesn't dispute the treatment that she's received. MARTA isn't contesting that she's incurred over $900,000 in medical bills. We know that we owe that to her. MARTA doesn't even contest the future medical treatment. The fact that she had this recent ankle fusion surgery, the fact that she needs a knee surgery. We don't dispute that those are surgeries that are necessary. And those are surgeries that will continue to improve her condition. We hear about her treating, we will hear from her treating physicians about their goals upon her recovery from both of those surgeries. Stand without pain, sit without pain, walk without pain, and wear normal shoes again. Now, according to plaintiff's paid expert Mark Yeager, he believes that Ms. Daniels is incapable of working in any capacity because she's unable to sit for longer than 30 or 40 minutes at a time. That causes pain in her lower extremities. But according to her physicians, who you'll hear from, those surgeries should eliminate the pain that she has while sitting. And even, as you heard, plaintiff's paid expert, Dr. Seaman, agrees that any situation where she doesn't go back to work is no longer defensible. The evidence will show that if all goes as planned with Ms. Daniels' most recent and future surgery, this should enable her to return to work. You'll hear how important her job was to her, how it gave her a sense of purpose and fulfillment, how it enabled her to provide for her family. These are things that are important to her. And even if you believe the plaintiff's expert, she should be able to return to some form of employment after she recovers from these surgeries. So let's talk about future lost earnings, which is one of the categories of damages that she's seeking. Mr. Johnson talked a little bit about that. Dr. Seaman will testify that Ms. Daniels will at least be capable of a sedentary or a seated position, seated job, as of September 2023. And as Mr. Johnson told you, he values that lost earnings scenario about $870,000. But he also agrees that if Ms. Daniels recovers to the point where she's able to go back to her prior job, his estimated lost earnings drop to zero. So you, as the jury, will have to weigh that evidence and decide what you believe is a fair and reasonable number to award for future lost earnings. As for past lost earnings, which is the period of time from the date of the incident up through whenever she starts working again, Dr. Seaman does not consider any scenario where she goes back to work in any capacity over the 2.5 years since this accident. He does not value that scenario at all. And that's because his opinion is based on Mark Yeager, plaintiff's other expert, who performed his evaluation and believes that she's not capable of working at any type of job currently. That she hasn't been able to work at all since this accident in any job, which essentially means she's unemployable. But Mr. Yeager will also tell you that he didn't ask, nor did he consider any of the activities of daily living that Ms. Daniels is engaging in. When he evaluated her, he didn't ask what she's doing on a daily basis. He doesn't know what a typical day in her life is like. His opinions are solely based on the 5 hours he spent with her on that one day in August. Now, her treating physicians will tell you that they would want to know that information if they're giving an opinion about her ability to work. They would want to know what she's doing on a daily basis. They would want to know what activities of daily living she's engaging in. And not one of Ms. Daniels' doctors has approved or even reviewed this functional capacity evaluation or this impairment rating that Mr. Yeager wants to come in here and testify about. You heard Mr. Johnson mention Ms. Friedman, who MARTA hired to perform her own functional capacity evaluation last fall. But plaintiff's expert, Mark Yeager, will tell you that he and Ms. Friedman agreed. They agree that Ms. Daniels has difficulty walking. They agree that she has difficulty standing. They disagree about how long she can sit. And Mr. Yeager opines, as I told you, that she can not sit for longer than 30 or 40 minutes, which prevents her from working in any capacity. Now, at his deposition, Dr. Seaman valued a different scenario where Ms. Daniels does go back to work. He assumes that she is able to go back to work in some capacity over the past 2.5 years. And when he calculated those numbers, his estimation for past loss earnings drops. So it'll be up to you to weigh the evidence to decide are appropriate enough for past loss earnings. Has she been able to go back to work in the 2.5 years since this accident? Or not? And you decide that evidence. You also heard Mr. Johnson talk about household services, or it's something that will be addressed because it's another category of damages. Help around the home. Dr. Seaman's new opinion is that any lost household services terminate as of next year. So as of next year, she no longer will require any assistance. $0. And that drops his total award for lost household services to less than $50,000. It'll be up to you to determine what is a fair amount for that category of damages. So how is Ms. Daniels doing now? And when I say now, we understand she's just had this recent fusion surgery, right? But let's talk about her life prior to that. She's able to independently perform activities of daily living. She's driving. You heard Mr. Johnson talk about that. She's able to bathe herself, brush her teeth, toilet, feed herself, cook. And that's important because she wasn't able to do these things right after the accident. So she has recovered to the point where she can. The evidence will also show that Ms. Daniels is still able to enjoy a lot of the things she loves. Watching her son play football at his out-of-state college football games, going to the hair salon, going to the nail salon, shopping, spending time with family and friends, and traveling. Mr. Johnson talked about some of the trips that she's been able to take since this accident happened. Going to Illinois, going to Minnesota, going to Florida, going to Vegas. Now, while we're talking about Ms. Daniels, I do want to say this. In order to decide this case fairly, you need to hear all the evidence. And if there's information you need as the trier of fact that isn't brought out on direct examination, I have a duty to provide that information to you and to share that with you. Now, on the flip side, because I go second, if I think that you've heard all the evidence that you need to hear from a certain witness, or to decide the case, I'm not going to waste anyone's time putting up additional evidence. Like the judge told you, I may not have to. Now let's talk about money because that's the reason here. What's fair and reasonable for Ms. Daniels. And we don't dispute that she deserves to be compensated for her loss. The evidence will show she should be entitled to her medical bills for the treatment that she has obtained. The evidence will show that she is entitled to this future medical treatment. Now, the plaintiff still has the burden to prove that amount to you before you can award any specific number. But we don't dispute that she needs this future surgery. You heard us talk about lost household services, and the evidence will show that number, according to their own expert, is less than $50,000. That evidence will show that Ms. Daniels should be awarded for at least some past lost wages, whether you decide that she was able to work at all during this time since the accident or not. She's entitled to something. Now, future lost earnings are unknown. And you must decide whether there's enough evidence supported and presented by the plaintiff to support such an award. Will she be able to go back sooner? Sure. Will she be able to go back to a higher paying job than the one that Siemens suggests? All of these things will impact that number, and that's for you to decide. Will she be able to go back to her prior job, which eliminates this category altogether? You will also be able, we asked, and you'll have to determine what amount to award her for pain and suffering. And that's a hard category of damages to measure. Mr. Johnson had a lot of blanks on that form that he thinks you've got to consider when you're determining pain and suffering. But I want you to remember those three things when you're getting that involved. And you need to focus on the evidence in this case when you're giving that involved. We talked about Ms. Daniels' life now and what it may realistically look like in the future. But the evidence is also going to show what a difference that a fair and reasonable amount of money will make in her life. That something much less than numbers that Mr. Johnson's going to talk to you about can still have a real and meaningful impact on Ms. Daniels and her family. I want you to be thinking about that as you listen to that. Because any award for damages, including pain and suffering, must be reasonably tied to the evidence in the case. And at the end of the evidence, I'll come back up here and I will tell you what we respectfully believe that number to be. So folks, I've just walked through what we believe the evidence will be in this case. So remember, I told you to keep these 3 points in mind because these are the 3 points you need to know to decide this case. And Mr. Johnson, as I told you, gets to put up his evidence first. And I want you to be thinking about these points as you listen to his case. Because you're here to decide one thing, and that's what fair and reasonable compensation will be for Ms. Daniels. And with that, I thank you for your time. And I'm honored to present this case on behalf of MARTA to you.
Thank you, Ms. Arnold. So ladies and gentlemen, we can start with the plaintiff's first witness, or we can give you a short break before we do that. Does anyone need a break? Yes, thank you. I forgot. We said Ms. Brown was going to get a break. A very important participant here. So we will take a little less than 10-minute break, assuming Deputy Gordon can corral you all. Remember, don't talk about the case. You actually haven't heard any evidence yet. It was just opening statements. Jury room, back hallway, all yours. We'll try to get you back in here around 11:15-ish once Ms. Brown gives me the next thumbs up that she's had a break. Thank you so much. All right, we'll be on a 5-6 minute break. I got a couple things I need to get on the record after that, but I want to give Ms. Brown a break. So I'll see you guys soon.
People watching, yeah.
Ms. Arnold, do you all have exhibits that you'll be using during the plaintiff's case? Or you'll just be relying on what Mr. Johnson gave me?
No, Your Honor, we're gonna be relying on what he gave. That should cover what I need for this.
Okay.
Good job.
Thanks.
Yeah.
We don't agree with it.
Yeah. Yeah, they're not. I'm very glad.
Well, I knew it. Like, oh, you know what? People can hear us actually when we talk. Did you know that? The YouTube people can hear us. Just so y'all know this broadcast on YouTube, and I'm pretty sure they can hear you when you talk before them. I'm never say it all the time.
Yes.
I think it's the court reporter. Yes. Oh, I tried, and it was garage open this side. And I heard, yes, I heard her, but I was like, oh, Lord, it's been a lot of years. And I heard. Yeah. No, we were coming home. Not for.
Hello, hello. And if it's red, it's just muted.
It's on right now, so.
We don't need it on. Yeah.
What is? Yeah. How about now? And do you see this microphone where anybody on YouTube can hear it?
I didn't even know the feature until. I'm like, oh, this is awesome. Surely. Oh, wait.
What? People are hot in here? Okay, you've already asked maintenance, or we should ask Monica? Okay, how hot is it in here?
72.7 according to that.
Okay. Yeah, I think we're good. Who, the jurors were saying that? Oh, all right, we'll get stuff on the record, but they just adjusted all that stuff. All right, Ms. Brown, you ready? Okay, we're gonna get back on the record in Daniels v. MARTA. Mr. Johnson, tell me what you think Ms. Daniels' needs are going to be during trial so we can sort them out now. We'll accommodate everything, but we should talk about it in this setting instead of in front of the jurors.
Sure. She's going to, and I told her that it's okay, that she has to stand up from time to time. She has to adjust her ankle from time to time. She has to appear to be slouching from time to time so she can rest her ankle up on the thing under the desk. I've told her as she needs to just do that stuff unless you instruct her.
Okay, Ms. Daniels, when you stand up, how long do you need to stay standing?
It's not necessarily needing to stand up. I go outside to the bench to put my leg up to give some kind of elevation to relieve some of the weight that has been.
Okay. So the standing up was simply, you may need to leave the courtroom from time to time. That's fine. You should do that whenever you need to. I was worried, the way I understood what Mr. Johnson was saying is that in the middle of trial, you might just stand right there at the table. That would be more problematic if we need to deal with it. I could talk to the jury, but there are issues of who could see what and jurors suddenly wondering, why is this woman standing up? But if it's standing to then leave the courtroom, that applies to everyone here. As long as there is one lawyer at each table, people can come and go in a non-disruptive way throughout the trial.
I didn't understand what her physical situation was, so we're learning together. Would it be possible for you to alert the jury so that they don't think that Ms. Daniels is being rude when she gets up and leaves the courtroom for periods of time?
I will. I'm not going to single her out. I'm going to let them know that people from both tables may need to come and go for different reasons throughout the trial, and folks shouldn't draw any conclusions about that. And then this can be dealt with later, but you said something in your opening, Mr. Johnson, about Ms. Poole, who is not an expert, but is the former employer or colleague of Ms. Daniels, offering an opinion about Ms. Daniels' ability to perform a job.
Yes.
And I guess you'll lay the right foundation for Ms. Poole to be able to offer what would be a lay opinion.
Right.
Okay.
By virtue of her experience, her prior job experience.
Okay.
Yes.
Great. That's all I've got. Mr. Johnson, do you have anything else we need to talk about before we bring the jurors in and you call your first witness?
I don't believe so.
You have witnesses that'll get us through, we'll probably break for lunch around 12:30-ish.
Yes.
Okay,
I don't know how long this one goes, but we have one here after that.
great.
So,
Okay, so if we want to go for an hour, you can fill it. You may not finish with the second witness, but we're not going to have to stop early because you don't have a second witness
I
here.
do not believe so.
Okay, and then same with the afternoon.
Right.
Okay.
Timing is a tough thing, Judge. We've got at least we got 4 more witnesses from right now that could be available to testify.
Great. Okay. And in general, I'll let you call witnesses in the order you want. If we reach a point where the witness you'd like to go next isn't here and someone else is, I will say you need to bring someone in and you'll figure out who that someone is. All right, Ms. Arnold, anything from the defense side that we need to talk about before the jurors come in?
They are.
Great. Then I'll talk to the jurors about people coming and going, and we'll be ready to go. Let's bring them in, please.
All right, so jurors.
Thank you, Deputy Gordon. Everyone can be seated. Welcome back, ladies and gentlemen. 2 process points before Mr. Johnson calls plaintiff's first witness. Number 1, there are no assigned seats, and so I encourage you all to sit differently each time, literally, because you will see things a little bit differently. You're going to have a great view of the side of some witnesses' heads because witnesses may be looking that way. They may turn to the jury, and so you are going to want to rotate. The one exception is, as we talked about in some of the panels, you may not have been on one of them on Friday. Every once in a while, we have a juror who needs to stand up because of a hip or a back or a knee, and we reserve the 2 seats at the end there because you can stand up, lean against that wall, and we don't need to stop what's going on. But if we don't have anyone like that in the jury, mix it up. Don't sit in the back row every time. Don't sit in the front row every time, unless you guys agree, hey, we're going to have assigned seats. I don't assign them and ask that you not do that. Number 2, throughout the trial, folks may be getting up to go get a piece of evidence or take a break in a way that need not disturb us. So if you have anyone from any of the counsel tables that steps away, don't worry about that. As long as there is a lawyer from each side here in court, we can keep on moving, which is my goal, to get this case moving at a healthy clip for you all. So I've asked the lawyers and their clients to feel free to step outside if they need to and just do that in a real quiet way. And they are going to do that. So with those comments made, Mr. Johnson, if you would call your first witness, please.
Judge, thank you. We call Heather Poole. I believe she's in the hallway. Would you like me to retrieve her, or do you have the court deputy do that?
So Deputy Gordon can check out there. In general, if you could get someone from your team sort of standing in the doorway and you say the name and then that person gets the person you need. But Deputy Gordon will do the honors this time.
Please swear or affirm that the testimony you will give is true, the whole truth, and nothing but the truth. State this very name for the record.
Heather Poole, HeatherPoole.
Give me 1 second, Mr. Johnson. I'm going to this. There we go. When you're ready.
Thank you, Judge. Ms. Poole, before we begin, let me just tell you what I'm telling all of the witnesses, which is that some of us hear better than others. And so if you could maybe speak in a voice that's just slightly louder than feels normal to you,
Okay.
I think it might help everybody hear what you have to say a little bit better. Okay. With that, let me ask you this. Tell us again your name.
Heather Poole.
And Ms. Poole, what is it that you do for a living?
I'm a regional manager for HSI Management.
And tell us what that means.
I oversee a group of multifamily apartment complexes.
How long have you been with HSI?
13 years.
And were you working back for HSI as far back as 2013?
Yes.
Have you ever met Jame Daniels?
Yes.
And where were you working back in 2013, by the way?
I was working at Vineyards of Browns Mill.
And that's the name of the apartment complex?
Correct.
When did you first meet Ms. Daniels?
I met Jame Daniels back in 2000. I can't remember the exact year that I met Jame. But I met Jame at Vineyards of Browns Mill when I took over the property, and Jame was a leasing agent.
And what is a leasing agent? Can you help the jury understand what Ms. Daniels' job would have been back then when you first got to know her?
Yes, so a leasing agent at an apartment community is responsible for leasing vacant units, walking the property, walking vacant units to make sure that they're rent ready for a new tenant to live in, walking the community, doing market surveys, doing a variety of marketing and walking up the property.
So when Ms. Daniels was the leasing agent, when you first met her, what was your job at that time?
I was the property manager.
Do you recall any initial impressions of Ms. Daniels when you first got to know her when she was a leasing agent?
Yes, she was a hard worker, dedicated employee, reliable employee.
Did she remain a leasing agent while you all were working at the Vineyards at Browns Mill, or did she ever change jobs?
She was promoted from the leasing agent to an assistant manager.
And who promoted her?
I did.
Why did you decide to promote Ms. Daniels from leasing agent to assistant property manager?
Well, I saw the dedication that she showed in her job. She wanted to advance her career in the industry. She didn't want to just stay a leasing agent. And our company likes to promote within.
Do you have an opinion about how Ms. Daniels fared as an assistant manager while you were property manager? How did she do?
She did a great job.
What's the hardest part about being an assistant property manager at the apartment complex that we're talking about here, Vineyards at Browns Mill?
Probably the hardest job in that industry is dealing with customer complaints. But there's, a large physical piece to that job, as well as an administrative part to it. There's collecting rent, there's posting rent, there's dealing with angry residents, there's
How was Ms. If I may, how was Ms. Daniels, as you viewed her, with dealing with angry tenants?
She handled it very well.
Did she remain assistant property manager, or did she change jobs again after that?
She was once again promoted. I was promoted from the on-site property manager to a regional manager, which took me off-site. And so Jame was then promoted to the property manager.
And was that the job Ms. Daniels was holding as of March 2nd, 2020, when she was hit by the MARTA bus?
Yes.
Let me ask you the same question I asked you about the promotion to assistant property manager. Why did you choose Ms. Daniels to be the property manager of the vineyards at Browns Mill?
Well, we knew what we had. We knew that we had a dedicated employee. We knew we had a trustworthy employee. Again, you know, promoting within. Jame knew the property best. She had a good relationship with the residents. The residents liked her. And she was the best fit for the property.
Now, before I ask you about her job duties as property manager, I want you to help the jury understand the nature of this property, okay?
Okay.
Tell us about the property. How big is it? What kind of buildings, that sort of thing?
Vineyards of Browns Mill is, it's a fairly large property, approximately 20 acres. It's got 10 buildings. Some buildings are 3 stories tall, some buildings are 4 stories. All stories are accessed by stairs. There's no elevators on this property. So they're basically like external breezeways. It's multifamily. There's a community pool. There's a gazebo with barbecue. There's playground. It's mild terrain. I mean, it's not like super hilly. It's not exactly flat, but it's a large property, about 20 acres.
Okay. I want you to now help us understand the daily routine, the weekly routine, yearly routine of what it means to be a property manager at the Vineyards at Browns Mill with 210 units, 10 buildings, 3-story, 4-story, no elevators. Tell us what a property manager does on an average day. Let's start there.
Well, on an average day, usually starts with walking the property to make sure that, you know, there's no safety hazards, there's no excess trash on the property. We always kind of tell our managers that their property is like their own little town and they're the mayor. And so they're responsible for everything that happens, you know, on that property and within their little city limits. So they want to make sure on a daily basis that they're doing kind of a general walkthrough, like I said, just to make sure there's no safety concerns, anything that would be a liability for an owner, for the management company, or certainly for a resident. After walking the property, then they would go to the office, you know, do admin work. There is, you know, a desk job component to being a property manager. You know, it could be posting rent, it could be delegating the staff's duties for that day. You know, she may have to go out and do market surveys at another property. She may be going to the bank to make bank deposits. So no 2 days are alike in the business at all.
Besides walking the property daily, are there other occasions, more formalized occasions, that a property manager has to walk the property and walk the units?
Yes. On a routine, they are to do quarterly unit inspections, and that's to ensure that the units, that there's no housekeeping issues, that the tenants aren't tearing up the apartments, that there aren't any unauthorized occupants or unauthorized pets, making sure that they are abiding by the lease. And that's done on a quarterly basis, and that's every unit has to be walked quarterly. And that is a team effort. That is not just the property manager. So that is the property manager, the leasing agent, the assistant manager, and they basically kind of dissect up the property. Then twice a month, they do zone inspections, which does not involve the units. That is the exterior of the property, where they do, I mean, it's a 360-degree walk. They kind of dissect the property up, the manager does, and each person is given a zone, and they walk, each floor of that building that's within that zone, and look at every floor in that breezeway, all the way around the building. And basically what it is just to make any kind of notations if there's any kind of deferred maintenance or anything, and then work orders are generated or vendors are called to take care of any kind of problems.
How much stair climbing is involved in this job? I think you mentioned, how many buildings? 10?
Correct.
So on a daily basis, as a property manager, how much stair climbing is involved here?
It can vary. Like I said, there's just no 2 days that are the same. There could be emergencies that take place, where one day could require more, but, on an average, a minimum of probably, I would say, 2 to 3 breezeways a day at a minimum. And those breezeways at vineyards, I'm going to say are probably at least between each level are at least 20 steps. So it's quite a bit of, that's, probably 60 steps at a minimum. It's quite a bit. They're large breezeways.
Does the property manager have to conduct inspections of individual units in the property?
Yes.
And how does that work?
When a unit is vacated, move out inspections have to be done. That's to us, and that is to assess any charges if necessary, or if a deposit is refunded when somebody moves out. And that is the property manager's, she makes that determination. When a unit is vacant and ready to be leased, she'll do the final inspection. Leasing agents and assistant managers kind of monitor it as either the maintenance or the vendors are getting it ready during the pre-lease, and the manager does the final inspection before kind of like the final sign off per se, before a tenant is allowed to move in. So, there are some months where there's more turnover than others. So like I said, there's just no 2 days are alike, but there's a lot of walking in the job. It's a lot of walking.
So we've been talking about the physical aspect of the job, but let's talk for a minute about administrative.
Yes.
Is typing involved in this job?
Yes.
What do you type? How often do you work on a keyboard in this job, and what's that about?
You're entering, there's a lot of data input, which is, there's a lot of reporting that is done. There's rent that is entered into a system. There is work orders that are entered. There's the completion of those work orders. There's bank deposits that are entered. There are marketing reports. There's this particular property, Vineyards, is what's called an LIHTC, which is a low income housing tax credit property. So there is a kind of a government layer on there. So because we're dealing with the government, there tends to be quite a bit of paperwork. There's a lot of government reporting that has to take place. So a lot of compliance reports. So there's quite a bit of data entry.
Given that, would you describe the property manager job as a desk job?
No, it's not a desk job. But there is a heavy admin component to it that requires data entry, but it's probably, I would say, a 50-50 split.
Okay.
On the physical and the admin side.
While you were Ms. Daniels' boss, while she was property manager that period of time, did HSI ever ask Ms. Daniels to perform any special tasks or assignments for the company?
Yes, we had Jamise do one special task for us. And that was go to one of our properties that was a troubled property that was in Tallahassee, Florida. And it was troubled. We took over management and it was troubled because it had a lot of vacant units and we needed a strong interim property manager until we could get the position filled. And Jamise was one of our strongest managers. And she had stabilized vineyards to a point where we could pull her off of vineyards and send her down to Tallahassee.
When she returned from that special assignment, did she return to her old property manager job?
Yes, she did.
As her direct boss, did you ever observe or hear about Ms. Daniels having any problems with any of the physical aspects of the property manager job before this crash?
No.
What was her attendance like? Do you even know? Do you remember?
Other than taking her earned time off, there was never a problem.
As her boss, were you aware of any future plans that HIS management may have had for Ms. Daniels?
It was always discussed that, we wanted to grow Jamise, and it was our hope to have Jamise be at some point, a regional manager with HSI down the road.
I want to take you now to the date of the collision, March 2nd, 2020. When did you first see Ms. Daniels after she was hit by that MARTA bus? Do you recall?
I believe it was 2 days after the accident because I was out of town the day the accident happened.
And where was she when you saw her?
At Grady.
Can you paint a picture for us? What it was like? Do you recall?
It wasn't the Jamise that I remembered.
How often were you able to visit her in the hospital?
I saw Jamise, I believe I saw her 2 or 3 times.
Now, I want to skip ahead in time to a point when Ms. Daniels returns from Texas, where she was living with her father for rehab, and she moved back to Atlanta, and I believe into one of the units in your apartment complex. Do you
Correct.
recall that? Is that when you picked back up your observation of her again?
Yes.
Because you didn't see her when she was in Texas.
That's correct.
Have you seen her fairly regularly since then?
I guess regularly is a bit subjective. I've seen Jamise maybe 3 or 4 times, since she's been living back at Vineyards, and I see her when I'm there at the property, you know, doing my visits, because I'm still over, you know, over that property.
And tell the jury in these more recent times that you've seen her, what have you seen of her physically? What, and by that, I mean, what have you noticed, if anything, about her physical nature?
The walking is not the same, you know, with the assistance that she needs with, the last time I saw her was with a cane. Jame's had a cane, and slower walking, and just very labored. Her hand, I guess I'd describe it as looked arthritic, you know, just kind of didn't look normal. Like I remembered, you know, Jame to be.
How long were you the property manager, not regional manager, but property manager of this property?
I was at Vineyards for, I kind of forget my recall a little bit, but I believe it was for about 10 months.
Based on your experience as a property manager in general and as a property manager at this particular apartment complex, do you have an opinion based on your observation of Ms. Daniels as to whether she would be physically capable of resuming that job?
Objection calls for speculation
It does not.
and lack of foundation as well.
I believe I just laid a 10-month foundation, Judge.
When you say physically capable, what are you asking this witness to answer?
I'm asking based on the physical capabilities as she observed them. Based on her observation and her experience, does she believe that Jame Daniels is physically qualified to do the property manager job? That's what I'm asking.
Not a medical opinion, but based on
Based on her experience.
of doing the job and supervising the job and seeing.
Yes.
Okay, does it appear to Ms. Poole that Ms. Daniels could do the things she used to do?
And would they be enough to fulfill the property manager role?
Okay, I'll overrule the objection when it's framed that way.
Let us know.
She would not be able to meet our qualifications to do the job from a physical standpoint, because she would not be able to walk the breezeways. And I don't know about the administrative end of it, but she would physically, she would not be able to do the job.
And Ms. Poole, you're basing that not because you've talked with doctors and physical therapists, but just your observations of, or your interactions with Ms. Daniels.
That is correct.
Okay.
If Ms. Daniels was suddenly completely back, completely uninjured, completely her old self tomorrow, would her property manager job be available to her?
No.
Would a leasing agent job be available to her?
No.
How about assistant property manager?
No.
Have you spoken with anyone from MARTA about your observations?
Yes.
And what did you tell them?
I don't recall exactly what they asked, but I believe that they asked.
No, I'm not asking what they asked.
Okay.
I'm just asking what you told them.
That Ms. Daniels is not able to work.
You say not able to work, meaning
Not
to,
able to work in the capacity that she was.
okay, in the job you're familiar with.
Correct.
Thank you.
Ms. Page?
It's almost afternoon, so good afternoon, Ms. Poole.
Good afternoon.
And you currently work as a regional manager for HSI, correct?
Yes.
Okay, are there more or less physical requirements as a regional manager?
It's 50-50.
Okay, and in your role as regional manager, you work closely with the property managers, correct?
Yes.
And each property has a property manager as well as leasing agents?
Each property at a minimum has a property manager.
Okay.
It depends on how many units how they're staffed.
Okay, and you're responsible for hiring property managers?
Correct.
And currently you oversee about 5 different properties at any given time?
Yes.
And you're also responsible for completing evaluations for property managers?
Yes.
Okay, and we talked a little bit about this earlier, but you previously helped oversee Ms. Jame Daniels at the Vineyards at Browns Mill, correct?
Yes.
Are there any golf carts available for tours of the property or for walkthroughs?
Yes.
Okay, and when you first became acquainted with Ms. Daniels, she was working as a leasing agent.
Yes.
And then you promoted her to assistant manager.
Yes.
And then you promoted her to property manager.
Yes.
And as you stated on direct, Ms. Daniels was an excellent employee.
I'm sorry.
I said, as you stated on direct, Ms. Daniels was an excellent employee.
Yes.
And she was very dependable
Yes.
and trustworthy.
Yes.
And we can both agree that the property manager position has some physical demands as well as administrative tasks, correct?
Yes.
And the non-physical duties include collecting rent,
Yes.
interacting with residents,
Yes.
communicating with vendors via telephone and email regarding contract work,
Yes.
paying bills for the property,
Yes.
completing reports to submit to the regional level,
Yes.
okay, and meeting with different staff for the property level, correct?
Yes.
And some of the physical duties include the quarterly unit inspections,
Yes.
which occur every 3 months,
Yes.
and then also the walkthroughs of the property that we discussed earlier.
You want to be more specific about those?
No, just yes or no.
Yes.
Okay, and are golf carts available for staff whenever they're doing the walkthroughs of the property?
No, they do the walks. They don't ride golf carts.
Okay, and we talked a little bit about the physical demands of the job, but you're not qualified as a functional capacity expert, are you?
No.
Okay, and you're not a vocational rehab expert,
No.
and you're not qualified to make a determination about whether someone is functionally capable of working a particular job, correct?
If they're, yes, I am in my position, in their position, yes. If they're going to be working for me, then yes, I can make that
Do
decision.
you have any professional certifications that enable you to evaluate someone to determine whether or not they can physically complete a job?
No.
Okay, and you're not a medical doctor either, are you?
No.
Okay, so you would defer any opinions related to Ms. Daniels' recovery from her recent surgeries and upcoming surgeries to her physicians, correct?
Yes.
And because Jame was such an excellent employee, you'd be willing to rehire her provided she can physically do the job as a description requires.
Provided there was a job available.
Okay, thank you. No further questions.
Mr. Johnson, any redirect of Ms. Poole?
No, thank you, Judge.
Okay. Jurors, any questions for Ms. Poole? Seeing none, Ms. Poole, thank you so much for being here.
Thank you.
You are free to go. Next witness,
We're retrieving him now.
and he is,
Mr. Mark Yeager.
all right.
It's 12 o'clock, Judge, and this is going to be a longer witness. This is the functional capacity evaluation expert for my side of the case. I just wanted to alert the court that it's noon and we're going to be starting a long witness.
Great. I know what time it is, and we will not get through Mr. Yeager before we break for lunch, but we fairly recently had our morning break. So we'll go a little bit longer. And when we reach sort of a natural transition in his testimony, then we will break for lunch. Thank you.
Yep.
My name is Mark Allen Yeager, MARCALANYEAGER.
Good afternoon, Mr. Yeager. Thanks for removing the mask. I was going to ask you if you were comfortable with that. It'll be a lot easier to hear you if we handle things that way.
Yes.
Thank you.
So, Mr. Yeager, we'll start again, and I'll ask you to tell the jury who you are.
My name is Mark Yeager.
And tell the jury what your profession is and what kind of work you do.
I am a licensed physical therapist, and do you want me to explain my current practice or?
Yes, just tell them what you do right now, and then we'll talk about your education and all that after.
Okay. So my current practice is such that I perform what's called functional capacity evaluations, which we'll be talking about. I perform a similar functional test, which is called pre-employment work screens, where employers who are hiring individuals for a particular job, I'm performing a job-specific test where they might have to do lifting, carrying, but those activities are specific to that job. I perform ergonomic analysis and what's called functional job analysis, where I go on site and I work with employers to analyze the physical aspects and demands of a job, how much job the workers that do that job, how much they have to lift, carry, stand, walk, the physical aspects of that. I do other types of consulting work related to injury investigation, as far as what potential ergonomic risk factors might have contributed to maybe somebody's injuries. But that's for the most part my practice now.
Mr. Yeager, is conducting functional capacity examinations and evaluations something that requires specific skills, education, and experience beyond what the public at large would typically have?
Yes.
Can you give us the benefit of your educational background and work experience in this area?
Certainly. So functional capacity evaluation, because the in-depth requirements of that are such that, require a full knowledge of the human anatomy, what muscles, bones, joints, nerves, what are all part of human function in a normal sense. So that allows you then, when individuals are injured or they have some kind of a disease process, we are then as a profession able to help as much as possible that individual regain those capabilities. So in terms of functional capacity evaluation, that understanding of what is normal human movement functions of the various aspects of our body, that's important to know when we go into performing functional capacity evaluations. And that is certainly within the scope of my practice.
And you do some teaching as well?
I do, yes.
What kind of teaching do you do?
I teach 4 in-person courses for other physical therapists and occupational therapists here in the US and in Canada. The totals 32 or 36 hours of in-person teaching. 16 hours of that is on functional capacity evaluations. 8 hours is teaching these clinicians how to perform functional job analyses. 6 hours is related to performing what I mentioned a moment ago, those post-offer employment tests. And then 8 hours is on work rehabilitation. And then I also teach 11 online courses. That is roughly in total about 30 hours, 90-minute up to 4-hour courses that are taught online.
Mr. Yeager, have you ever been qualified as an expert in conducting and analyzing functional capacity evaluations in a Georgia court?
Yes.
How many times?
I've testified in the last 4 years on functional capacity evaluations twice.
Judge, based on Mr. Yeager's background and experience, I tender him as an expert in the field of functional capacity examinations and evaluations and move that he be allowed to testify about his testing and conclusions in this field.
Any examination of Mr. Yeager at this time?
No, Your Honor.
Okay. Any objection to having Mr. Yeager qualified as an expert in that field?
No, Your Honor.
Okay, Mr. Yeager, for purposes of this trial, you are qualified as an expert in the field of functional capacity analysis, and you will be able to offer opinions based on the findings that you've done.
What were you hired to do in this case? What was the job given to you?
Okay, I was requested to perform the functional capacity evaluation in addition to an impairment rating evaluation.
What about a functional capacity evaluation, or is that the same thing?
Yes, yeah. So I was asked to perform a functional capacity evaluation with Ms. Daniels.
And who hired you to do that?
You did.
And who's been paying you for your work?
You or your office.
And you're charging a fee for being here today to testify in front of this jury, is that right?
That is correct.
And I prepared with you so that you could present your testimony in a logical manner before you got on stand, is that correct?
That's correct.
And did you charge me for that?
I did.
Did you charge me any money for any particular result? Or were you simply charging for your time regardless of your opinions?
I charged for the objective evaluation that I performed.
Did you, in fact, conduct a functional capacity examination of Jame Daniels?
I did.
All right. Help us understand exactly what a functional capacity evaluation is in this context. What does that mean?
Sure. Functional capacity evaluation is a standardized evaluation to see in someone's current condition, whether it's related to injury or some type of medical condition, a disease, what their capabilities and their limitations are for doing work-related activities, lifting, carrying, reaching, squatting, bending, gripping, pinching, hand coordination activities, to see not only what they can do and to what capacity, but given the context of their physical or medical conditions, where are their limitations? How do those limitations affect their capacity to do these activities, maybe to a greater extent? So in kind of layman's terms, that's what the functional capacity evaluation is. It is a clinician, or it should be when done properly, it's a clinician-driven evaluation, as opposed to a client-driven or a computer-driven process. So as a physical therapist and staying within my scope of practice, I'm able to direct and perform the evaluation to where I am getting an objective measurement of what their capabilities are. It's important, though, through this evaluation that I maintain my client's autonomy. And I explained at the beginning of the evaluation, they have the ability to stop any activity at any point because I can't make them do anything. However, it's important for me through the evaluation to make sure that based off of the medical record review that I've done, the physical examination that I've performed with them, is that evidence that I've collected consistent with their performance. If there's discrepancies, then I, as a clinician, need to address that because my goal is to reach a safe maximum level of effort or performance with that client.
In connection with this functional capacity evaluation, did you prepare a report of your findings and conclusions?
Yes, I did.
And do you have it with you?
Yes.
Would it help you to use that report in answering detailed questions about your findings?
Possibly, yes.
All right, well, let's begin with this. Before you can give us conclusions, if any, tell us how you did the evaluation, just mechanically.
Sure.
What happened when was it, first of all?
Okay, so I saw Ms. Daniels in person on August 6th of 2021. From the time that I received this referral to the time that I saw Ms. Daniels, I was provided her medical records. So my practice is to review those records in advance of the client showing up to my office. And that's for two reasons. One, as I reviewed through the medical records, I want to make sure there's not what's called contraindications, something that may be actually unsafe for that individual to actually go through this evaluation. So I want to make sure that for my client's safety, if there might be what's called contraindications, that I address that before they arrive. But that's not very common. But the main reason for reviewing the medical records is so I understand what are the injuries, what are the conditions that I should then be prepared to evaluate when the client eventually arrives to my office. So I do that evaluation of the medical records in advance. I sent Miss Daniels a confirmation letter that explains how to dress, about taking medications, and information that that she would need to know before she shows up to my office. So that way, then I can get the best evaluation or perform it in as most a comprehensive way. In that confirmation letter, I provide a client questionnaire, which she returned completed, and that gives her an opportunity to write down her doctors, her medications, past medical issues, a description of her symptoms. And I use that in my initial interview of Ms. Daniels to go through so I can again get as a comprehensive and thorough history before we actually get into the evaluation activities. So those are all the activities that led up to the point that I saw Ms. Daniels on August the 6th.
Now tell us physically what you did and had Ms. Daniels do.
All right. So when Ms. Daniels arrives, and she was with me face to face for 5 hours and 2 minutes. So I am my only employee. So the person that I'm evaluating, unless if there's a bathroom break, they are in my presence the entire time. And throughout that evaluation, I'm observing how they move, how they posture throughout. But when Ms. Daniels arrives, I get her situated in an ergonomic task chair, an office chair that's at a table in front of me. I adjust it so that the height of it, the armrest, the backrest are all situated for her body. And that's important because I'm at that point evaluating her sitting tolerance. I don't announce that to her, but as I'm going through her client history, I'm observing how is she sitting, how is she posturing, and I want her to be seated in that chair as comfortably as possible, and then see how well she tolerates that. So I go through her history. While seated, I then proceed to evaluate her hand grip, her finger pinch, and her hand coordination activities. After that, I proceed and go into my physical examination, where I measure neck range of motion, trunk range of motion, all the joints in the arms, all the joints in the leg, how flexible, how many degrees of movement do those joints move. I check the strength of her neck, her back, her arms, her legs. I do some other testing in terms of measuring for atrophy around her right thigh and her right calf. I measure both sides, but I'm looking to see if there's any presence of atrophy that has affected that right thigh and that right calf, given the injuries that she had. I check her balance. I check sensation with both her right and left arms and also her right lower leg. And that's part of my physical examination, which is all completed before I then proceed with completing the rest of the functional capacity evaluation activities.
After you completed all of the functional capacity evaluation activities, did you form any conclusions about her functional capacity? And I'm referring here, by the way, to page 2 of your report under the executive summary section.
Can you say your question again?
Sure. What conclusions did you reach based on her functional capacity examination about her functional capacity in general?
All right.
What limitations did you notice?
Sure. Okay. So, so out of my evaluation, I concluded that her functional capabilities for doing the lifts and the carries and all those activities that I mentioned, that her functional capabilities were limited by the injuries that she had sustained to her right forearm and wrist, her left forearm, and her right lower leg. And those capabilities did not meet what is considered the full range of what's considered sedentary work physical demand level. And that was because of a loss of range of motion in her right wrist in all the directions that the right wrist normally moves. Loss or a decreased of range of motion in the right forearm. Both her right hand and left-handed grip strengths were below what a woman her age should be expected to have. Also, her right-handed pinch was also below what would a woman her age would normally have. I determined that decreased strength in her right arm and her left arm limited her capabilities, as well as endurance affecting both arms. I determined that her right ankle range of motion. So if you think of like pressing on the gas pedal and taking your foot off the gas pedal, rotating your ankle in and out. So loss of motion in those planes of motion affected her capabilities. Decreased weight bearing tolerance on that right leg affected her capabilities. Decreased strength or decreased endurance, with her back and her left leg, because she's had to compensate so much for her right leg, was also affecting her capabilities. And then just a general increase of irritability in the symptoms of those areas that were injured also had an impact on her functionality.
You mentioned job classifications a minute ago. Can you explain to the jury whose job classifications these are and generally what the different ones are?
Sure.
So that they'll know what you mean.
Okay. In the medical field, when we're talking about functional capabilities, the U.S. Department of Labor has defined 5 different physical demand levels or physical work categories. And the terms for those categories, the first one is sedentary. The second one is light. Third is medium. Fourth is heavy. And fifth is very heavy. And there's 2 reasons or 2 practical uses for those categories. One practical use is if you take a job and you analyze that job and all the various physical aspects of that job. If you're sitting all day, or if your job is more physical and you're lifting a certain amount of weight, those physical aspects of the job will put your job or that job into one of those 5 categories. All right. So if you think of all the jobs that are in the US economy, there's a lot of jobs there. So there's going to be some aspects that will fit into a category and some that won't. So from the perspective of what I did with Ms. Daniels is I took her FCE results and then compared that to the criteria of those 5 categories and which of those categories do her capabilities fall into. And
so I had a question about that. And
yes.
So you testified earlier that they didn't meet any of those 5. Is that right?
Well,
completely.
Completely, yes. And I do go into detail as far as how her capabilities fall within that sedentary range, but don't fully meet that sedentary definition.
If you'll just explain that to the jury, please.
Yeah. So the exact definition for sedentary work is that it is defined as exerting up to 10 pounds of force occasionally, which is a third of an 8-hour workday, and or negligible amount of force frequently, which is 2/3 of an 8-hour workday, or about 5 hours and 20 minutes, to lift, carry, push, pull, or otherwise move objects, including the human body. Sedentary work involves sitting most of the time, but may involve walking or standing for brief periods of time. Jobs are sedentary if walking and standing are required only occasionally and all other sedentary criteria are met. So these definitions are fairly broad because, again, there's a lot of jobs that might, if a job involves lifting a feather, that job would fall into that sedentary category. But sedentary also means handling 10 pounds up to a third of the day or 2 hours and 40 minutes. So these definitions have to be broad. And the reason why I concluded that Ms. Daniels did not meet that sedentary requirement is because I found that one, she was not able to squat safely to lift items from below 24 inches because of her right ankle injury. And there were some other areas too that kept her from fully meeting that full definition.
So I want to ask you about a few of the details in your report. And I want to talk about sitting issues involving sitting down. I saw a discussion of that on page 3 of your report, and I had a question about it. What does sitting down mean in this context? Is it sitting on anything, anywhere, or is it sitting in a certain position? What do we mean when we say that a person can only sit for a certain amount of time?
Sure. So in this context, with any of these activities, we should be talking in the context of doing these activities in a work environment. So sitting in a work setting should be ergonomic, sitting upright, sitting with an ideal posture. Now, in many work environments, that's not always possible, but that's the perspective that we want to start from. How is this individual able to sit in a appropriate posture? And then are there any kind of physical limitations that prevent that from happening? So going back to that definition for sedentary work, that definition, it's not very specific, but it just says sedentary work involves sitting most of the time. So I kind of define that as at least 51% of the day. And I concluded that Ms. Daniels was able to sit for a frequency, which is up to 66% of the day. The only qualification that I made with regard to her ability to sit was that because her right ankle cannot get to what's called 0, but it's actually kind of a 90-degree position, because she's a little bit more in a what's called dorsiflex position, toes pointing down, she can't get that foot flat on the floor. So ideally, and I've performed a couple thousand office ergonomic evaluations where I'm getting people situated properly in their office chair, their desk chair. And so when I'm trying to get somebody, ideally, I want 90 degrees roughly at the hip, 90 degrees at the knees, feet flat on the floor. That's going to be their most comfortable, ideal position. And because of her ankle limitation, she's not going to be able to do that.
Did your FCE, functional capacity evaluation, include any analysis of sitting in a car? Was that part of your testing?
No.
How about an airline seat, flying occasionally on an airplane? Was that something you tested for?
No.
And I want to ask you about the right wrist now. Can you tell us what limitations you noticed in Ms. Daniels' right wrist and how that affected your analysis?
All right. So Miss Daniels' right wrist motion, normal wrist motion has 4 degrees or 4 directions. So flexion, extension, ulnar deviation, and radial deviation. All right, so those 4 directions. And because consistent with the surgery that she had, her wrist was in 10 degrees of a flexed position, minus 10 degrees in extension. So in the motion of flexion and extension, she's stuck in that 10 degrees of a flexed position. In terms of ulnar deviation and radial deviation, she was 10 degrees in ulnar deviation, minus 10 in radial, which means she's stuck in that 10 degrees of ulnar deviation. So she was flexed 10 degrees and ulnarly deviated 10 degrees. And that was all the motion that she had in her wrist.
I'm going to talk about mobility, walking issues. Did your report conclude anything about the way she walked, Ms. Daniels?
Yes, she walked with an abnormal gait pattern, which I characterized as being antalgic. And that term antalgic means kind of like a painful presentation.
Can you spell that?
Antalgic? ANTALGIC. And think of stepping on a sticker or walking barefoot through the grass. You're going to limp on it so you can sit down and pick it off. So that's an intelligent gait where you're not able to put full weight bearing, and there's effect from that. So there was an intelligent quality, but also consistent with my physical examination of her right ankle. Her right ankle range of motion limitations prevented her from being able to walk in an abnormal way. Again, with that right ankle, she's not able to get to a 0 degree or kind of a 90-degree angle with the lower leg. Her lower leg was -6. You need to have +10 ideally for just a normal gait pattern. So she's -6. She's not able to even get that lower leg up to that 0 degree or 90-degree angle. When there's a loss of mobility that way, you have to compensate at the knee, compensate at the hip in an effort to try to normalize your walking pattern.
What did you conclude about Ms. Daniels' ability to go up and down stairs?
All right, she was able to do it, but consistent with those range of motion limitations, she had to do it in what's called a step 2 gait pattern, where you go up with the good leg, 1 step at a time. She came down the same way, where she stepped down with the bad leg, but it's because she's relying on that good leg to lower her down. So when she went up, she stepped up with the left foot, followed by the right foot, left foot, right foot. When she stepped down with the right foot, but it's requiring her to use her left leg to do so. She can control stepping down on that step. She also did it in a sideways manner, again, because she's trying to compensate for that loss of mobility in that right ankle.
Now, Mr. Yeager, let me represent to you that the evidence in this case is going to be that after you examined her in August, this current June, Ms. Daniels had an ankle fusion surgery, subtalar ankle fusion surgery. Once she recovers from that surgery, can you say one way or the other whether she would test differently if you retested her at that point?
You should have retesting if the question about her functionality remains at that point.
Can you predict how she will come out at this point?
No, it'd be speculative.
Let me represent to you that she's also going to have a right knee replacement. And that is going to occur in the future. And you tested her last August. Same question there. If she has a right knee replacement, can you say one way or the other how her testing would come out if you then tested her after the knee replacement surgery?
It would again require additional testing.
Are you aware of whether or not anybody else conducted a functional capacity examination of Ms. Daniels?
After I saw Ms. Daniels, there was another FC that was performed with her.
And who was that by and for?
It was performed at the Friedman Group by Miss Peggy Friedman.
And who was she doing that on behalf of?
My understanding is for defense.
Did you get an opportunity to read her deposition that she gave, the discovery deposition that she gave in this case?
I did, yes.
Could you tell from reading it whether she had been able to read your discovery deposition?
Yes, she had.
Thank you.
Is this going to be your witness, Ms. Arnold? I want to ask the correct lawyer from your side.
Oh, that's right. It is going to be mine. Yes.
Okay.
You're ready, Your Honor.
Well, how long do you envision your cross-examination being?
Being that it's 12:30.
Break for lunch now? Okay, ladies and gentlemen, we're going to take our first lunch break of the trial. You are free to leave the building for lunch. You don't have to leave the jury room if you don't want to. Let's try to keep it to 1 hour, so be back by 1:30. If everyone is back early and you're raring to get in here and we've got the lawyers, we will continue, but let's aim for 1 hour. At 1:30, Mr. Yeager will be back on the stand and Ms. Arnold will be asking him questions from the defense perspective. Reminder before you run out of here, please don't talk about the case during your lunch break. It's fine to have lunch with each other. You don't have to talk to each other at all. Nothing wrong with you all chatting. Just don't talk about your experience with this trial so far, other than like how nice Deputy Gordon is, how nice the courtroom is. That kind of stuff is fine. Okay. Any logistical questions from our jurors? No? Have a great lunch. Thank you. All right, you all can be seated. Mr. Johnson, anything before we break for lunch?
I don't believe so, Judge.
Ms. Arnold?
No, Your Honor, except to just point out to the witness that he is still under oath, so I don't believe he's entitled to chat with counsel at this time.
Okay, thank you for pointing that out. That's correct. So, Mr. Yeager, you're going to get a lunch break. I'd ask you to be back here in court by about 1:20, 1:25. Because if we can get started right at 1:30, that'd be great. You need to make sure you're not talking about your testimony with Mr. Johnson. If anyone from the defense comes up to you, you can tell them, wait till court, and we'll take care of things then. Thank you, everyone.
Thank you.
Thank you.
Okay, guys. Give me a second.
Hey, just check it to see if anybody wants us to grab them something for lunch. Y'all good? Check it to see if y'all want us to grab them something for lunch.
Yes.
Salad.
Super salad.
Okay.
Super
sandwich.
Salad for me.
You eat salad?
Oh, she doesn't need these.
What kind of zucchini preference?
We had four of them.
Okay, yeah.
Cute.
I'll take my phone off. Put that in store.
Okay, so I guess we just stay in here. Can't eat in here. Go sit out there. We'll go sit out there.
Yeah.
Yeah, there's a Subway.
Yeah, let's just get some here. I don't know if you have time to leave and get some.
They said they was gonna try to. The cafeteria. Thank you, Tom.
We don't need that.
Okay.
Oh, you got
Is this unlocked from our lunch period? Are we able to get back in if we come like before time? It's not locked out? Okay.
I'm gonna lock it, but I'll be here.
Okay, thank you. Are you staying put? Huh? Are you staying put? Yeah, I'm gonna eat my little salad, go out and smoke my cigarette and come right back. I am gonna get a drink. Might as well, I bring it, I don't have to spend no money. Yeah. Or walk nowhere, really. I mean, there's a Subway right there. Yeah. I didn't know there was, I was like, oh, what's around to eat? Yeah. Yeah, I bought some snacks myself, I'm gonna get a drink. Yeah. I need to talk to. Seeing how Friday went, I brought snacks. I said, seeing how Friday went, I brought snacks this time. Because Friday I was hungry. Yeah. I was sitting, everybody was snacking. I'm like, oh, wait a minute. I sure did. I was gonna bring that station back to the okay. I just left it open for you right now. Yeah, but I'll be able to get back in here. Yeah, it's not going to. You're not going to lunch? Yeah, my lunch already. Okay, all right. I'm gonna just grab a drink. I'll be right back. Well.
Hey, Stacy, it's Erica Brown, the recorder. Did you have to like, wait a minute, let me think. I know you talk to a lot of us. I know. So. Oh, God, yeah. Yeah, this is Stacy Wilson, right? And I didn't respond back to your text, but you guys are so welcome. For showing and for staying, you said thank you for staying, you're welcome for that. I try to represent as much as I can, but I have an issue and I don't know if I need to talk to either you or who I need to talk to. So Friday that just passed, I had a job, I forgot what it was about. What was that job? For Mercedes-Benz, something like that. They're the defendants, if I'm not mistaken. Stacey, I have it in there, and I have been crying all weekend because I had a bad one last week. I'm in the courtroom now. My voir dire didn't take long, but the lawyer's like, hey, don't worry about it. I'm like, ooh. But the job that I had Friday, all my audios got filled up because we were there like all day. My audios all got filled up. I was like, oh my God, what am I gonna do? I was like, oh, I got a sound recorder on my phone. Start taping with my phone. Phone goes out. And I'm like, oh my gosh. So I was like, you know what? I have room audio because that's my backup of the backups. So I had 3 backups that went out on me. And so when I get home, I go to review the deposition. I think about probably maybe the last half an hour of the deposition. When you go to listen to the room audio, everything is underwater. It sounds like it's like it's drowning. I'm like, I didn't do anything wrong. Why is my room audio, which is the audio on your computer, why is it not working? Called Eclipse. Oh, nothing you did wrong. Your system shut down. Why? Oh, I don't know. It doesn't. Why? Why is my system shutting down when y'all know I'm a court reporter? And they're like, we don't know. Eclipse. That's what it does. He did a little settings or whatever he had to click. I don't know. He said, but it wasn't your fault for whatever reason your system decided that it wanted to go to sleep, so to speak. So Eclipse went to sleep when I didn't even know. So I've been crying like literally physically all weekend because now the attorneys that I had Friday, I have to tell them the last half an hour of the deposition is not taken down. And I don't know what to do, Stacey. And I'm like, so, my anxiety is like 1,000% right now. So, giving you all that information, who do I need to talk to? Or I can call the lawyers myself. I mean, you know. Do I think what? Say that again, honey. No, this is a deposition. Yeah, no, they don't have it. Yeah, I'm in the courtroom now. I've taken care of that. It's just my voir dire, you know, when they pick the jury selection, like that, that's fine. I told the guy who hired us, hey, look, it just didn't go. And he was like, you know what, we'll see what we got, and that's it. So I'm not even worried about that, but I have been on anxiety level like 1,000%. So my system shuts down without me knowing that. And I said, is there any way to get notification? Hey, your system, the tech guy said no. Advantage Software says no, it just decided to do it and there's no notification that you will get saying, hey, I'm going to sleep. Which I don't understand that. That never happened to me. But Stacey, what do I do in response to these attorneys? Because the one attorney was from actually Arizona. it sounds underwater. Everything sounds underwater. It's like, you ever, I don't know if you ever hear it glow, it's that's what it sounds like. And so I have 2 masks that I take with me. I have 2 of everything, Stacy. They were both wet. But the reason why it yeah, go ahead, I'm sorry. Sorry, next time I will tell you. I'm sorry, I am voice. I'm sorry. She's like, what are you talking about? Okay. You guys are so much stuck, yeah. See now, and that's the thing, I'm like, when you say notes, now I don't know what you're talking about because I don't know how their software does, but that's okay. Hey, we're all one team. I'm not worried about, we'll get to understand it by and by. So, yeah, so Stacey, with the voice, because I'm a voice, we have, Eclipse has a room audio that once you put your mic on, it will record by itself, so you don't have to do anything. Well, my software, Advantage software, my Eclipse decided that it went to sleep without me doing anything. I don't touch settings because they're already in settings. And it went to sleep basically. So there's no recording of that last, and I don't even know if it's the last, I don't even know if it was a half an hour. It was like the opposing attorney said his questions, the plaintiff's so the plaintiff's attorney did his questions, I got all that. The defense attorney, when he went to do his questions, the defense attorney did his questions, and then everything went underwater, and I'm like, but he got some of the questions, I did record some of the questions, but everything else, because my sister decided to go to sleep, sounds like it's underwater, and I didn't do anything wrong, so I was crying literally like physically tears all weekend trying to figure this out. Okay, I'm sorry. Christia, okay. Okay. Yeah, because like I said, I have the whole deposition, probably accept her like that. Even if it might even not even be 30 minutes, Stacey, it might even be 20 minutes, but I'm sorry, and I have spoken to Christia, but not about this. I didn't know she was your boss. Okay, so I know who you're talking about. Please let me know what I need to do, because I know it's due soon. I haven't even worked on it yet. I think, yeah, I haven't even worked on it yet, because I have 4 transcripts due right now, so I'm not even working on it, so I'm not even scoping it yet. But just let me know what to do, because we're probably gonna have to do a Zoom and do the last half an hour every day. Because he's not coming back in from Arizona. So. Okay, and I appreciate it. And again, Stacey, I'm not afraid to talk to the lawyers, you know, nothing, it happens. I didn't know systems go to sleep like that, so. I know, it's like. That's what I said. Oh. See, that's why that's frustrating. Yeah. And that's what I said. As long as I didn't do it, because I first thought, oh my God, what did I do wrong? But hey, like you just said, Stacey, it happens. Ooh, that's horrible. That FedEx, that's horrible. I'm gonna let you go. I'm not gonna hold you hostage, but just let me know what I need to do. I will be in court all week, as, I don't know if you know, but I have a court trial all week. In Fulton County Superior Court, so just, you can text me, but during the day, I doubt if I, unless I probably get you at lunchtime, but lunchtime is different every day, so. Just let me know what we do, yeah. Okay. I'm so thankful and grateful to you. Thank you so much, Stacy. And I hope you guys get that FedEx tracked. I will let you go. Sweetheart, you have a blessed day. Thank you. You're welcome. Bye-bye. Unbelievable. Just, ugh. Alright, I'm not done or anything, it's lunchtime, so I'll be here all day. I just wanted to tell you, I put Tristan's stuff back in that, it should be in that first suitcase. Oh, you were reading her diary. Oh, you was reading your daughter's diary? Eating that salad. And and I stayed right here in the courtroom, so I don't have to go, you know what I mean, walk around with no food. Not necessary, thing. That was a good idea. But I meant to tell you that because I know you're on me about, we gotta get it to the lawyer. And if you look through there, there's just stickers from work, but I can't think of no other paperwork that I have for her. Yeah. Cause those names, she got like, if you look at the one, I think she got it where it says therapist and all that stuff. They handle, yeah. Oh, it does? For 1:30. It's 12:53, I took it at 12:30, but I had to call Vertex, that's why I was on the phone calls. Because I gotta let them know, hey, listen. There's last 30 minutes, my computer shut down. You know, she said, oh yeah, no, ain't nothing you can do. So I was anxious about that. This morning, the lawyer said, well, see, I said, well, are you gonna ask for the lawyer? He was like, we'll see, but he didn't spaz out like I thought he would. I wasn't, because I didn't lie, but I was like, okay, Lord, don't make me lie. So, hey, I didn't take it, thought I, this was wrong, and it wasn't. He said, don't worry about it, we got what we got. But I was like, oh my God, I thought you were going, he's like, hey, we're here, man. So anyway, so then I just called Vertex just now and told them what happened with Friday's deposition, or Thursday, whenever it was, I don't know. And she said she will let see what we can do, because he's not gonna come back from Arizona. That lawyer was from Arizona, he ain't coming back here. Not for 30 minutes of the devil. Yeah, his mom, I said, you flew away from Arizona for this? He said, yeah. He was a taking attorney, he could have easily did that, so, like I said, I don't know nothing. Yeah, you're right, I didn't think about that, but they do charge the client that when they have to do their thing. Yeah, they charge you for like, if they make a phone call or mail out a stamp, I was like, they could do that? Cause I remember the lawyer charged us for that, I mean, you could call me and tell me to mail that out, you don't have to charge me for that. But anyway, that's where my anxiety was like 1,000 this morning, like my heart was literally beating out of my chest. Well, you were trying to calm me down this morning, I know that, but that's, ugh, man. I was just like to be excellent, I don't like no hiccups like that, that's what spazzes me out, but anyway, go ahead and do what you're doing, man, I just wanted to tell you about that, why I had a little bit of time. To say that, but I love you, and how did she do? She got in school, okay, she should be in class right now, actually. Her class in school. Oh. She got some breakfast or whatever. I'm thinking about what goes to you. Yeah, I get it, okay. That makes sense. I did get her up pretty early. Okay. She don't have a class, well, she's in class now. Her class didn't start till 12. Alright, I am going to continue. I got, but what is it, 1 o'clock, a half an hour, I'm going downstairs, come right back up here. So I'm out to right over there. I'm not sure what, I know we got out at 7 with the board there. Ain't no time when we get out of that. It's not a board there, it's just regular court. It's so interesting. So shouldn't be, I don't think he goes past like, 5 o'clock, but then again, you never know. So I'm gonna have that to a little later, and I love you. Okay. I think I should change masks.
No, I didn't see Daphne, but I'm sure I'll tell her that we're here.
Did you find something to eat?
Barely. It was a catastrophe. I'm bringing my own tomorrow.
Yeah.
Live and learn.
Number of mine new offices now. Kitchen. I moved to the other side of the, Rick moved. Did you know Rick moved?
No.
He moved. Diagonal corner, Billy's.
Oh, really?
And so I moved.
Bigger than that.
Better view, I guess.
Yeah, he does that.
Closer to him.
Yeah, and then he was. I'm like, okay, he's like, well, if you don't want to. And it was a bigger, bigger office. And then 2 weeks after, I've been in the water with the kitchen of the.
It's not October, November.
Pretty cool. Access.
What time do they get? Yeah. Brandon and I just came in like 8. The other stuff going on.
Just have to stand out there. We try to get them to come in. I try to get them. I try to. Maybe it's early, you can go 20, 30, early access pass.
Any Francis, or anything, Brandon, Maxwell. Yeah. Other than Maxwell.
Should have been a side entrance over here, or?
Yeah. This trial. I don't know.
Okay. All right. I'll try to remember, and if you need to, just raise your hand.
I will, but, because I don't, is that right?
I don't know.
Okay.
Just,
Well, yours is a good job. I'm assuming that is. Thank you, that's what I'm trying.
Oh, turn it on?
Yeah, I need the lights on.
I'm just gonna turn it off for now, because
Okay.
the live feed on YouTube picks it up.
Oh, does it?
Yeah.
But it, was it on before?
Yeah.
It was?
Yeah.
We weren't loud enough for it before? Maybe we're just not talking into it, maybe we should push it closer to us.
For her, you were good, remember what I said yesterday, you did very well, but they're not talking into the mic, cause I'm really strained. I can pick it up, but
Because they're facing the jury, I bet,
yeah. So if they speak into the mic, I can just sit still, but if you see me turning and looking in your mouths, I'm not being funny, it's cause I'm reading your lips. So, just remember to speak into the.
You should get warm, because what did they want us to turn the AC down? Brr, I'm wearing all these layers. It's cold in here. All right. You ready, Miss Brown? You're bundled up?
Keep thinking you're saying Miss Brandon.
No, that wouldn't be very nice, since that's your first name.
Happens all the time.
Yeah, I'll try not to do that. Nope, Ms. Brown. We are back on the record in Daniels versus MARTA. I have one juror matter to bring up. It's not bad news. It's actually, you all will have a little chuckle. Juror Clay has offered to drive juror, I think it's Begg, the one who doesn't go on highways, but wanted to make sure it would be okay if jurors carpooled. I plan to address that with a hearty yes, that's what makes this world go round. But I wanted to make sure there were no concerns. I think it's no different from jurors having lunch together. They just need to not talk about the case. Mr. Johnson, any issue with that?
Sounds like a great plan to me.
Ms. Arnold.
Me too, Your Honor.
Okay. Mr. Johnson, anything else we need to talk about before the jurors come back in?
I don't believe so, Judge.
Mr. Yeager, you can come on up and be in position. Ms. Arnold, anything from the defense before we bring the jurors in?
No, Your Honor.
Great. Then once Mr. Yeager gets, you can just stand sort of by the witness stand. We'll bring the jurors in. I just don't want them to collide. Great. Okay. All right. Thank you, Deputy Gordon. You all can be seated. How was lunch? You found something to eat? Did everyone go to American Deli? We'll see how that goes. It's just it's the close place, and some people panic like there's only American Deli. We are going to pick up where we left off, which was Mr. Yeager had completed his direct examination and cross-examination is about to start. But before we do that, I want to provide an answer, and that is jurors may indeed carpool. And thank you. If that makes a juror's commute easier, carpooling is fine. You guys could all drive in one big happy fur bus to get here and back. You just can't talk about the case when you're together. So just like having lunch is fine, going to dinner is fine, not that we'd ever keep you here for dinner. If there's a way that you all can collaborate and carpool that makes life easier for some of the jurors, go for it. But in the car down, just don't talk about the case. Listen to the radio, do whatever you're going to do. But thank you for creating that opportunity, because I know we heard about some transportation difficulties that some of you might have. So that's a great idea. Ms. Arnold.
Okay. Mr. Yeager, good afternoon.
Good afternoon.
On direct exam, you described for the jury what sitting means for purposes of workplace setting. Do you recall that testimony?
Yes.
And that position is similar to how you're seated now.
Correct.
Okay, and it's similar to how Ms. Daniels is seated now.
I'm not able to see below the desk, but so I don't know how she's sitting below this height.
Okay, and you also testified that ideally, in a seated position, someone's feet will both be flat on the ground, right?
Correct.
Okay, but you'd agree with me that there's a number of different positions someone can have their feet in under a desk, right?
True.
Okay, Ms. Daniels is not a patient of yours, is she?
She is not.
Okay, and that's because you are not a medical or physical therapy provider for Ms. Daniels.
I'm a physical therapist, but I didn't provide her treatment.
That's right. She was not a patient of yours.
Correct.
Okay. No doctor referred her to you.
No.
Okay. You were asked and hired and paid by the lawyer in this case to perform an evaluation of his client.
That is correct.
Okay. In fact, the majority of your business is working with plaintiff's lawyers as their paid expert to perform these evaluations. True?
Of the breadth of the evaluations that I do in personal injury cases, that is correct.
Okay. You haven't provided treatment or care as a physical therapist in the clinical sense in over 5 years. That's also true.
I have provided clinical services as recently as September of last year, which was related to providing on-site services for a local warehouse distribution center on Fulton Industrial Boulevard. I'm not sure if that's Douglasville, but in that area. And I was functioning as a physical therapist, helping this employer with preventing and handling work-related injuries, symptoms, discomfort. So I'd put that in the clinical practice.
Okay. But as far as receiving patients at a clinical practice, you haven't done that in over 5 years.
Correct.
Okay. You performed over 3,000 functional capacity evaluations in your career.
After I had testified about that, it's shortly or nearly 3,000.
Okay. And in most of those cases, you were hired and paid by personal injury lawyers like Mr. Johnson, right?
In a majority, yes.
Okay. 100% of the impairment ratings that you've performed over the last few years are cases in which you've been hired and paid by personal injury lawyers like Mr. Johnson. True?
Can you restate that again?
Sure. 100% of the impairment ratings that you've performed in the past few years are cases in which you've been hired and paid by personal injury lawyers like Mr. Johnson.
Correct.
Okay. This isn't your first case with Mr. Johnson's firm, is it?
It is not.
Okay. In fact, you've been hired and paid by the law office of John Foy and Associates over 10 times.
I don't recall, but it's not much more than that.
Okay. Your deposition told us at least 10 times. Would that be accurate?
Yeah.
Okay. This is not your first case with Mr. Johnson either, is it?
This is my second.
Okay.
Or this was my first, and then I think I had one sometime since then.
Okay. Your deposition, you told us is at least the third time he's hired and paid you to perform an evaluation and testify on his behalf. Would that be accurate?
Under Mr. Johnson's file, I only have 2 cases, but it's possible that it was 3.
Okay. Your opinions in this case are based on your evaluation of Ms. Daniels, as you stated, which lasted around 5 hours on August 6, 2021.
Yeah, 2 minutes over 5 hours.
Okay. That was over a year ago, wasn't it?
August 6th, yes.
Okay. And so if you were to evaluate her again, those opinions may change.
They would reflect how she was at that time, but my opinions based off of the evaluation I performed in August 6th are at the time that I evaluated her.
Right. And if you were to evaluate her again now or in the future, those opinions that you've rendered in your report may change.
Potentially.
Okay. And that's because people's conditions can improve or decline over time.
Correct. Or
Okay.
stay the same.
Okay. So because you have not evaluated her again since August of last year, your opinions are limited to what you observed and evaluated during the 5 hours on that one day in August of 2021.
Correct.
Okay. That's the only information you can provide to assist this jury here today.
Correct.
Okay. You chose not to ask Ms. Daniels about any of her daily activities during the time you spent with her on that one day in August of 2021, right?
Well, I did question her as far as what, in my interview with her, her symptoms, what aggravates, what she does to relieve. So in the context of that, yes, I did ask her about what are some aggravating factors to the problems that she was experiencing. But in terms of what I think you're referencing in terms of assessment for activities of daily living, I did not have an interview on that topic.
Okay. So at the time you completed your functional capacity evaluation and your impairment rating, you were not aware of what, if any, limitations she had with respect to personal grooming or self-care, correct?
Correct.
All right. Not aware of the dynamics or the specifics of her family life?
Correct.
Not aware of whether she required assistance in the home?
Correct.
You had no understanding of what a typical day in her life was like?
Correct.
No understanding of Ms. Daniels' lifestyle outside the 5 hours you spent with her on that one day in August of 2021.
That is correct.
Okay. And you still don't know those things as we sit here today.
Correct.
Okay. You never asked for this information because you didn't consider it valuable to your analysis.
A functional capacity evaluation is to assess an individual's capabilities for doing these work activities in the context of an 8, 10, or 12-hour workday. So how individual chooses to spend their activities outside of work, that's not what I'm evaluating. I'm evaluating their lifting capacity, their carrying capacity, their grip strength, their postural capabilities for sitting, standing forward, bent. So I can offer an opinion on their potential for doing those activities that are commonly associated with work.
Okay. And all the things I asked about, you told me at your deposition that that is not valuable information to your evaluation.
It is not information that I would base my opinions on in an FCE.
Okay. Before you rendered your opinions in this case, you were not aware that Ms. Daniels still drives her daughter to school each day, which is an hour round trip, correct? Okay. Attends her son's out-of-state college football games, correct? You were not aware of that at the time you rendered your opinions in this case.
Correct.
You were not aware that she traveled via airplane to Chicago, New Orleans, and Minneapolis, correct?
Correct.
You were not aware that she had helped her son move into college, correct?
Correct.
You were not aware that she maintained certain housekeeping functions around her home at the time you rendered your opinions, correct?
None other than what she described as far as activities that have aggravated her symptoms, but other than that, no.
You're not aware that she cooks for herself?
I didn't ask her that question, no.
Okay. You're not aware that she bathes herself?
Again, I didn't ask her that question.
Okay. You're not aware that she performs personal care tasks for herself?
I did not ask.
You did not ask those questions?
Correct.
Okay. And you didn't consider any of this information when rendering your opinions in this lawsuit about Ms. Daniels' functional capacities and her impairment, true?
Correct.
Right. Well, strike that. You also didn't ask, nor were you provided any information regarding her job duties or responsibilities at her prior job, correct?
Correct, because she told me that she was no longer employed where she had been previously employed.
And you did not do any investigation to find out what those job duties and responsibilities were?
From my understanding, that was not relevant because she was no longer employed there.
Okay, you weren't asked to do that.
Correct.
Okay. After you complete your functional capacity evaluation, you leave it up to the lawyer who's hired and paid you to determine whether or not to have your evaluation reviewed and or approved by any of Ms. Daniels' medical doctors, right?
The validity and reliability of an FC is not dependent on having a doctor review it.
Okay, that was not my question. My question was, you rely on the lawyer to determine whether or not to have a medical doctor review it.
If they deem that they would request that, then either I let them do that or I can send the report to the doctor to request a response.
Okay, and you don't know whether Mr. Johnson did that in this case, true?
I don't.
Okay, and he didn't tell you to seek that approval, did he?
That is correct.
All right, he also didn't tell you to provide your impairment rating to any of Ms. Daniels' doctors.
That is correct.
All right, so you don't know if her current doctors would agree or disagree with your current impairment rating.
That would be correct.
Okay, and that's because you left that up to Mr. Johnson.
Correct.
Okay. You're not a medical doctor yourself, correct?
I am not.
Okay, and you're not qualified to render any medical opinions.
None that are outside the scope of a physical therapist practice.
Okay. You're also not an occupational therapist.
That is correct.
You're not a vocational rehabilitation expert.
Correct.
So to take your functional capacity results and then determine what specific jobs Ms. Daniels would be able to perform, you would defer to a vocational rehabilitation expert.
Correct.
Okay. You wouldn't be qualified to do that.
Correct.
And an economist wouldn't be qualified to do that either.
I don't know.
Okay. Thank you. As for Ms. Friedman, isn't it true that you and Ms. Friedman agree that Ms. Daniels, at least at the time you both evaluated her, had difficulty standing?
Correct.
You both agree that she had difficulty walking?
Correct.
You disagree about how long Ms. Daniels can sit?
Correct.
All right. Your opinion that Ms. Daniels cannot sit for longer than 30 to 40 minutes without pain is primarily why you say that she falls below the sedentary work physical demand job classification.
I didn't say that she can't sit because of pain. That was my professional recommendation, that every 30 to 40 minutes that she be able to stand up briefly for symptom management. I concluded that she was able to tolerate sitting for a frequency, which is 2/3 of a workday, 5 hours and 20 minutes.
So it was not your opinion that her inability to sit for longer than 30 to 40 minutes is attributable to her right ankle and lower leg issue? That's not your opinion?
Yeah, that's the physical limitation, but I'm not saying that it's because of pain. It's because she doesn't have the flexibility in that ankle to place her feet flat on the floor. So which requires her then to have compensatory posturing as she's sitting.
Sure. And as we've already established, there are many positions in which someone can have their foot placed under a desk, right?
Correct.
Okay. So assuming that this recent and future surgery eliminate any pain with sitting as hoped, that would eliminate at least any pain associated with sitting, which would, as you said, prevent her from working in a sedentary capacity.
Again, my reason for addressing that right ankle issue with regard to sitting is because of the limitation in her ankle dorsiflexion. So like you're taking your foot up off the gas pedal. And if she's not able to get to zero, she's going to have to place her foot forward or outward in some other posture. And unless if the surgery directly addresses that loss of range of motion, she's still going to, whether there's pain or not, she's still going to be limited in the posturing and the placement of her right lower leg and her foot.
Okay. And Mr. Yeager, to give any opinions about Ms. Daniels' current condition or her future condition, you'd have to evaluate her again, wouldn't you?
Yes.
Okay. Thank you very much.
Mr. Johnson, any redirect?
Briefly, Joe. Thank you. What's the difference? Ms. Arnold asked you about your ability to say whether or not Ms. Daniels could currently, as she was when you saw her in August, work at any particular job. And you said no, because that's another field of expertise. Is that right?
Correct.
But you've testified about job categories and her limitations and where they fit in those job categories. Can you help the jury understand the difference in those two, just so there's no confusion?
Sure.
Thanks.
Sure. So those 5 categories I mentioned before lunch: sedentary, light, medium, heavy, and very heavy. By taking Ms. Daniels' capabilities and comparing that to those 5 categories, then a vocational rehab consultant can then look in those categories and find, are there any jobs from a physical aspect that she might be able to match with? And there's other criteria too, which is why I don't do this. But education and other things that I wouldn't testify on. But from a physical and functional capacity, where does Ms. Daniels' capabilities fall within those categories? And then that helps the vocational rehab consultant to then look in jobs in that category that they might be able to qualify for, or at least investigate.
Thank you. That's all I have, Judge.
Anything based on that, Ms. Arnold?
No, Your Honor.
Okay, questions from the jurors for Mr. Yeager? Yep. Okay, so again, you need to write it down. It's not, okay. No, that's okay. I thought you were about to say, here's my question. No, don't apologize. Write it down, and then you'll give it to Deputy Gordon. I'll work through it. What else? Thank you. A lawyer from each side, please, this way. Just right here. Then press the little black button to get the next one. Mr. Yeager, are you the proper expert to answer questions about why it is that Ms. Daniels had only a certain range of motion in her wrist, or why her grip strength was what it was? Is that your role, or do you more assess, because of the limits on range of motion, here are some conclusions that I, meaning you, make?
More the latter, where I'm evaluating the condition that's present, and I can make using clinical reasoning, relate that to the surgeries that she's had, the injury, and that historical information. Now, as far as there being internal issues that might be contributing to that loss of motion or restricted motion. From a medical perspective, I would certainly defer that to her surgeon or her treating physician, but I'm evaluating the condition as it presents to me at that time, which is the limitation in range of motion or limitations in strength.
Okay, so there's questions of causation. What is causing a wrist to be limited in its range of motion? You're saying it's more for the treating doctors. Your expertise is as a result of that. What are you limited to doing? I'm saying it the wrong way because we've also heard that there'll be vocational experts who can get even more granular, but you at least are able to categorize based on what you observe someone's limitations in certain ways.
Correct. I'm using that as correlation, and that's in the realm of an FCE. It's important to do that because you're looking also for consistency of performance from the client. And are they performing in a manner that's consistent with those range of motion or those strength deficits? Is it consistent with that past medical history or not?
Okay, great. Mr. Johnson, based on that brief exchange I had with Mr. Yeager, do you have any follow-up?
I do not. Thank you, Judge.
Ms. Arnold?
No, Your Honor.
All right, Mr. Yeager, thank you for your time. You are free to go. Your next witness.
We're seeing if he's in the hallway, Judge.
Okay.
Oh, is it? Do you have to address this, Dr. Seaman? We have the one in that, or we need to address wrong?
Okay. Is that, I didn't mean to it's doctor. It's not Mr. Seaman, it's doctor.
It's Dr. Bruce Seaman.
Okay.
He would be the next witness if you'd like to take up any matters prior to that.
Oh, well, I did. I just didn't know that he was next. So, ladies and gentlemen, you may still have another afternoon break. The sequencing of witnesses was different than I understood. I'm gonna need you to go into the jury room or that back hallway for just a few minutes. I think this conversation will last about 4. So don't go too far or get too comfortable in the jury room because we'll want you to be comfortable out here in just a moment. Thank you.
We don't need Dr. Seaman in here.
Nope.
Okay, if you'll wait outside while they address a couple of issues.
Stay nearby, please. All right, you all can be seated. Let me try to frame the issue. Dr. Seaman has now sat for 2 depositions. There were some, I think, late disclosures, concerns from the defense, and then the concerns were largely resolved because Dr. Seaman sat for a second deposition. Flowing from that deposition were concerns from MARTA that Dr. Seaman might be offering what MARTA has characterized as speculative or conjectural opinion testimony. No doubt an expert. He's got doctor in front of his last name, but I think he's an economist. So the concerns that MARTA flagged were Dr. Seaman speculating as to why Ms. Daniels' doctors may have done certain things, speculating as to why Ms. Daniels might be motivated or not to work, and finally speculating as to what Ms. Daniels' prior employer, the apartment management company, what they might be willing to do. I found most compelling the first category, speculating about what doctors would do. The second one, I don't know that it required a lot of expertise to say someone might be motivated to work if they needed money and were in dire straits. But I want to give you a chance. You've read the motion. I want to give you a chance to respond on the record, Mr. Johnson. And then Ms. Arnold, I'll let you or Ms. Page flesh out more of a response. But I wanted to, this may be one where Mr. Johnson said, we're not going in one of those directions. But I assume there's still an issue since we had to pause.
I just want to say, we're not going in those directions. He is going to testify from his report as to numbers. And every bit of that testimony that they're complaining about is testimony that was elicited by the defense when they question him. And I want to make it clear that if anybody invites him to speculate on the defense side, he should have a right to answer the question that's asked him. And that's what happened here. They're not saying that anything in his report is speculative. I mean, they may be, but they're not saying it can't be used for whatever reason. They're saying that they asked him, what do you think about this? What do you think about that? And his answers, they have a problem with. So I think that the best thing to do here is let's just let the testimony play out. And if somebody wants to make an objection, then let's discuss it at that time. But it's really hard to, parse out every permutation in advance. And especially when all of these pieces of testimony arose in response to questions that were not about information in the report.
Okay, I agree with much of what you said. We can't think of every possible scenario that would come up. The defense has asked that I direct both sides. I think it was more directed at plaintiff, but I hear you that these weren't questions you asked, but it does sound like Dr. Seaman was comfortable saying, well, I'll tell you why I think the doctors didn't do X and Y and Z. Those shouldn't be questions that you're asking. Now, if Dr. Seaman has trouble maintaining linearity and answering your question and he drifts over there, there can always be an objection and we'll nudge him back into his lane. But in general, that's something that both sides should stay away from. Hopefully he's not going to be non-responsive in his answers. But I'm hearing you say, Mr. Johnson, these aren't areas that you plan to go into. You didn't in the deposition. You're not going to go into them here. You'll be driven by his report and the numbers contained therein. And if Ms. Arnold thinks you're straying from that, she can always object before Dr. Seaman starts to answer. And then I can provide more guidance then. Ms. Arnold, is there more you think we ought to do right now?
The only other, the other point I'll make, Your Honor, is that there is a statement in his report where he says she has not been able to return to work. And that's an example of a statement in his report. If Mr. Johnson's not going to go into that, where he's asking him to provide that opinion, he's not qualified to provide that opinion. There is a dispute about whether or not she's been able to go back to work since the accident. That would just be an example of something that was not elicited by me. It's in his report.
Okay, and your focus is on able. It is a true statement, as I understand it, that Ms. Daniels has not gone back to work. And that is a fact that Dr. Seaman knows. And so he could testify to that. But if he veers into, I don't believe she had the ability to go back to work, red alert, not his space. That is someone else's space.
That's right. And there was some testimony about that at the deposition. I don't think she can return to her prior job, my understanding. So just as long as he stays out of that line.
Who are the experts who will talk about the ability to go back to a certain job or the types of job? Is there someone at trial who will talk about that, or Mr. Yeager was as detailed as we get?
Mr. Yeager, and then the doctors talking, and then the witnesses and the plaintiff.
Okay, but there's not a vocational expert.
Additional experts being.
Okay, so Dr. Seaman should not be talking about his theory as to whether Ms. Daniels is able to go back to work or if she could get her previous job. He may have certain assumptions, assuming she doesn't go back to work, or assuming when she goes back to work, she makes a fifth of what she made before. He can run with that math.
Right.
Okay, I think we are looking at this the same way. But I'll be attuned to it, and I'm confident that MARTA's lawyers will as well. Okay, anything else, Ms. Arnold?
No, Your Honor.
Anything else, Mr. Johnson?
No, thank you, Jay.
All right, can you see if our friends are ready, and can plaintiff's team get Dr. Seaman in here, please? Sadler, you're getting all your steps in today, having to get these witnesses in you.
I need it.
Doctor, you can just come and stand near the witness stand. The jurors are going to come in. We'll stand for them, and then we'll get you sworn in. Thanks for being here.
All right, juror.
Thank you, Deputy Gordon. You all can be seated. Appreciate your patience, ladies and gentlemen. We worked through, in about the time I forecast, the concerns that the lawyers had. If you would, for the record, Mr. Johnson, call the witness again, just so it's on the record, and then we'll get him sworn in and go from there.
Thank you. We call Dr. Bruce Seaman to testify.
I do. Thank you. Yes, my name is Bruce Allen, A-L-A-N, Seaman, S-E-A-M-A-N.
Dr. Seaman, would you please tell the jury what your profession is and what you do for a living?
Yeah, well, for many years, I've been an economics professor, primarily at Georgia State University, right up the street here. And I was chairman of the economics department for some time there, director of graduate studies. I also had a joint appointment for about 10 years in the School of Public Policy at Georgia Tech. And I'm currently an emeritus professor just recently. So I'm currently not teaching, but I still have an office there, still advise students, still doing research. But for many years, I've been an economics professor at various universities, primarily at Georgia State.
What were you hired to do in this case?
I was hired to evaluate the tangible economic losses, not including any medical expenses or anything, of Jame Daniels. This is primarily net earnings losses, both wage losses and any fringe benefit losses, and a certain amount of lost household services, at least up to a certain period of time.
So let me ask you a little bit more before we tender you as an expert about your education and your qualifications to testify for the reasons you were hired.
Yes, Mr. Johnson. Well, I have a bachelor's degree in economics and minor in political science from a college near Philadelphia called Albright College, A-L-B-R-I-G-H-T. And in the process of getting that degree, I had also studied at a university in Austria, in Europe, and also at American University in Washington, D.C. I then have a master's degree in economics and a PhD degree in economics from the University of Chicago. While I was a graduate student, I taught at quite a few places, including the University of Chicago, but also Indiana University, DePaul University, and Roosevelt University. And again, like I said, I've been at Georgia State for quite a long time. And in addition to my typical research and teaching responsibilities over many years, and at times administrative responsibilities, I've also frequently done work in what's called litigation support, but I originally got involved in that because of my interest in law and economics, and the fact that for about 5 years, I was also employed by the Federal Trade Commission, which is a government agency, does regional offices like here in Atlanta, but I also spent time in Washington. They do a lot of work on antitrust economics and also antitrust law enforcement and consumer protection. And so that got me involved working with attorneys, and that sort of expanded to providing testimony like the testimony I'll provide today.
Have you ever been qualified as an expert economist in any Georgia courts involving the value of economic losses resulting from injuries sustained by individuals?
Many times.
Have you ever been hired as an expert witness on these issues by Ms. Arnold's law firm, Weinberg, Wheeler, Hudgens, Gunn, and Dial?
I have, yes.
Based on Dr. Seaman's education, background, and experience, I tender him as an expert in the field of economic analysis and move that he be allowed to present expert testimony about the economic losses of Ms. Jame Daniels in this case.
Ms. Arnold, do you want to examine the witness at this time?
No.
Any objections to him being qualified as an expert in the field of economics and calculating economic losses?
No, you are.
All right, Dr. Seaman, for the purposes of this trial, I'm qualifying you as an expert in the general field of economics, but in particular for here, calculating economic loss.
Thank you, Your Honor.
You're welcome.
Now, we got into this a minute before, but you were hired. Who hired you, first of all?
You and your firm.
Yes. Okay. And who's paying you for your attendance here in court today?
Your firm.
Okay. What exactly did you understand your job to be in this case?
Well, as it often is in injury cases where somebody has been employed and then has some injuries and is no longer employed or is potentially capable of doing some work, but a different kind of job than she originally was doing, he or she was originally doing. I commonly do that. It's a matter of getting as much information as possible regarding the earnings history of the person, the qualifications, past jobs that they've had. And then specifically in this case, since Ms. Daniels had been working for SI Management, property management for some time, since about 2013. The accident, of course, happened in 2020. Had a decent amount of earnings history for her, as well as some information about whether or not she was receiving employer-paid fringe benefits. Those benefits were modest, but there are some. But based on the information that I had, I was able to apply the usual analysis that an economist would do, determining the base income she would have earned, let's say for the full year that she was injured and going forward, including growth rates, and also if there's alternative employment possible, one has to calculate that. It's called sort of mitigation earnings. And all of those losses, at least the ones that go beyond today, there's sort of past losses that sort of go from the date of the accident to today. And then future losses are projected, and those have to also be translated into what's called present value dollars.
Did you prepare a report and that memorialized all of your findings in your analysis?
I did.
And do you have that in front of you?
I did.
Would it help you as we go for you to be able to refer to that report?
It would.
Okay. Let's start with telling the jury what you reviewed and what you did in order to be able to formulate the opinions you're going to give us today.
Well, as I indicated, I had a decent amount of earnings history for Ms. Daniels and the job that she was performing at the time of the accident, and in fact, had been performing for about 7 or 8 years. And those earnings, I could also adjust to 2020 dollars using kind of a consumer price index adjustment, kind of an inflation adjustment. And so I was aware that her earnings as early as 2015, for example, had been $63,585, which in 2020 terms, 2020 dollars, would be $70,023. But that wasn't always what she was earning. She didn't always earn that much, but her earnings on average from 2015 to 2019, which was the last full year before the accident, in dollars, in 2020 dollars, adjusted sort of for inflation to 2020 dollars, were $63,604. And so that, even though the very last year, 2019, she'd actually earned in 2020 dollars $69,278. I did not use that figure. I adjusted for the fact that she had had some up and down years, and the average basically in 2020 dollars was $63,604. So to directly answer your question and not go ahead of you too far, I had this earnings history. I was aware that her employer was not really paying much in terms of fringe benefits, in terms of, let's say, health insurance or retirement plans. So I limited any fringe benefits to sort of what the employer would have been sort of legally required to pay for a W-2 type worker, full-time worker, which is a bunch of different kinds of insurance legally. And also, as most of you, I think, know, that if you're working and getting W-2s, your employer is required also to pay on your behalf into Social Security and Medicare on your behalf. And that's 7.65% of gross wages. So ultimately, when you add the additional sort of modest kind of like unemployment compensation insurance and workers' comp and things like that, it's about 10.07% in terms of fringe benefits. So modest fringe benefits. But I did have that information. And it's more than I sometimes have and less than I sometimes get, but it was certainly adequate to, I think, project in this particular case.
Can you tell us the different categories of damages that you formulated opinions about. And then we'll talk about each one later, but I mean, I think you talked about past wages is one.
That's correct.
Tell us all the different categories of economic loss that you calculate.
Okay, let's take the simplest distinction first. I'll just get back to it. I had mentioned it in passing casually there. There are past losses. That's defined literally as the date of the accident. They're in March 2nd, 2020 to today, September 19th, 2022. Those particular losses, if you focus on the wage earnings losses and the fringe benefit losses, I guess I can give you that number now if you'd like. If you like. On the wage side, up to today, it's $156,479. It's 156,479. The fringe benefit losses, again, they're modest, but they're 15,757. When you add those two numbers together, you get up to today in terms of earnings losses, 172,236. That's 172,236. And then future losses would start from today and go forward. I've already mentioned, and I hope I didn't go too fast with that essentially what I did was I looked at essentially the earnings history, put it into 2020 dollars and averaged it. I actually averaged it from 2014, which was a lower earnings amount, and that was $63,604. And that's what I use as the base going forward. Now, again, just to repeat a point that I mentioned, but I want to just mention this again. The very last year that she worked without any injury or anything before the accident happened, it's 2019, of course. In that year, she made $68,347. That's in wages. If you make that a modest adjustment into what's called 2020 dollars, that would actually be 69,278. But I didn't use that figure. I used 63,604. In part, that's because I'm going out to age 66 and a half. And that is a statistical kind of result based on her educational level and gender. But partly I went to 66 and a half because, well, it's almost to the full benefits Social Security retirement age for a person born in her year, 1977, which is age 67. But also her earnings background, if you look at her resume, she was pretty stably employed for about 15 years up to the accident. She had different kind of jobs, but she had her first child when she was about 23, but since about age 28 to about age 43, she was pretty much working. And so there's no reason to suspect she would keep working pretty regularly. But to take into account movements in and out of the workforce, perhaps working part-time, shifting between one job and another, working only part-time, I don't use this 69,000 figure or 68,000 figure. I use 63,604.
So I want to go back to what we're calling prior losses.
The past losses, yes.
Past losses.
Yes.
And you gave a figure of 172,236, right?
That's correct.
And I want to clarify something here so that everybody understands what we're saying. That figure, as I understand it, you tell me if I'm wrong, is the total amount that she did not earn for that period of time. But you are not here to offer an opinion as to about whether she should have been working back then, right? That's somebody else's job. Your numbers, as I understand it, are based on the fact that she simply had not been working for that period of time. And that based on that, the number that she was not paid was 172,236.
Sir Johnson, you were correct. The information I have is that in 2020, where she only worked a partial year because that accident happened fairly early in the year in early March. So she made about 18,523 that year. But again, my projection is that she would have made, going back to this number once again, the 63,604. So the difference between those two numbers is the loss for that year. Then I'm aware that she didn't earn anything in 2021 or up to this point in 2022. But Mr. Johnson, you were correct. I'm not offering any opinion other than the fact that I'm aware that she didn't have any earnings during those 2021 and up to today 2022 period.
Now I want to change and talk about future losses. Okay.
Right.
I understand that you calculated essentially two different scenarios for future losses, and that you and I are going to primarily talk about the second scenario. But could you explain to the jury the two different scenarios? And again, these scenarios, am I correct, make assumptions about whether she will be able to get certain jobs or not. You are not here to say whether that will happen, right?
That's
You're
correct.
just here to say, if a certain thing happens, here's the financial consequence of that. Is that,
That's correct.
Am I saying that accurately?
You are.
Okay.
That's correct.
So tell us the two future scenarios you calculated, and briefly tell us the first one, because I don't think we're going to spend a lot of time on it.
I don't think we'll spend much time on the first one. The first one basically continues to assume that she's not earning anything in her post-injury situation. And so that would be, you might use the terminology, the no mitigation case, but she continues to have no earnings. And in that situation, her future earnings can be calculated and added to those past lost earnings. And when I do that, I'll just give you that number for the record here. The future in present value dollars, and just for a second, present value is fairly a simple concept. It's kind of the opposite of compound interest. You had $100 today and you could invest it at 3%, you'd have 3 1 year from today. If I said to you, look, I'm going to promise to give you $103 1 year from today, how much would you pay me for that promise? You would say, well, gee, it's worth $100 because I myself could just invest $100 and have 103 1 year from now. So it's sort of the time value of money. It translates essentially future dollars into present dollars by basically saying, how much do you need today when safely invested that would grow to be these numbers in the future? So any number I give you that talks about any losses from today going into the future are in present value, or what's called discounted dollars. And so I'll skip the breakdown in this first case between the fringe benefits and wages and just tell you that the present value of those future losses, if she's not earning anything going forward in her post-injury situation, is $1,342,758. That's $1,342,758. And if you add that to the past losses that I've already talked about, that $172,000, the total would be $1,514,994. So that's that first case that Mr. Johnson mentioned.
Now, tell us what the second case is that we looked at.
Okay, so the second case recognizes that she's had some medical procedures already. She's going to have continuing medical procedures. She's had or the ankle fusion, plus the rehabilitation period, plus ultimately getting a knee replacement, plus the rehabilitation expected period suggests to me that if we assume, based on good outcomes from these medical procedures, that she'd be able to earn some income. And, and it's a matter of looking then at what is a defensible and a reasonable degree of economic certainty alternative set of employment opportunities. And to do that, starting, let's say, 1 year from today. I mean, literally, if we said 1 year from today, September 19th, 2023, she will be able to go back to work after having had the surgeries and the rehabilitation that's required to put her back into a position of being able to work. I then generated alternative earnings based on, in 2023 dollars, $35,513, and projected that forward using a growth rate. And just to give, I'll stop, I guess, for a minute.
I wanted to ask you, when you're making this assumption about what she's earned,
Yes,
if she started to work a year from now at a job.
yes.
Are you assuming she is able to get a job, but is not going to be physically capable of the old job she had, which would have involved climbing stairs and walking a 20-acre property, but that she would be well enough to earn income?
That is correct. That is correct. And this last point that I made about the 35,513, certainly that is not as high as the income she was earning in that previous job in property management, which would be about today, maybe $66,118. But it's my understanding that, or I did not assume that that is the most likely case. And so I looked at these alternatives. These alternatives were based largely on things that she's done in the past, jobs she's had, activities she's been involved in, which generally fit into a kind of office and administrative support type positions. If you specifically look at particular jobs with, let's say, switchboard operators, including answering services, telephone operators, bill and account collectors in the metropolitan Atlanta area, you get about 35,513, which is also kind of between two other possible alternatives. We know she actually, from her educational background, is qualified in nursing, sort of as a nursing assistant or nursing orderly. She has certifications in that. If you look at what those jobs pay, they typically pay, if you round it up to about 31,000. Frankly, nurses are underpaid in my opinion, but that's just a separate point. That would be an alternative. That'd be lower than what I'm using. There's other possibilities. A more general range of administrative positions or customer service positions that might be as high as 40,000. So the average is roughly in between there. But so I use 35,513 and project that forward. Compare it to what she would have earned had she been able to continue in this higher paying position in property management. And that allows me to calculate, with this mitigation alternative set of earnings, a net loss for the future.
Okay, so I'm not an economist either. Make sure I got you. The reason you're saying she has future losses once she starts back, if she is able to start back any work at all a year from now, is because she'll be earning less in all likelihood than she would have been earning before,
That is
right?
correct.
So if a year from now, Ms. Daniels started back at her old job, if it was somehow reavailable or an identical job, and if she was cured enough to be able to do that job,
Yes.
would she have any losses going forward at that point?
If she could go back and earn just what she would be expected to be earning in that old job, that property management job, starting 1 year from today, after all these rehabilitations and these medical interventions occur, and there would be no further losses past that September 19th, 2023 period. We'd have primarily past losses plus about 1 year of future losses between now, today, and 1 year from now.
But if she is able to return to the workforce, but not as a property manager, that is a economic loss that you have calculated.
Yes, I mean, I could tell you what it would be with that even more optimistic case as well, but I definitely have calculated it based on what I think are these alternative jobs with administrative support and responsibilities that compare closely with what she has done previously, starting in jobs back in 2005. Yes.
Forgive me, I'm so sorry.
Yeah.
The jury's going to decide where the wage loss figure should be. So let's give them MARTA's most likely, most optimistic scenario.
Okay.
Well, I guess that's not true. I guess MARTA's going to say that she should be.
So we'll let MARTA say what they're going to say. You can ask your question.
Okay. But let's just give a number for date of loss, March 2nd, 2020, until a year from now. Just that number.
And should I give it to you just in earnings now? Just the earnings, right? Nothing else. I mean, because nothing like household services, just earnings.
Just earnings.
Okay, just earnings. Okay. Well, You remember that I said that up to today, given that she had not earned anything except for that partial amount up to March in 2020, that loss had been 172,236. If you add another year of losses, and then she can return to her old job with fringe benefits, that would add another 72,776 loss. And that would be then $245,012, 245,012. And then from that point going forward, if she's able to do just what she had done before and be in that same path, either with HSI or somebody else in that area, then there'd be no further losses. So that number would then be 245,012.
In addition to the 245,012, did you also factor in some additional economic losses she would have suffered between March 2nd, 2020 and 1 year from today?
Well, there is this other category entirely, which I've only mentioned very, very briefly. It's called household service losses. And so I think that's.
It is.
It's such a, yes. Household services are something that are regularly calculated by economists in situations of either a death or injuries where people have to change their activities. They can no longer do as much as they were previously doing regarding all sorts of household activities, from cleaning, cooking, financial management, maintenance, basic maintenance, any kind of outdoor work that has to be done or anything else, childcare, things of that nature, shopping for goods and services, and along with childcare, sort of taking care of any other household members or non-household members. Those are all household service kind of categories. And so I did calculate the past and even up to, let's say, this 1 year from today period of household service losses as an additional category of damages, of losses that she would have suffered.
And how much was that?
That figure is, if you add the past and the very modest future up to a year from today, is 45,998. 45,998.
So if you add 245,012, which you've testified is past wage loss plus 1 year, and you add that to 45,998, which is past household services plus 1 year.
Correct.
What do you get?
I get $291,010, 291,010.
If Ms. Daniels re-entered the job market about a year from now, under the conditions that we talked about, what do you calculate her total future economic losses would be through her working life?
Okay, if we go back to the case where I'm looking at these sort of administrative positions, just sort of like earning about midway between sort of nursing jobs for which she has certifications. And those are not sedentary jobs, of course. She'd have to be moving around quite a bit for that. But if that's an option, she'd be making about 31,000. If you look more broadly at a range of administrative or customer service positions, you could get around 40,000. In 2023 dollars, I'm using 35,513. If you project that forward, compare it to what she could have earned had she been able to do the property management jobs, the present value of the lost future wages is 634,345, 634,345. Fringe benefit losses, again, are fairly modest, relatively speaking, 63,879. And the total of those two is 698,224, 698,224. Which if you add to the past losses, I don't want to jump ahead of Mr. Johnson, but
wait, before you do that,
sounds okay.
You're jumping ahead of Mr. Johnson.
I said I didn't want to, and I went ahead and did it anyway.
That's okay. You told us about household service losses from the beginning of this scenario, March 2nd, 2020, until a year from now. Are you including any loss of household services in that future work life?
I'm not.
And why not?
Well, household service losses are a little bit different, or household service activities are a bit different. You can sometimes do household services even if you're somewhat impaired, but of course, you're kind of your own boss in that regard. You might be doing them more slowly, somewhat less efficiently, somewhat less effectively. Nobody's there holding you to account particularly. You don't have to worry about meeting everybody else's expectations in the office, or especially with your supervisor or your employer. So it is not automatically inconsistent to say, look, post surgeries, post rehabilitation, on the household service side, I'm assuming that she would be sufficiently recovered that she could do household services. And she, of course, could also do some work in the workforce in these administrative type positions, or these, or sort of halfway between a somewhat higher administrative job and the nursing, which is just 35,000. So there's nothing inconsistent about having zero future household service losses and still having her being able to earn some amount of income.
So her future loss under your calculation, assuming that she went back to work and got a job commensurate with her education. By the way, what is her level of education?
Well, she's got a high school diploma, but she also has quite a few additional certifications. I mean, she did quite a lot of other things, educational, and having been a professor for many, many years, I know there's some sad circumstances where students, either because of academic reasons or financial reasons, and Georgia State's been making major efforts to sort of prevent these things from happening, but there are a lot of people who end up with, let's say, some college, no degree, but they've taken some post-high school courses. She is certified as a patient care technician, as a certified nursing assistant, as a master cosmetologist. She's got other, Atlanta Technical College she attended, and she achieved these certifications. And so I consider that roughly about the equivalent of an associate's degree type of educational background.
So I sidetracked myself, but I wanted to make sure we got that in the record.
Oh, that's fine. That's fine.
So you've calculated, assuming she goes back to a job a year from now in the $35,000 range, ish, right? For the rest of her career, that the future losses would be $698,224. Is that right?
That is correct. That is
so. What number do you get if you add that future loss number to the number you gave us for past losses of $291,010?
Okay, that total number, including wage losses and fringe benefit losses, is $870,460, $870,460. Again, that's the net. That's the difference between what she could have made at the higher paying job in property management and what she's likely to make in these other types of administrative jobs.
Now, I want to ask you about the few of the assumptions you made in your report, and I think you've addressed most of these, but let's just be sure.
Can I just make one quick observation?
Please.
I just should say for the record that if you add then the past up to 1 year from today, household service losses, just to get this straight, you'd add also that previously discussed 45,998 that I talked about on household services. So the total losses in my report, which would be earnings losses past and future, household services past up to 1 year in the future, adding all that together in this scenario is 916,458, 916,458.
Thank you very much.
And that's just a little bit higher than the figure I just gave you a moment ago of 870,460 because it includes the household service component, not just the earning.
I understand. Thank you.
Okay.
I want to just ask you about some assumptions you made, and so we're clear on them. One assumption is that if she is going to start back to work, it won't be tomorrow. It'll be a year from now. Why did we make that assumption?
Well, because as I understand, the doctors who are working with her, and based on the likely rehabilitation period of like 6 months to a year, and when the likely, let's say, knee replacement would occur, and she's already sort of working on trying to get rehabbed on the ankle fusion, it just doesn't seem likely in that time frame that she'd be able to effectively return to work prior to that period. So 1 year from today is both convenient, but also reflective of the timetable, as I understand it, regarding the surgical procedures and the typical rehabilitation period. That's why I did that.
The next assumption that you made in your calculation was how much she'd be earning a year from now if she couldn't do her old job, but she could do a job that her resume and her education level suggest that she is capable of.
Right.
And you chose the figure, what, 34,000?
35, well, it was $34,424 in 2021 dollars, but projecting it out to that period when she starts in 2023, it's 35,513.
Thank you. The next assumption you made is that Ms. Daniels would work until age 66.5. Is that correct?
Yeah.
But if you look on your report, if you turn to page 5 of your report, there is a discussion in there about stopping work at age 61.5. And if I could just get you to help us understand why there's a number 61.5 for stopping and why you used 66.5. And then I'm going to ask you whether that makes much of a difference.
Okay, thank you. All right, well, first of all, economists have to try to tailor their analysis to the specific case at hand. For example, in cases where somebody is very, very young, doesn't have an earnings history or any record of having really been in the workforce because they're just too young, then you very much focus on these sort of statistical results. If you look at sort of labor statistics and do statistical analysis of them, and these things get published and economists read these and review them, and I'm familiar with all that literature, just statistically, a person with her level of education as a female and her age would typically have a years to final separation from the workforce. This is a terminology that is a little bit awkward, but it means something that you and I can understand, I think, pretty easily. What's the typical age at which a person would just leave the workforce and stop working completely? Okay. And that is not exactly the same thing as what's called a work-life expectancy. A work-life expectancy does take into account the possibility that over that period of time, like age 66 and a half, they might be between jobs, they might be unemployed, they might be only working part-time, they might have various ebbs and flows we're all familiar with in terms of how life works. And so, you want to take into account both things. So what I've done, and I've mentioned this a couple of times, is I've said that I didn't use the actual earnings history results that I could have used for her potential earnings in property management. And again, I'll just repeat this one last time. In 2019, she actually made in 2020 dollars, $69,278. As early as 2015, she had made in 2020 dollars, $70,023. I didn't use anything like that. I basically used 63,604. Now, one reason I'm using a lower number like that, and I'm comfortable using a lower number like that, is because it is a kind of adjustment for the fact that as you're going to age 66 and a half, you might not be working full-time all the time. You might be between jobs. So, the typical adjustment that one makes for the work-life expectancy is incorporated in my 63,604 figure. I might just say one last thing. I think sometimes these statistics, and they're valuable to economists, but you have to understand certain limitations as well. Female work-life expectancies at whatever age and educational level are still somewhat lower statistically than males. And that might be accurate for certain people, but in general, I think is a bit unfair to females sometimes, because there are females who are very much actively engaged in the workforce and basically doing the same kind of work as men. And so if you use males instead of females, again, I would get more than 61 and a half. It'd be like 63 and a half. But in general, I really am looking at the fact that I'm aware that her involvement in the workforce was quite stable for about a 15-year period from previous employment, and been stable at HSI. And so my best judgment doing this very often is to say, yes, there is a distinction conceptually between what's called a work-life expectancy and years to final separation. But I believe that I have factored that in. One might dispute, have I factored it in exactly the same way that another economist or every other economist would do it? I believe that most economists would be very sympathetic to the way I've done this. But the point is, I have factored that distinction into my calculation.
So can you tell the jury how much difference there would be if you calculated her total earnings, assuming that $35,000
Yes.
your starting salary a year from now, through 61.5 versus 66.5, and why that involves slightly different calculations?
Okay, well, here's what I can tell you. Let's say that I went only 61.5 rather than 66.5. But I also recognized, as I've said so many times here, that she actually had made as much in her most recent year, the literally most recent year of her work prior to the accident. She made about $69,000 in 2020. If I had used a higher figure over a fewer number of years, it partly offsets, but not entirely. The result I would get in that particular case is just slightly about 3.5% lower. Instead of the 870,460 figure, which was what I testified is the past lost earnings plus future net lost earnings. In that case too, where she's able to earn something starting a year from today. That was 870,460. This number would be 839,218. So it'd be modestly lower. It'd be modestly lower. It's not a huge difference. It is a slight difference when you do it that particular way.
So let me wrap this up just to make sure that I know the two key numbers here. The number that you give for total losses from the date of the crash until 1 year from now, assuming that she should be awarded those losses, is $291,010.
It's $291,010, assuming that 1 year from now she can go back to her old.
So, okay. If you assume that she can go back a year from now, but at a different job.
Correct.
As you've testified about, her total losses, past plus future, 916,458. That correct?
Including the household services.
Including household services.
916,458. That is correct.
Thank you, sir.
Thank you.
Ms. Arnold?
Thank you, Your Honor. Good afternoon, Dr. Seaman.
Arnold.
Hasn't been long since I deposed you for the second time, less than 2 weeks
Seems like
ago.
only yesterday.
Doesn't it? Because that was fun, wasn't it? And we took a second deposition.
Loosely, yes.
We took a second deposition of you because you issued a new report in this case dated August 23rd, 2022, right?
That's right.
And in the new report, you offer a new opinion, correct?
That's correct.
Okay. Dr. Seaman, you'd agree that your job as an economist is to make defensible calculations linked to factual realities in a particular case.
Yes, I can go along with that.
Okay. Well, those were your words, actually.
Oh, good. You were very eloquent.
It's also your job to provide testimony that's helpful to the trier of fact, which is the jury in this case, right?
Correct.
Okay. You'd agree that your calculations are based on assumptions.
Yeah.
Factual realities can differ from assumptions. True?
It is not unlikely that in situations, especially where there's medical issues involved and possible improvements that are not 100% certain, there are some range of feasible outcomes. Yes.
Right. And if you become aware of factual realities that differ from the assumptions upon which you've relied, you have a duty to the triers of fact, in this case, to change your calculations accordingly.
I would feel an obligation to assist the jury in reaching a determination because that's my job.
Okay.
I'm
And that's
not
what,
advocating about anything. I'm trying to apply sound economics to assist the jury.
right, because your job is to assist the jury.
That is correct.
Okay. Your first report is dated September 12th, 2021, correct?
Right.
All right. And in that first report, you valued the first economic loss scenario that you and Mr. Johnson discussed, which assumes Ms. Daniels is unable to return to work in any capacity ever again, right?
Correct.
That's case one.
That's case one.
Okay, and that is based on Mark Yeager's opinion that she is incapable of any form of sedentary employment, right?
Correct.
Okay. That opinion also assumes that Ms. Daniels will continue to incur some percentage of household services loss up through age 78, right?
That is correct.
Okay, and that's about 33 more years.
That's right.
All right. In this new report, you offer a second economic loss scenario, which puts Ms. Daniels back to work at a sedentary capacity as of September of 2023, right?
Yes.
Okay, next year.
Yes.
That opinion also terminates her lost household services needs as of September 2023, regardless of whether she goes back to work, right?
Yes.
And you just talked about that.
Yes.
So that number is $45,000 regardless of whether or not she goes back to work.
Yeah.
Okay. Next September, she'll be 46, right?
Yes, 46.
This new report accounts for the factual realities that differ from the assumptions that you relied on in your first report, right?
There was that, and there was also different discount rates, but that was a technicality in terms of how the present value was calculated. But I understand your point and I agree with it. There were different factual realities as I understood them.
Right. And you mentioned discount rates. Discount rates can change from time to time as well, correct?
They can.
And if they change, they affect your calculations,
They
right?
can, yes.
Okay. You told me at your deposition that it is no longer defensible to assume that Ms. Daniels has no remaining earnings capacity. Do you remember that?
I think I said that was the less likely case, and it's not the one that I would focus on today. That was the case one. But
Okay. A low probability.
low probability, I think, was what I said specifically. Yes.
Okay. Well, you specifically said it wasn't defensible either, didn't you?
Well, I think maybe a few lines later, I said low probability, but I'm not going to dispute that.
I
Your
won't pull out the
recollection may be better
transcript.
than mine.
I won't pull out the transcript. Okay, so let's talk about case two,
Okay.
since that's what you're focused on here,
Yes.
to talk to this jury about here today. So case two is based on defense expert Peggy Freeman's opinion that Ms. Daniels is capable of sedentary work, at least as of last year when she evaluated Ms. Daniels, right?
Yes.
Okay. But your case two scenario addresses Ms. Daniels' ability to work in September of next year, right?
That's right.
Okay. And Ms. Freeman hasn't seen Ms. Daniels since November of last year, right?
Yes.
Okay. So you are assuming for purposes of case two that Ms. Daniels will only be capable of a sedentary position as of September 2023, right?
That's right. But I'll just say for the record, remember that I did factor in the possibility of this nursing job, which is not really sedentary. I mean, you can easily imagine that nursing assistants are not really just sitting down at a desk. They're running around assisting patients. The earnings there was about 31,000 in Metro Atlanta. So I didn't, and you'll recall in my deposition, I did make this point, Ms. Arnold, that I don't automatically limit it to sedentary. She has training in nursing, and that's a non-sedentary possibility. Not every non-sedentary job that she would be likely to possibly be able to get is higher paying than the case that I have examined, which is more like 35,000.
Right. And the only jobs you chose to value in this report are sedentary positions, right?
Yes, but again, had I used nursing, which is non-sedentary, I would have higher losses because I'd be using a lower amount for her alternatives starting 1 year from now.
Okay, and let's talk about that for a second. So the specific job position you mentioned was nursing assistant or orderly, right?
Yes.
Okay. And that's a job that you believe Ms. Daniels would be capable of working come September 2023 based on her qualifications, right?
Yes, in fact, she's a certified patient care technician and has a certified nursing assistant CNA qualification. Yes.
And those people are on their feet all day, aren't they?
Pretty much, yes.
Okay. And the job can include lifting, transferring patients
It
from
can.
time to time. Okay. Pushing patients in wheelchairs.
Yes.
Okay. I suspect that's considered medium or maybe even heavy duty work. Wouldn't you agree?
It's possible, yeah.
Okay. So if you agree, Dr. Seaman, that Ms. Daniels would be capable of performing that type of job upon her recovery from these surgeries, why can't she go back to work as a property manager?
Well, as you know, I'm not really opining whether she can or cannot particularly. As you correctly point out, it's Ms. Friedman's position that the primary alternative would be sedentary. And I didn't use the nursing, but I agree with you completely that nursing is not sedentary. The point I'm just simply making is that there are non-sedentary positions that can in fact pay even less than the sedentary position. So I continue to not really be opining on any medical issues here.
And no expert has, nor can they, give an opinion as to what her condition will be a year from now, right?
I think that's absolutely correct. Yes, there's certain degrees of uncertainty there. Physicians can be optimistic or they can give some degree of prognosis, but nobody will know with 100% accuracy at this point. No.
And you've read and relied upon the testimonies of the surgeons who have and will perform those surgeries.
I have.
Okay. And according to those doctors, the goal of both of those surgeries is to alleviate the difficulty she has with standing, sitting, and walking, right?
Correct.
Okay. You even state that further rehabilitation will improve functionality, right?
Yes.
Okay. And improved functionality can improve her ability to work.
Yes.
Okay. So if the surgeries do in fact alleviate the difficulties she has with sitting, standing, and walking, she should be able to work in a job that requires her to stand and walk at times, right?
Yeah, I mean, my understanding is that those are possibilities, but that the actual likelihood of returning to exactly the kind of job she had, either with that particular employer or even somebody else doing similar kind of duties, is low. But as you know, I've already testified today about the possibility of returning to such employment 1 year from today. So it's not something I have discounted out of hand.
The truth is no one can rule out her ability to go back to her prior job at this point, right?
I think that's right.
Okay. You agreed and earlier, Dr. Seaman, that if the surgeries go as planned and Ms. Daniels can go back to her prior job, then your future lost earnings cap number would drop to zero.
The future would drop to zero as of the time that she returns. And so the number that I'd given you today, that $291,010 number, has that particular date at which she returns potentially to her prior employment as 1 year from today.
And that's a great point you raised, because if she were to return to work sooner, sometime before September 2023, your number would drop.
It would drop. I think given the rehabilitation schedule, as I understand it, and again, I myself am not a physician. I mean, I'm a doctor, but a PhD, not a medical doctor. You know, I'm trying to cure some gaps in the knowledge of students. That's as far as I go for curing. But in general, it doesn't seem consistent that she could return to anything really, given the rehabilitation schedule as I understand it. But again, that is a judgment for the doctors to make, not for me to make.
Right. Okay. So let's talk about past wages. As an economist, you've pointed out it's not your job to referee or take sides between the two functional capacity experts in this case, right?
Right.
Okay. It's not your job to say who's right or wrong about Ms. Daniels' ability to work.
Right.
All right. But you've only chosen to value Mr. Yeager's opinion with regard to past wages, which assumes that she has been unable to work in any capacity over the past 2.5 years, right?
Well, I say yes, but could I just clarify slightly? I think you'll remember in my direct testimony when asked by Mr. Johnson that what I'm really saying about the past losses is that it is demonstrably true that except for partial 2020 up to the date of the accident, she has had no earnings. That I know. She has no earnings. Now, again, you're asking me, do I have an opinion of whether she could have had some earnings? All I know is she had medical procedures being done. There were descriptions of symptoms that the physicians gave when they decided she needed further surgery. And that's all I know. And I know that she earned nothing. And my calculations are based on the fact that she had earned nothing.
Right. That's the only scenario you included in your
That's right.
report. Okay. And then Mr. Johnson just had you do the math here for the jury about a scenario where she has continued to work from the date of this accident up through September 2023, right?
I don't think I was asked about the particular case that you're, if I'm understanding your question, if you're saying, is there a scenario where from the date of the accident, like the next day after the accident, she went back to work and continued working all the way to today? I don't think I've actually addressed that specifically.
That's not what Mr. Johnson had you calculate.
No.
Okay. At your deposition, you calculated a second scenario where she goes back to work a year and a half prior to your current date of September 2023, right? Remember that? We valued her going back to work a year and a half before your date of 2023 at a sedentary level position.
Yes, I think there were a number of hypotheticals you were giving me in that deposition. I'm not sure I remember all of them, but I know I was trying to address your questions and your concerns.
We explored some options about her returning to work in some capacity at some point during these 2.5 years, right?
I mean, if you're asking me, is it possible, or, could I do a calculation based on her doing some kind of work in some capacity prior to this 1 year from today case? I could certainly do that. I could.
Right. And we won't sit and do all those calculations today because there's multiple scenarios for what that could be. But the bottom line is this: if Ms. Daniels could have been working in some capacity at any point during the 2.5 years since this accident, your past lost earnings number of $172,000 would decrease.
Yes.
Okay. One thing you do include in your new report is a list of 3 jobs you've picked from a certain category of sedentary positions for which you believe Ms. Daniels to be qualified, right?
Yes.
Okay. And this was not based on any opinion from a vocational rehabilitation expert, correct?
Correct.
It was
based on
not
her resume, basically.
Well, I'll get there.
I don't want to jump ahead.
It was not based on any opinion from a functional capacity expert.
That's right.
Okay. Neither Friedman nor Yeager has recommended any specific jobs for Ms. Daniels, right?
That's right.
Okay. You, Mr. Seaman, Dr. Seaman, are an economist, true?
I am.
Okay. You are not an occupational therapist.
No.
You are not a functional capacity expert.
No.
You are not a vocational rehabilitation expert.
No.
You are not qualified to render opinions in any of those areas of expertise.
That's correct.
Okay. And you agree with me at your deposition that as an economist, you cannot determine what jobs a person is qualified to perform.
That's right. I think I testified today that this particular level of about 35,513 happens to be about midway between a broader category of all administrative, including customer service, and these nursing jobs. It sort of fits between there. And it happens to be related to these particular 3 that I know you're asking me about now, which was.
Right. And I will ask you about those now.
Okay.
You picked 3 jobs: switchboard operator, telephone operator, and bill and account collector based on what you saw in Ms. Daniels' resume, correct?
Correct.
All right. Isn't it true that she's never actually worked in any of these specific jobs?
Well, these were activities that she identifies as part of her responsibilities in jobs that she had with specific employers. If you're asking me, has she ever claimed that a particular job she had was switchboard operator or telephone operator, I'm not aware that she claimed that. But if you look at the actual, you're all familiar with resumes and how they work. You sort of identify an employer and what kind of jobs you were doing, and then areas of responsibility or activities. And so I'm looking at what she actually had done. And so.
Okay. And in fact, what she actually has done in specific jobs she has had include medical records reviewer,
Yes.
medical assistant / laser tech, enrollment processor / administrative assistant. Yes. And administrative assistant / buyer, right?
Yes.
Okay. You didn't choose any of those jobs that she's actually worked before to use in your calculations. True?
True. But again, you have to sort of also recognize in terms of, the data that's available on wages in the metro area or any other area has to do often with these descriptions of what you're doing. So sometimes that particular job description may not have specific data, but you'll also recall, I'm sure from our discussion in the deposition, that I readily conceded to you that if you broaden to all the administrative in that database that you and I are familiar with from the Bureau of Labor Statistics, you could get possibly this 40,000 figure, which I've mentioned several times already today.
I'll get there, Dr. Seaman.
Yeah.
But my question to you was, you did not pick any of the jobs that she actually has worked in the past and look at those annual salaries and calculate those numbers to assist the jury here today. You did not do that.
I did not. I don't think there'd be a big difference, but I did not specifically know.
Okay. You could have, as you point out, could have considered the average annual salary for all office administrative and support occupations across every possible category, which as you know, is $40,000, right?
Yes,
Okay, but you didn't include that scenario in your report, right?
I didn't do it in the report. I did discuss it, as you know, in the deposition.
You chose a salary that was lower than that average of all those positions, right?
Lower than that average, higher than the nursing, orderlies, and assistants.
Okay, and you agree that there are hundreds of jobs that fall within the broad category of jobs for which you believe Ms. Daniels to be qualified, some with higher salaries and some with lower than you chose.
I think that's right. Some with higher and some with lower, and that's sort of where I was with my 35,513.
Right, so you could have picked 3 different jobs based on the same skill set, which have higher salaries than the 3 select jobs that you've chosen.
I could have. I guess I could have given a dozen scenarios, and I guess the question really is, at what point does it cease being particularly helpful? As you know, in my deposition, I was fully cooperative in discussing with you the implications of using the 40,000. So, I mean, if you wanted me to have, instead of 2 scenarios, or this primarily, this primary scenario starting a year from now, you wanted me to have 12 scenarios, I could have done that. And I would have then taken the average of that, and it wouldn't be very different from what I've already testified about today.
The bottom line is this: if things play out as we hope, and Ms. Daniels goes back to work sooner or at a higher paying job than the 3 jobs that you have picked, your estimated future lost earnings will decrease.
That is correct.
Okay, and if she goes,
yes, I'm sorry.
that's all I needed. And if she goes back to her prior job or a job with comparable salary or higher, her future lost earnings drop to 0.
As of the date that commences.
Okay.
And again, I've already given you this number of 291,010. If, as of a year from today, she not only has no future household service losses, but she also has no further earnings losses. So we've covered that.
Isn't it true that you've never met Ms. Daniels?
That is correct.
Okay, you've never even seen her before today.
That is correct.
All right, you've never even spoken to her before today.
That's right.
All right, if you had, that would have been noted in your report.
That's right. This is not unusual, by the way. I don't normally get overly involved in a particular person. I don't want to get overly involved in it personally unless I have specific information that I need. And I usually get that information by posing inquiries through the attorneys that she's working with, or at times a phone interview will take place.
No phone interview in this case, right?
Not that I can recall now.
Okay, and if you did have a phone interview, it'd be listed in your report.
Yes, I would be careful to do that. Yes.
Okay, and it's not in your report. All your communications have been with her lawyer who hired and paid you in this case, right?
Yes.
Okay, and you've been hired and paid by lawyers to provide opinions at least 483 times in civil tort matters over the course of your career.
Sounds low to me. But I imagine that's about right. Did I say that?
Maybe it's
is that
up.
something I told you in the
Maybe it's higher than when I took your deposition.
Yeah.
Dr. Seaman, it's my understanding that the Federal Reserve Board meets Tuesday and Wednesday of this week and will announce another increase in interest rates.
Yes.
Okay. As an economist, what will an increase in interest rates do to your discount rate and the resulting loss estimate?
Well, if it translates into higher treasury bond yields or high quality CD yields, which it's likely to do, although even given the recent increases we've seen from the Fed, there still has been some fluctuation in these treasury yields and CD yields. But I know where you're going with this. If in fact there's any further increase in the discount rate, the present value of future losses would decline. Typically it would be within a reasonable, it would not be huge, but mathematically, the higher the discount rate or the higher the yield you can get on safe investments, the less you need now to grow to those future numbers. That's the concept.
Okay, and the end result would be another decrease in the numbers that you've proffered to this jury here today.
That's right.
Okay, thank you, sir.
Thank you, ma'am.
Mr. Johnson?
Thank you, Dr. Seaman.
Thank you, Mr. Johnson.
Jurors, any questions for Dr. Seaman about the discount rate or anything else? If you do, just get a note card, write them down. It's on. Were you having trouble hearing him? Oh,
It's got this fun little thing on it. I didn't know if that was.
that's for your health and safety. No, that microphone works. Thank you for flagging that. It has to do with the If that monitor is unmuted, then we all know because it starts to sound real unpleasant. Okay, any note cards? Nope, okay. Thank you, Dr. Seaman.
Thank you. Thank you. They were even more attentive than my students, so that's impressive.
Mr. Johnson, your next witness.
Yes, I'm going to let my partner handle the next witness, Judge.
Okay, whoever's going to handle it, that next witness
Just
is,
let me handle the first ones, is maybe a better way to say it, but.
okay.
Your Honor, next we're gonna call Imani Sermons.
Okay, about how long do you ask? I'm only asking, we're gonna take our afternoon break. And if it's a witness who won't be on too long, we'll do one more witness then break. If Ms. Sermons is gonna be a long time, we may break now.
Your Honor, I don't think terribly long, but I would appreciate it.
You'd like to break first?
Yes.
Okay, well, why don't we do that, ladies and gentlemen? Again, we only go till about 5, so we'll take a break. Let's try to be back. I'll try to get Deputy Gordon to get you back in here around 3:20, 3:21, about a 10-minute break. Enjoy the real estate back there. Don't talk about the case. You can talk about carpooling, but not about the case. And we'll see you in about 10 minutes. All right, you all can be at ease. It does seem warmer in here now.
Yeah.
Like the AC stopped working. What does the thermostat say back there?
73.1.
No, I don't know that one works, but all right, it's still low, but it does seem warmer. And several of the jurors are fanning themselves. So, and you've got a whole nother jacket. So if you get cold, Ms. Brown, you got a whole nother layer. I see that. All right, I'll look into that. Mr. Johnson, anything we need to get on the record before we break?
I don't believe so, Judge.
Ms. Arnold?
No.
Okay, see everyone in about 10 minutes, please.
Georgia?
Yeah. Hey, Jean. Hey, Shane, hey, Anna. Hey, Ray, hey, Tyler. Yeah. Still twisting and turning, right? That's what I do. I said, I keep reading I read the note, but I still pull it.
Phillips is old and like, surely
I
it's not
know.
still.
When I first seen it, I'm like, nah, that's not true. Even though it said turning, I was like, nah, that can't be true. Oh my God, okay. Sweetie. Did they touch that thermostat?
I feel air, so they might have.
By 0.2 degrees.
Okay. Thank you for being so precise.
I don't know how much difference that.
Cause I get cold quick.
Me too, that's how
Yeah, I get cold quick. I don't like air. I mean, I'm a July baby, so I like when you can't breathe hot weather. Sorry, that's just me. That microphone don't do me no good. I really can't hear. Jackie, do me a favor. Give them that mic.
So what they're doing, you're not, they just.
It might be just.
My check.
Say it again? See, I didn't hear it.
Oh, wow.
Huh?
They're just not speaking.
Did you see it somewhere?
That's what I need them to do.
I guess
though.
you was
For real,
always
for real.
out.
Okay, so it's not me, it is working. I can't hear. Yeah, and you know what, it's. Time is right there.
Oh, it's gonna give these back.
Okay. You got somebody else coming? It's a new witness, right?
Hey, Brandon. Okay.
Yes.
I'm gonna suggest.
Jack.
I'm gonna suggest.
Mr. Jackson.
And then, because we're running ahead. Pace go damn fast. What I'm gonna suggest is. We do, this is the bar. After that, we play Dr. Payne's video.
Yeah.
And then we pick it up with mom in the morning.
Okay.
And then the last three videos, and then Jame's. And then maybe we've got another, we're not going to, but, you know, we're gonna call Jame's and if we want, you know, you know, you go with. So that's my suggestion.
Yeah.
It may, and it's a little 4 or 5, a little bit, you know. But anyway, do you have a problem with that? That's narrow.
I figured that's probably what you guys.
I just would rather like one doctor, just pick this up in the morning. I'm a little. I have the times on all of it, and I think hers is about the shortest. It's like 35 minutes.
Cause the only thing I'm saying, I'm a grateful doctor, he just makes another video. To fill the time, but I don't care.
I don't see why the word, but do you have a list of exhibits that shows how much time you try to? Here. Good.
Set it away.
Dr. Payne? Okay. It's 33 minutes.
Welcome to work, nice to see you.
Can we take up something real quick?
That's what I was just going to ask.
Oh, look at that.
Yeah. All right, Ms. Brown, you ready? She's ready. All right. Yes, Mr. Johnson, before we bring the jurors back in.
Thank you. Ms. Arnold and I just had a discussion about timing. And we are, that is to say, I am running quite a bit ahead of schedule. This evidence for the whole case should, I would think, be concluded by tomorrow, which is day 2.
Your evidence.
My evidence.
Okay.
I don't know how much MARTA has, but I suspect that we can get all of the evidence in by tomorrow, easily.
Okay.
Your time is spare. My suggestion would be this. We are going to call the plaintiff's daughter to testify now. That won't quite really get us to the end of the day, but we have one doctor video that runs a little over a half an hour. And what we would like to do is call this live witness, play one video, it's a little over half an hour, pick it back up in the morning with Miss Daniels' mother, and then the last 3 doctor depositions and then Miss Daniels.
Okay. So go
Might
as,
result in us leaving a little early today.
okay. So go as late as we can today with daughter and one doctor.
Well, we can finish that. I'm telling you, we will finish that. And if we finish that and it's before 5, we were talking and it would be an appropriate time to break and pick it back up in the morning.
Okay. Ms. Arnold, thoughts about that approach?
I told Mr. Johnson I'm fine with that.
It sounds like the plaintiff may rest midday-ish, maybe a little after lunch tomorrow. I'm not holding you to that. If things take longer, they do. But based on what you've described, we're heading in that direction. How long do you think the defense presentation will take if there's going to be one?
If there's going to be one, Judge, we would just have one witness.
Is that Ms. Friedman?
Yes, sir.
Okay. So you could see resting tomorrow as well.
Yes.
Okay. I don't have an issue with that. So let's do it that way. I'm not going to tell the jurors the exact plan, but at least I'll know that when Ms. Daniels' daughter is done, I'll explain a little bit how the depositions will work. And we're going to start with one now, and hopefully they get through that. And then we'll wrap for the day.
So we're actually one live now, right? And then one video. And that's, yeah,
Correct.
right.
Okay.
Okay, thank you.
Great. Can you be getting the next witness in this direction while we get the jurors in? And she can just wait right there, but let's bring the jurors in, please. The witnesses? Okay.
Yeah, and I can hear you on this, but that mic is
Not picking it up. Okay.
not at all.
All right, juror.
All right, everyone can be seated. Welcome back. Let's call plaintiff's next witness, please.
Plaintiff calls Imani Sermons.
All right, Ms. Sermons, this way, please.
Imani Sermons, E''MANI, last name Sermons, SIRMONS.
Ms. Sermons, I need you to move closer to the microphone. The chair does not have wheels, so you have to kind of heave it forward, but that way you don't roll off the witness stand. And then when you're answering, if you could just be a little closer to the mic, everyone will be able to hear you better.
Can you hear me?
Yeah, but you have a soft voice, which is great. But we're in a space where you're going to want to, like you're fussing at someone. You can be nice, but just a little louder so that things are coming out so that that gentleman way in the back of the courtroom can hear you.
Or this one.
Yep. Or that guy too.
SIRMONS.
Okay. And you can bend the microphone up so it's closer to you. Great. All right. We'll see what happens when you're ready.
Good afternoon, Imani. How are you?
I'm good.
Okay. I'm going to start just asking you again to introduce yourself to the jury.
My name is Imani Sermons.
How do you know Ms. Daniels over here?
It's my mom.
Do you have siblings?
Yes.
How many siblings do you have?
2.
And where do you fall in the line of your siblings?
The oldest.
Okay, so you're the oldest of 3.
Yes, ma'am.
Do you know that your mother was involved in a collision with MARTA?
Yes, ma'am.
How did you hear about that incident?
I learned about it from my grandmother.
Where were you when you found out?
Home alone.
And what did you do when you found out about it?
I called my brother and told him about it. He informed his football coach and he volunteered to take my brother and my sister to the hospital as I was on my way.
And your brother and your sister, were they elementary, middle, high school?
They were in high school.
Both of them?
Yes, ma'am.
Were you able to get to the hospital?
Yes.
Was it that day, that same day?
Yes.
When you got to the hospital, were your siblings there?
They met me there.
Were you able to go into your mother's room?
Not immediately, which has scared me because I just wanted to make sure my mom was okay. But eventually they allowed me and my sister to go back.
When you went into your mother's room, what did you see? Describe what you saw when you walked in there.
When I walked in, my mom was covered in a blanket and they had a neck brace on her.
Were you able to speak to her?
Yes,
Was she able to speak to you?
yes.
You recall what she said to you?
She told me she loved me.
Were you able to spend a good amount of time in the room with her?
No,
What happened?
we were rushed out.
What did you say that?
We were rushed out.
Rushed out?
Rushed.
What hospital was she in when you went to see her?
Grady?
Did she spend her entire hospital stay at Grady?
No.
Where else did she go?
Emory?
She was transferred to Emory?
Yes, ma'am.
While she was at Emory, were you able to visit her?
Only one time.
Why only one time?
Due to COVID.
What about COVID? Did they limit visitations because of COVID?
Yes.
Was your mom eventually released out of the hospital?
Yes.
Okay, and when she was released from the hospital, where did she go?
To my grandma's house.
While she was at your grandmother's house, were you able to see her?
No,
Why not?
because my grandma has health problems and COVID would interfere with it.
When were you finally able to see your mom?
At the end of May, when we got ready to move to Texas.
When you saw her at the end of May, when you got ready to move to Texas, was she walking?
No,
How was she getting around?
in a wheelchair.
Why were you all getting ready to go to Texas?
So she can do physical therapy.
Do you have family in Texas?
Yes.
And what family members did you have in Texas at that time?
My grandpa and my aunt.
Okay. Did you go to Texas with her?
Yes.
When you all were in Texas, did you see your mom trying to walk again?
Yes.
Did you see her trying to cook and kind of do the things that she used to do?
Yes.
When she tried cooking, did you have to help her?
Yes.
How did you help her?
She would tell me what she need to cook whatever, like the seasonings or the ingredients, or maybe like utensils, and she'll tell me how much to put in, what it is I need to cook, or help her get things that she couldn't reach.
Was she walking around the kitchen at that time?
No.
Okay. How was she getting around at that time?
In the wheelchair.
So when she was telling you to grab items and ingredients, she was in a wheelchair telling you to do those things.
Yes, ma'am.
Did you have to help her, or did you help her relearn how to dress herself?
Yes, ma'am.
And how were you helping her with that?
I would help her put her clothes on her.
Did you eventually come back to Georgia?
Yes.
Well, obviously you're here. When did you come back to Georgia?
I came back at the end of June.
Okay. At the end of June of what year? What year are we in now?
2020.
2020. Okay. Did your mother come back with you?
No.
She stayed in Texas?
Yes, ma'am.
Who did she stay in Texas with?
My grandpa.
Did your mom eventually come back to Georgia from Texas?
Yes.
Why?
After my grandfather's passing.
When your mom came back to Georgia, were the two of you living in the same home?
Yes, ma'am.
Now, when your mom came back to Georgia and the two of you were living in the same home, did y'all take any trips together?
Yes, ma'am.
All right, let's talk about some of those trips. Tell us about the first trip that you and your mom were able to take.
She surprised me to Vegas for my 21st birthday.
Okay. You said she surprised you, so you didn't know what was happening?
No, ma'am.
So tell me about it. 21st birthday, you wake up. Tell us about it.
She woke me up I didn't pack a bag. We just went to
Just speak up.
I said I woke up. I didn't have a bag packed. We went to the airport. I pushed her around because she couldn't walk through the airport, so I pushed her around in the wheelchair. When we got there, she had a scooter rental, so that's how she would get around.
And when you say when we got there, where are you talking about? The airport or Vegas?
Vegas.
Okay, so when you got to Vegas, she had rented a scooter to get around. Is that what you said?
Yes.
Okay. All right, keep going.
She rented a scooter. It would be some things that I would do on my own because she couldn't come with me because of her scooter. But when we would leave the room, she'll be in her scooter. I'll walk down the strip and she'll ride in her scooter.
Was there any point where your mom was not in the room where she did not have to use her scooter?
No.
Did you all take any other trips?
Yes.
Okay, tell me about it.
We went to Chicago to help my brother move out of college.
Okay, all right. Let's back up again. When this incident first happened, I think you told us that your brother and your sister were both in high school, right?
Yes.
So now we're fast forwarding. When your mom comes back to Georgia from Texas, at some point you all went to Chicago. What year was that? Do you recall?
2021.
2021. So by 2021, your brother had graduated?
Yes.
Okay. And you said to move back from college. What school was he going to?
Aurora University.
Aurora University?
Yes, ma'am.
Okay. So when the two of you were in Chicago to help your brother move back, did your mom actually help him move anything?
No.
And why not?
Because of her limitations.
Okay. So what was she doing while she was there?
She just stood around.
Kind of ordered everybody else around?
Yes.
Okay. All right. Did the two of you go anywhere else?
We recently went to Florida.
Okay.
Well, she went to Florida and I went to Houston at the same time she went to Florida. She was there for a day because she thought she could do it on her own, but she called me and I left from Houston to come to Florida to help her.
Okay. When she called you, what was she calling you for during that time?
Because she couldn't get around.
Okay. And when you say Florida, where in Florida?
Tampa.
Okay. So you left Houston and you went to Tampa. When you got to Tampa, tell us about how that trip went.
For me, I had a good time, but I was having to help my mom get around because she can't walk for a long period of time. She can't stand up for a long period of time. It's only but so many things that she can do on her own. So
if you can, the best you can, because the jurors don't know your mom. So the best you can, if you can describe to the jury what kind of person your mother was before this incident, before you got that phone call from grandma.
my mom was happy. She was happy. She's not happy no more. She's depressed now. She used to be able to take us anywhere we want. She still tries with what she can do now, but she's not the same.
Iman. No, turn it away.
Ms. Page, do you have any questions for Ms. Sermons?
Yes, Your Honor.
Okay, Ms. Sermons, you okay to keep going?
Yes.
Okay.
Good afternoon, Ms. Sermons.
Good afternoon.
It's nice to see you again.
You too.
You have a close relationship with your mom, correct?
Yes, ma'am.
And you all have always been close.
Yes, ma'am.
And you told me at your deposition that you all have gotten closer since this accident.
Yes, ma'am.
And you've always looked up to your mom, right?
Yes, ma'am.
And she's one of the strongest people you know.
Yes, ma'am.
And she's been strong throughout her entire recovery, right?
Yes, ma'am.
And you expect her to continue to be strong as she continues her recovery process.
Yes, ma'am.
And you're protective of your mom.
Yes, ma'am.
And you told me at your deposition it's because you feel like no one's going to look after her like you do.
Yes, ma'am.
And that's because she's looked after you and been such a great mother, correct?
Yes, ma'am.
In fact, even after her accident, when she received clearance to drive, she would drive you to and from work before you got your own car.
Yes, ma'am.
And in January 2021, you started working at, Ruchado Wings off of Fulton Industrial?
Yes, ma'am.
And your mom drove you from home to Ruchado Wings at the beginning of your shift, correct?
Yes, ma'am.
And that drive was about 20 minutes one way?
Yes, ma'am.
And would she return home until you got off of work?
Yes, ma'am.
And then she would drive back to pick you up at the end of your shift?
Yes, ma'am.
And she continued to do this from January 2021 until March of 2021, correct?
Till May.
Until May, okay. Did you start working at Zara at some point in March
Yes,
2021? Okay. So would she also drive you to work at Zara?
Yes, ma'am.
And that Zara was located at Lenox Square Mall?
Yes, ma'am.
And because of traffic, that could take anywhere from 20 minutes to 1 hour for her to drop you off at work?
Yes, ma'am.
And would it be the same for her to return and pick you up at the end of your shift?
Yes, ma'am.
Okay. And your mom continued to do that until June of 2021, correct?
May.
Until May, okay. And I understand that your mom recently had a surgery in June, correct?
Yes.
And your understanding is that this surgery is supposed to help eliminate some of the pain in her leg?
Yes.
And before her recent surgery, she was able to cook on her own.
Yes.
And she was able to feed herself.
Yes, ma'am.
And she was also able to do some chores around the house.
Yes, ma'am.
And as we already discussed, she could drive.
Yes.
And do grocery shopping.
Yes.
And your mom enjoys spending time with family.
Yes.
She's very family oriented.
Yes.
In fact, you said your mom's life revolved around you and your siblings and what you all were doing before the accident, correct?
Yes.
And you say that your mom's life still revolves around you all.
Yes.
And to this day, she does anything she can for you and your siblings.
Yes.
Including traveling to Illinois in August of 2021 to help your brother move into college.
Yes.
And taking you to Vegas to surprise you for your 21st birthday.
Yes.
And going back up to Chicago to help your brother move out of college.
Yes.
And even traveling to some of his football games up north. Is that true?
Yes.
Okay. And then you all also went to Tampa, Florida, right before she had this recent ankle surgery, correct?
Yes.
And another thing you all enjoy doing is trying new restaurants that you discover on TikTok.
Yes.
Okay. So all in all, you would describe your mom as a warrior.
Yes.
And you told me at your deposition that she's outgoing.
Yes.
And she likes to take care of the people around her.
Yes.
And she's made a lot of progress in her recovery.
Yes.
And she hasn't yet returned to work, correct?
No.
And she hasn't made an attempt to do so yet.
No.
But you're hopeful that she'll be able to return to work after she recovers from her recent and future surgeries?
No.
You're not hopeful that she'll be able to?
No.
Okay, thank you. No further questions.
Did you have any follow-up?
No, Your Honor.
Okay, any questions for the jurors for Ms. Sermons?
So sorry.
Don't apologize. That's what these questions are for. You just write it down. Got a couple? Thank you. Counsel? This way, please. I'll let you have If you hit the wall, just right. Two more questions, Ms. Sermons. You ready?
Yes.
Okay. Can you tell the jurors if you know, what the purpose of your mother's trip to Tampa was?
So she can get away.
So it wasn't to get treatment, therapy, anything medical. It was personal.
Yes.
Okay. Did your mom go by herself or did she bring people with her?
She went by herself.
Do you know how she got down there?
We traveled to the airport together.
So she flew.
Yes.
Okay. Do you know how she got around once she was in Florida?
She got through the airport using a wheelchair. Then she had a rental.
A rental car?
Yes.
Okay. And can you tell the jurors again why it was you and your mother went to Texas initially? Am I remembering correctly that soon after your mother, at some point after your mother was released from the 2 hospitals here, you all went to Texas?
We went there so she could do therapy.
Okay. Therapy as in physical therapy?
Yes.
Was there a particular reason that you went to Texas rather than stay here or go to Alabama or Tennessee?
Me and my siblings, we all went with my mom to Texas.
Okay. Do you know why Texas was the place that your mom went for rehab rather than some other place than Texas?
I don't know the answer to that question.
Okay, that's a fair answer. And could you tell the jurors again why it was you described your mother having to relearn certain things, like how to get dressed? Did she forget? She tell you, I don't remember how to get dressed? Or was it more physically, it's more difficult to get dressed than it used to be because of the injuries?
It was physically difficult.
And you helped her with that?
Yes.
Thank you so much. Ms. Adler, if you have any follow-up based on these, you should feel free, and then see if Ms. Page does.
Just one follow-up, when you all were in Texas, was your grandfather available to help your mom to and from her rehab?
Yes.
And that's all, Your Honor.
Okay. Ms. Page, anything else?
Oh, yeah.
All right. Ms. Sermons, I very much appreciate you being here and sharing with us what you did. Okay, you're free to go. Ladies and gentlemen, the next witness is going to appear somewhat virtually. There are a number of doctors who have been interviewed, examined by both sides in what's called a deposition. So it is a direct examination and cross-examination by these same lawyers. But sometimes we have witnesses whose schedules make it complicated for them to come to court. And so the lawyers agree, well, we'll do this questioning at a time that works for everyone, and it's filmed and preserved. And if there were objections made, I rule on them after the fact. So they'll show me the transcript and I'll say, all right, that part cannot come in because that question was a problem or that answer was a problem. But otherwise, it's testimony that you're free to consider, just as if the doctor were sitting right here. You will hear the questions that the lawyer asks and the witness's answer. The difference, other than having the witness here in front of you, is that you will not be able to do this. You will not be able to submit questions to the witness because it's not virtual in the sense that she's appearing over Zoom, in which case you could, and we just have that witness hold on and we'd work through the questions and then we could ask them. So it's a little less dynamic. You all won't be able to ask anything, but otherwise the questions that the lawyers wanted to cover are addressed by those witnesses. But it's a press play and you'll watch and listen, and it should appear on that screen right there. We'll make sure the audio is good. That's what's going to happen next. There may be a few more after that one, maybe not necessarily today, but I wanted you to know that it's a perfectly acceptable way of presenting evidence. And again, it's only what the witness says in response to the questions from the lawyer that is actually evidence. And you should give it no more or less weight just because the doctor isn't here today, but was subject to the questions of the lawyers a week ago, a month ago, whenever it was, they took the deposition. So I didn't mean to steal anyone's thunder or misrepresent anything to the jury, but it was my understanding that the plaintiff's next witness is in fact one of these doctors in this very format. Is that correct?
That is correct. Judge, this will be Dr. Diane Payne's trial testimony.
Dr. Payne. All right. Let's see. Have you tested the audio? It was pretty good when you tested it. Let's hope it stays that way. Thanks.
And Doctor, can you please introduce yourself to the jury?
I'm Dr. Diane Payne.
Dr. Payne, as you know, I represent Jame Daniels in this case stemming from a head-on crash with a MARTA bus back on March 2nd of 2020. And I'm here today to ask you some questions about your care and treatment of Ms. Daniels following that collision. Would you please tell the jury where you were working back in March of 2020 and what you were doing back then?
I was employed by the Emory School of Medicine and worked at Grady Memorial Hospital doing trauma care for upper extremity musculoskeletal injuries.
In addition to doing trauma care at Grady, did you also do any teaching?
Yes, sir. I did a lot of teaching for surgical residents and worked with several surgical residents in orthopedics as well as plastic surgery.
Can you tell us a little bit about your educational background and whether or not you have any board certifications, specialty certifications in medicine?
So I am trained, I did residency and fellowship training, residency training in orthopedic surgery and fellowship training in hand and microvascular surgery at Duke University. I'm board certified by the American Board of Orthopedic Surgery. I have a certificate of added qualification from the American Board of Orthopedic Surgery and hand surgery.
And you're licensed to practice medicine in the state of Georgia, and your license is on file with proper authorities?
Yes, sir.
Okay. You're no longer with Grady, is that right?
That's correct.
Where do you work now?
I work at Atlanta Orthopedic Institute.
Okay. Doctor, as part of your practice back in March of 2020, did you have an occasion to treat Jame Daniels?
Yes, I did.
When did you first see Ms. Daniels?
I saw her, I met her the morning of March 3rd, 2020.
And can you tell the jury what her physical condition was at the time you first saw her on March 3rd, 2020?
When I met her, she was in the ICU. She had suffered multiple injuries, and she was awaiting my consultation for care of both of her upper extremities, where she had sustained fractures on both limbs.
Doctor, we have marked as Exhibit 1 a surgical illustration that is over your head behind you. Can you see that?
Yes, I can.
I want you to tell us whether this surgical illustration accurately depicts the injuries that Ms. Daniels had to her arms and right wrist that you treated her for on March 3rd, 2020, and the subsequent medical hardware that was used to repair them.
So this depicts the injuries with the fixation that we utilize to basically put the bones back in the right position. And so what you see on the right extremity is a broken radius, which we refer to as the distal radius. She had a small fracture at the distal end of her ulna. On the left side, you can see that she had a fracture that affected her radius here and her ulna here.
And is this an accurate depiction of what you did and what you saw in Ms. Daniels?
Yes, it is.
And we're going to discuss the surgeries you performed in a few minutes, but for now, can you just help the jury understand about the metal hardware in both her left arm and her right arm and wrist in terms of which pieces of metal you put in and which ones remain and which ones you took out in a second surgery?
Okay.
Can you just point and tell us about that?
Sure. So on the left upper extremity, these metal plates were utilized to help align her bone and hold them in the right position.
And that's in her left arm,
Yes,
is that
sir.
right?
And those remain to this day. On the right side, we utilize several small plates that are very difficult to see on this diagram. You can see one along the edge here, you can see one plate here, and then we have a larger plate centered over the middle, and that plate, the larger plate, was taken out at a later date.
Okay, so that long strip of metal there on the right was removed in a second surgery that you'll tell us about.
Correct.
But then the other pieces of metal in her right wrist remain.
This smaller plate that you can see here on the edge of her radius was also removed at a second surgery.
And did you perform an initial surgery on Jame Daniels on March 3rd, 2020 at Grady Hospital?
Yes, I did.
Did you operate on both her right and left arms at the same time during the same surgery?
Yes, I did.
Were Miss Daniels' injuries considered by you as a trauma surgeon to be sort of routine, or were they unusually complex?
Her left upper extremity injury was routine and relatively straightforward to manage. Her right upper extremity, I would say, was more complicated and more difficult to manage overall.
And in fact, I understand from your prior meeting with myself and MARTA's attorney that you decided to use Miss Daniels' right wrist injury and treatment as a teaching aid. Is that right?
That's true.
Tell us about that. Who were you using, who were you trying to teach with it, and why did you think that Miss Daniels' case would be helpful in that regard?
Well, Miss Daniels came to me as a patient during a time where I was preparing a lecture for hand fellows who are training to be hand surgeons. And the task that I was given for that teaching conference was management of upper extremity fractures. And so she was a great example of a patient who had a fairly complex injury on the right upper extremity that I could use to help them, those trainees, to understand how to manage the fracture.
And I understand that you created a PowerPoint presentation, is that right?
That's correct.
Would that PowerPoint presentation be useful in explaining to the jury what Miss Daniels' injuries were, both to her right wrist and her left arm, and what you did to fix them?
I think it would.
Okay, why don't you show that to us and take us through the PowerPoint? And I don't know whether there's a point during that PowerPoint where you talk about the second surgery, but if there is, let's just stop just before that.
Okay.
Okay? See if you can turn that on and walk us through that.
Okay, so this initial slide just describes the injury pattern that Miss Daniels sustained, and she had multiple injuries, as mentioned earlier. She had a left forearm fracture, which we refer to as the forearm fracture, and we refer to that as a both bone forearm fracture because she broke both the radius as well as the ulna, as you can see depicted in the graphic. On the right side, she had what we refer to as an intra-articular distal radius fracture. And because of the nature of the fracture, because the fracture had a significant amount of what we refer to as comminution, meaning several pieces, the fracture displaced to the point where the wrist bones would displace off of the radius, and that is what we refer to as a carpal dislocation. She also sustained a tibial plateau fracture on the right, a calcaneal fracture on the right, and had multiple pulmonary contusions.
Let me interrupt you and ask you what those are. What's a tibial plateau fracture?
Yes, sir. So a tibial plateau is the lower leg bone. So this is a depiction of the tibial plateau fracture. This is a tibia bone, and the plateau is what we refer to as the surface, which is the weight-bearing surface of the tibia.
All right. And the
calcaneus is the heel bone, what we refer to as the heel bone. And so this is a depiction of her.
And you did not do those surgeries?
That is correct.
Those were done by Dr. Moore?
Correct.
Is that correct? Okay, you only did the upper extremity surgeries?
Correct.
Okay, I'll let you continue with your PowerPoint.
So these are her injury films that were taken in the emergency room when she came into the trauma bay. And so this first image think there is a pointer here. This first image, I'll just use this, I think this will be better. So this first image depicts her right radius, and what you can see is this is her hand, and these are her wrist bones. This is the radius bone, and the wrist bones are basically moving off of the radius. And an easy way to think about that is the ice cream simply is falling off of the cone because there's not enough stability to hold the bones in the right position. So that's what we refer to as a transcarpal dislocation. And this is a depiction, I'm sorry, over here on the left, you can see that her wrist bones are falling forward.
So that's the same
It's
wrist.
Yes, sir. This is a right and this is a right. In the middle, you can see her left upper extremity, and you can see the fracture that she had both to her radius as well as her ulna. This is a CT scan. We often will get CT scans, which are basically high-powered x-rays that allow us to delineate the different pieces of bone that are broken. And so these can be very helpful for us in determining our treatment strategy.
Forgive me for interrupting.
So this is her right wrist, and this is what we refer to as a lateral image using a CT scan, and this is a video that we can play, that we scroll through the different images to be able to see the amount of comminution that's present in the distal radius.
Comminution means?
Fracture fragments.
So you're looking for fracture fragments in her right wrist with that CT?
Yes, sir. This essentially provides us with more or less a map of the pieces of the puzzle that need to be put back together in order to recreate her joint surface.
Okay.
Then we look, this is a lateral view, so looking at the patient from this direction, and we're basically slicing her in tiny little slices from front to back. So then we also look at it from what we refer to as a coronal view, which is looking at her from front to back from this direction. Again, multiple small slices. And then if we play this video, this shows as we progress through the fracture site, you can see she's got a fairly big piece here, but there are lots of small pieces associated with that. So with what we do in terms of fixation, there are lots of ways to manage these types of fractures, but the important thing with her fracture pattern is we need to provide stability because the bones of the wrist are trying to fall forward because of the amount of comminution that she had along this portion of her radius.
And again, you mean by comminution, you mean the number of little
fracture
pieces.
Fragments, correct.
Okay.
So the goal with the surgery is to try and restore her joint surface so that she can have adequate range of motion with her wrist into flexion and extension. So we use these small plates to help us restore the anatomy of the distal portion of her bone. And then this longer plate is added because the injury pattern here can create an unstable wrist. And so we use this plate to help stabilize the wrist by securing the plate on the back of her hand that lines up her wrist bones in the correct position and keeps them from falling forward. This type of an injury can be associated with ligamentous injuries in addition to bony injuries. And so this plate is a way to help manage the potential ligamentous injuries that can result. So in the left upper extremity was certainly more straightforward in terms of the management is simply to put the bone back into its anatomical alignment, and these plates are used to help hold that bone in the correct anatomic alignment while it will heal.
And then after it heals, as I understand it, the metal plates just remain.
That's correct. We don't typically remove hardware unless the patient is having some sort of a problem with the hardware or the patient has a fracture that hasn't healed, which means that would require a second surgery to try and stimulate bony healing. So these are her x-rays from her post-operative visit, which was actually about, I believe, 2 to 3, possibly 4 weeks after her surgery. So her left upper extremity, here you can see the plates that we placed in her forearm. Her alignment looks quite good here. We've restored her anatomy of the forearm, and that's really important because we want to be able to maintain rotation of the forearm. On her left upper extremity, what you can see is that we've tried to line up the articular surface of the radius so that she can be able to flex and extend her wrist once this plate is removed. So we get these pictures just to make sure that the hardware is in a good position and that everything appears stable after we put it in.
I'm sorry, is that the end of the?
That's the end of the PowerPoint.
Okay, thank you. Doctor, are there risks associated with that kind of surgery?
Certainly, there are risks associated with all surgery. The biggest risk that we worry about as surgeons is infection. Nerve injury is a possibility. We're operating around nerves and vessels. Non-union is not a risk per se of surgery, but it's a risk of the fracture not healing appropriately.
Did this surgery, in your opinion, go as well as could be expected?
Yes.
Okay. Now, I understand there was a second surgery.
Yes, sir.
And we'll talk about that. But after the first surgery, can you look at your notes and tell me when the next time you saw Ms. Daniels was, so we can talk about that?
So I saw Ms. Daniels in follow-up on April 17th.
Sure, that's what I show as well. How was she doing at that time?
I think she was struggling a little bit at that time. She was very apprehensive about moving. She had gone to an acute rehab, and it's unclear whether or not she was getting any therapy while she was in that rehab center, and so she was just very apprehensive to move her hands and move her fingers.
Well, let me ask you this, doctor. What is the typical reaction of a patient after having a traumatic hand or wrist surgery?
Well, that can vary based on patient personality. Everybody handles injuries in a very different way. Some patients can be very dramatic and fall into a catastrophic thought process, and that can make it very difficult for them to move forward. Some patients do incredibly well and fall into a pattern of, this is not going to beat me, I'm going to get better. And so it's hard to know how patients are going to do, but I think a lot of it is based on personality, in all honesty. I think after a traumatic injury where you have multiple injuries, I think it's very easy to fall into a pattern where you're afraid. You're afraid to move, you're afraid to walk, you're afraid you're going to do damage. So it's our job, I think, as providers to help patients understand that they need to move and they need to help themselves in order to get better.
During that April 17, 2020 visit, did you make a plan for her next phase of care?
I did. I got her to therapy, and we made a plan to come back to remove the plate that needed to come out on her right upper extremity.
And that was in June of 2020, that second surgery.
It was.
But before we get there, you mentioned that you got her set up with therapy. Do you have, before you, an occupational therapy note from, looks like Kennedy Hawkins on May 4th of 2020?
I do.
So that was a physical therapy note after her follow-up visit with you.
Correct.
After the first surgery.
Correct.
And you were just mentioning about how important patient motivation was and the healing process.
Correct.
What was Miss Daniel's stated goal for her hand and wrist as reflected in this note in the subjective section there on page 2?
So the patient was having difficulty using her right hand, and her goal was, quote, to use her arm and hand as before, end quote.
Is that what you want to hear from a patient?
Absolutely.
Did she follow up with your office again on May 28th of 2020 before the second surgery?
She did.
Okay, and how was she doing at that time? And had any plans changed after that visit with regard to your treatment, or did things remain the same?
She was doing relatively well. She was going to therapy at that time, and a plan was made to take her back to the operating room to remove the plate.
And it looks like you saw her only one more time.
Correct.
Which was in June of 2020, on June 1st. What did you do for Ms. Daniels on June 1st, 2020? And may I ask if you will use the illustration that we have up there, Exhibit 1, to explain to the jury what you did on that day?
So on June 1st, we brought Ms. Daniels back to our ambulatory surgery center and removed the bridge plate from the right radius. And at that time, I also removed this smaller plate that's along the edge of her radius. I was a little concerned it may cause her some symptoms once she was able to move her wrist. And so that plate was removed as well.
And you had, following that surgery, by the way, did the surgery go according to plan?
It did.
Okay. Following that surgery, there's a discharge note by you. Where does it indicate that Ms. Daniels was going to rehab after that second surgery?
The patient was moving to Texas.
Okay. And do you know anything about her course of rehabilitation with the rehab facility in Texas?
Unfortunately, I do not.
Because by the time she returned to Atlanta after living in Texas, you had relocated, is that correct?
That's correct.
And she treated, when she returned to Atlanta, with a different Grady doctor.
She saw a different Grady doctor in consultation.
Okay, and you're not aware of whether or not she's treating with new Grady doctors today, are you?
I am not aware.
Okay, so tell me about the consultation and what you know about that.
So she was seen by Clifton Meals, who is one of my previous partners at Grady. And her concern at that time.
What time are we talking about?
March 12th, 2021.
Okay.
And her concerns at that visit were limited range of motion through her right wrist.
All right.
And based on the documentation, she was only seen that one time. She, based on the note, made it clear she did not want any additional surgery. And so no treatment was provided.
Were any limitations noted in that record?
Limited range of motion is all that's noted, but there's no values recorded to give a sense of how much motion is limited.
How long does it take a patient after the kind of surgery you perform typically to reach maximum medical improvement, doctor?
I would give a patient at least a year post-surgery before I would state that the patient has met maximal medical improvement. I think it takes a longer period of time for somebody to regain function, and tissue changes continue to occur far after surgery. Motion can continue to get better with proper therapy. And so I think it takes at least a year for a patient to fully recover.
And this follow-up visit occurred 1 year and 3 months after the collision, is that correct?
So her date of injury, this visit was March 21st, and her date of injury was March 2020. So it was 1 year.
1 year.
I would also comment that there's no indication that the patient has had any type of therapy in the interim. And after removing a plate such as this that she has in her wrist, she needed therapy.
And if she had therapy through licensed physical therapists while in Texas, would that be the kind of thing you're talking about?
She would need care from a certified hand therapist who could have been a physical therapist, but yes.
Okay. Doctor, thank you very much.
My pleasure.
Let me just ask you, actually, a couple of more just little closing questions. In your medical opinion, what was the cause of Ms. Daniels' pain, broken bones, and other injuries for which you treated her for and operated on her for?
She was involved in a motor vehicle collision.
And was your treatment medically appropriate and necessary given her pain complaints, test results, and symptoms?
Yes.
Thank you, doctor.
Thank you.
Good morning, Dr. Payne. So I have a few follow-up questions for you. And some of the things we discussed already, but I just want to make sure they're on the record. So in your discussion with Attorney Johnson, you mentioned the last time you saw Ms. Daniels was in June 2020, correct?
That's correct.
And that's the visit where you removed the hardware in her right wrist.
Correct.
And you haven't seen Ms. Daniels since that last visit?
That's correct.
Nor have you spoken with her?
That is correct.
Okay. And we talked a little bit at the end about how Ms. Daniels, or your expectation was that she would have completed certain therapy.
Correct.
For her healing. And if I'm correct, you specifically recommended that she work with a certified hand therapist to help her work on her finger mobility, wrist mobility, and forearm mobility.
Correct.
And this was critical for her to recover and obtain her normal function prior to the accident.
Correct.
And you recommended at least 3 to 6 months of therapy with a certified hand therapist post plate removal, correct?
Correct.
And non-compliance with that therapy could delay a person's recovery.
Correct.
And it could also create issues with stiffness.
Correct.
And their ability to regain strength.
Correct.
Okay, and so it's important to keep those joints active so they can regain their function.
Absolutely.
Okay, and I believe that previously you spoke about how it was important for a patient like Ms. Daniels to work diligently on trying to restore her wrist range of motion.
Correct.
And to do that, she would need the guidance and treatment from a therapist to help facilitate restoring that mobility.
Correct.
And then once the range of motion is restored, then the patient is able to work on restoring strength.
Correct.
Okay. And some of the specific treatment that the certified hand therapist would have been doing would be working with their hand to do soft tissue mobilization.
Correct.
And working to diminish the adhesions that can develop from scar tissue.
Correct.
And working to improve the mobility of the tendons and the ligaments.
Correct.
And trying to improve the overall elasticity of the tissue.
Correct.
Okay. And they would also be assisting with the forearm mobility. Is that correct?
Yes.
Okay. And failure to comply could cause a patient such as Ms. Daniels a difficult time restoring her range of motion.
That is true.
Okay. And in addition to being an orthopedic surgeon, you're also a licensed physical therapist?
Yes.
Okay.
I do not have an active license anymore.
Okay.
But yes, I did practice physical therapy for several years before I returned to medical school to become a doctor.
Okay. And when was your license last active?
2004.
Okay. But typically, as someone who has experience as a physical therapist and as an orthopedic surgeon, you will often express your opinion to your patients about what type of therapy they need.
Absolutely. I think being a therapist makes me a much better orthopedic surgeon because I understand the therapy that's needed to achieve a functional outcome.
Okay. And based on your experience and training, you believe that Ms. Daniels also needed physical therapy for her lower extremity to regain function and mobility.
Correct.
And you suspected that she needed at least 6 months, given her calcaneus fracture and her other lower extremity injuries.
Correct.
Okay. And similarly with not complying with the certified hand therapist, if you're not complying with physical therapy for your lower extremities, that can delay a person's recovery as well.
Absolutely.
And create problems with stiffness.
Yes.
And affect their ability to regain strength.
Yes.
Okay. And if someone did not comply with the lower, scratch that. If Ms. Daniels did not comply with the physical therapy for her lower extremities, that could also cause issues and cause her not to restore her ankle and knee mobility. Is that correct?
It can severely limit her range of motion. Yes.
Okay. And that could also affect her gait.
Yes.
Okay. So she would need to also work with someone to help with her ankle range of motion.
Yes.
And her knee range of motion.
Yes.
Okay, when you were providing treatment to Ms. Daniels, were you working hand in hand with Dr. Moore in terms of being aware of the severity of her injuries?
Yes, I was as an orthopedic surgeon, I could look at her x-rays and understand the severity of her injuries. Dr. Moore and I saw the patient in clinic at the same time, but we were not in the room together.
Okay.
And so I cannot comment on his treatment plan.
Okay.
But with the knowledge that I have as an orthopedist and as a physical therapist, I could look at her x-rays and know that she's going to need a significant amount of therapy to have a good functional outcome.
Okay. And from looking at her x-rays and from your experience, what was your opinion in terms of her knee range of motion and the need for therapy?
Well, it's hard for me to look at an x-ray and understand what her range of motion actually is.
Okay.
So I can look at her x-ray and have a presumption that she's going to have some limited range of motion. But I can't comment on exactly how much that limitation would be looking at the films.
Okay.
When I saw Miss Daniels, I didn't specifically focus on her lower extremities, but I would talk to the patient, how are things going? How are things going with your lower extremities? Just so that I had an understanding of how the patient was doing in totality.
Okay. But all in all, you would agree that it was important for Ms. Daniels to make sure to comply with therapy for both her upper extremities and lower extremities?
Yes, ma'am.
Okay, thank you. No further questions.
Doctor, with respect to Ms. Daniels' lower extremity and why she's in the condition she is physically, would you defer to Dr. Moore and his opinion on that?
I would.
Okay. And did anything that Ms. Page raised with you during her cross-examination cause you to change any of the opinions you gave this jury during your direct examination?
No.
Thank you.
That's it. Just want to make sure there wasn't like an epilogue. She comes back. Okay. Ladies and gentlemen, with that, we are going to end for the day. One of the things that I discussed with the lawyers during your last break was scheduling. We're ahead of schedule. It sounds like, subject to change, but if you all are more or less on time tomorrow, we'll complete the evidence in this case tomorrow, which would mean all that would be left for Wednesday, depending on when we end tomorrow, would be closing arguments and then the charge that I have to give you, the law that I give you after closing arguments. So we're doing real well. It may even be that closings happen tomorrow, but I have to talk with the lawyers some about the law I'm going to give you, and I'm not quite sure when we'll do that. So I am less alarmed that we're ending half an hour early. We're not wasting a good 30 minutes of your time and then telling you, oh, we're going to need you on Friday. It's not how this is going to shake out. So we're at a close for today. It is important when you go home tonight or wherever you're going to work or whatnot, that you not talk about this case with friends, colleagues, enemies, whomever, because we don't want them interacting with you about what this case is about. They don't know, and their experiences with trials were different from yours. Please don't do any research. I know you weren't able to ask Dr. Payne any questions about those diagrams or the wrists or the arms, but that's just the way it's structured, this trial with these doctors. There may be other witnesses you can ask questions of that will assist in that, but no outside research. We're going to try to start as close to 9 as we can tomorrow, but that requires all 13 of you being here for us to do that. If something comes up and you can't be here tomorrow, Mr. Garfinkel, make sure you call and write, and we'll know that you are exactly where you need to be, and we won't panic, and we will not come get you. But that applies to anyone. If you're having car trouble or you decide you don't like your Uber driver because she drives too fast with the blue lights on, then we'll come up with other plans. You guys are doing a great job paying attention, and we'll see you as close to 9 as we can tomorrow. Any logistical questions? Take your pads with you to the jury room, not home. And then tomorrow when you report, just buzz and we'll let you into the jury room tomorrow as early as you end up getting here. Thank you so much. Do they know how to get out of here? They do? Okay. All right. You all can be seated. Mr. Johnson, tomorrow you've got some live witnesses and some previously recorded witnesses. You'll have everyone you need so that we're not having to take a break because someone's not available.
That is correct.
Okay. And your current forecast is resting lunch-ish, maybe a little after lunch?
Here's what I can tell you. We've got the plaintiff's mother testify.
That's Ms. Lundy?
Yes, we have 3 doctor depositions. One is 1 hour, 5 minutes. One is 1 hour, 5 minutes. One is 43 minutes and 15 seconds.
Okay, so that's 3 hours basically across the 3 when we add them all up. Okay. We may have to take some popcorn breaks in between there to keep the jurors focused, but okay, good. Well, I hope you bring some. All right, that's good to know. I was going to ask how long they were. I was hoping they were like Dr. Payne. They're as long as they are. And
we can break during.
We will. Don't worry.
You know what I mean?
Yes.
We don't have to.
No, Ms. Brown loves them. She's happy there are more depositions. I'll be monitoring the jury. And so it may well be that I ask your technical expert to pause, have the jurors maybe just do the hokey pokey and not necessarily leave. And then you've got Ms. Daniels.
Yes, sir.
Okay. All right. So we will not be done before lunch.
No, sir.
The only witness currently forecast to potentially be called by the defense would be Ms. Friedman.
Correct.
All right. So she does not need to be here before lunch. At lunch, let's take stock of where we are, because if for whatever reason we end at 2, I would like to have Ms. Friedman testify tomorrow, or doctor, whatever her title is, and not wait until Wednesday to do that. But let's help me remember at lunch to get a sense of where we are in the process. We may not get through. Tomorrow's Tuesday. We may not get through the deposition. We may have to pause one deposition before we break for lunch. Around noon, I have a few of the grand jurors from the special grand jury coming who need to chat. And so everyone will have to leave. And that will be when we pause and you get your lunch break. And then we'll just pick up where we were.
When I was saying we were ahead, yeah, I wasn't necessarily meaning that, we could bust it up and be done by 3 o'clock tomorrow. It's just that we were thinking, I think Brandon and I were thinking it was going to take us through Wednesday. And it's not. That's the point I'm making.
No, I'm not asking you to change anything you've been doing. Both sides have been very efficient and we'll keep that up, but you don't need to accelerate anything tomorrow. And some things are unacceleratable. Right. If it's an hour and 5 minutes, it's an hour and 5 minutes.
Right.
The questions don't get any longer or shorter. Okay. Ms. Arnold, anything from the defense?
There you are.
All right. We'll see everyone. You don't have to be here at 8:30 tomorrow. I'll see you a little before 9. I'm going to work on the charge tonight, because if we do end at 4 tomorrow, I want to do the charge conference so that on Wednesday, we can get going with closings. If we end closer to 5, we'll see whether we stay late to do the charge conference or have the jurors show up at 9:30 on Wednesday. And it may be that Ms. Friedman's not testifying till Wednesday, and we'll work something else out. But I've got your proposals. Ms. Niles has distilled them into a draft. I'll look at that tonight and push something out to both sides once I'm done.
So just assuming that MARTA does not call Ms. Friedman, is it fair for us to rely on having closings Wednesday morning and not late after 3 doctors and Jame Daniels and you know what I mean?
Yes.
Can I just tell myself I'm going to figure that out tomorrow night after?
I can tell you that. You don't have to tell yourself. I can tell you that. You may need to do the charge conference tomorrow. That's lower impact. You won't need to do closings.
Okay.
Okay. Even if Ms. Friedman doesn't testify.
Okay. Thank you.
All right. I think that's it. Thank you, everyone.
That's a good question.
Yeah, thank you. Thank you very much.
Every once in a while, he gets one. Thank you.
You are allowed.